No. Good morning, everyone.
I'm sorry, Ann. I don't know if you're going all day, but I do have AFA this afternoon. I have to get on that work session. So I will be with you this morning, and I'm not sure how long this afternoon.
Okay. Thanks for letting us know. We usually have people give us a little update when we do a round of introductions, and we are streaming now. So I just want to welcome everyone to the Joint Standing Committee on the Judiciary. Today we have a full schedule of work sessions. These are meetings related to bills that we've already had public hearings on, and the opportunity for the committee to discuss the bills and vote on them. We don't take public comment because that happened at the public hearings. You will occasionally see us bring in people with special information who can answer specific questions that the committee has regarding some of the bills. And you'll see the bill sponsors on most of the bills as well. And before we get started on our first work session, we'll begin with committee introductions. And I'm just going to call on people as I see them on screen. Representative Cardone, we'll start with you.
Hello, I'm Barbara Cardone. I represent House District 127, part of Bangor.
Thank you. Representative Moriarty.
Good morning, all. I'm Steve Moriarty. I live in Cumberland, which is the largest part of my district, the rest being part of the town of Gray.
Thank you. Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell. I am the tribal representative for the Passamaquoddy tribe. Thank you.
Thank you. Representative Evangelos.
Good morning, everyone. Jeffrey Evangelos, House District 91. I reside in Friendship. And Madam Chair, after the introductions, I just want to talk for a minute about the threat of a really bad storm coming through today and whether we lose our access to power or internet if we have a contingency plan. So thanks.
All right, thank you. Representative Hagan? We're not able to hear you, Representative.
Sorry about that. Dave Hagan, I represent House District 101, Hamden and Newburgh, and nice to see all of you.
Thank you. Representative Poirier?
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. Representative Sheehan?
Thank you, Madam Chair, and welcome everyone. My name is Erin Sheehan, and I represent House District 12 in Biddeford.
Thanks. Representative Babbage?
Good morning. My name is Chris Babbage. I represent House District 8, which is most of the 35 square miles of Kennebunk, but I represent only one of its 4 beaches.
Thank you. Representative Senator Keim?
Good morning, everyone. My name is Lisa Keim, and I am proud to represent Senate District 18, which is Northern Oxford County and 2 communities in Androscoggin. And I do wish I was on this mountaintop because I think today is going to be a scorching hot day. Oh, and just to mention, I have a meeting at 11 that I have to join, so I will be out of the committee for a while at 11.
Thank you. Representative Reckitt?
Yes, good morning. My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland.
Thank you. And Co-Chair Harnett?
Good morning, and thank you, Madam Co-Chair. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside, and I will be popping in and out of today's meeting due to some obligations, including a work session in another committee sometime this afternoon. Thank you.
Thank you very much. And we are joined today by our legislative analyst, Peggy Reinsch, and also our committee clerk, Susan Panett. And I think I've had everybody introduce themselves other than me. I'm Ann Carney. I represent Senate District 29, the people of South Portland, Cape Elizabeth, and a little bit of Scarborough. And did I miss anybody? Don't think so. Okay, so we are going to now open up our first work session, and this is LD 272, And it is actually a reconsideration of a bill that we had previously voted on. And Peggy has the details for us. Thanks, Peggy.
You're welcome. Thank you. And thank you for your patience with this. And thank you for, I want to thank Representative Tools for his patience on this bill. This is an act to establish separate prosecutorial districts in Down East Maine. If you remember, you heard this bill and it was unanimous agreement to split Washington County out from Hancock County. Right now, that's one prosecutorial district. You voted ought to pass. We sent it for a fiscal note, and the fiscal note came out really big because we didn't really give enough direction in the bill to how this needed to happen. And so Sam actually did the drafting on this to put in effective dates for when this new prosecutorial district is established, and also so Hancock is split off, and provides for an election. So I'm happy to, if you don't have the copy of that amendment, I'm happy to share the screen to show it to you, because it's so different from the original bill, and because you voted ought to pass, you will have to, if you want to go forward with this, you will have to vote to reconsider and then re-vote the bill. It's substantively different. And the fiscal note, and I know Representative Toole wants to speak to this, the cost is $23,000 for that first year of the new prosecutorial district. And I think it's a little bit higher after that. It's supposed to be the difference between the ADA salary and the district attorney's salary, because what we're doing is taking an assistant district attorney position and turning that into a district attorney position rather than increasing the position count. So if you need me to share the screen, I'm happy to do that. And otherwise, if you already have it in front of you, great.
Let's go ahead with the screen share, just because it's, I think, a really efficient way for us to address this. And at the same time, I'll just give the bill's sponsor an opportunity to speak. Representative Toole, I did bring you over to the panel. Would you like to address the committee? Go ahead.
Yes.
Welcome.
Am I on? Okay.
You are.
Thank you, Madam Chair, and thank you to all that have been sticking with this bill and following it since it was last taken up. I knew at the time when it was taken up, the fiscal note was going to be a problem, that it was going to be a couple $100,000 or $170,000 when it originally came out. So I worked with Peggy on trying to sort through that, and made the point that the original bill, while it was clear in our intention that the new district attorney or the new attorney would take office in January 2023, the fiscal note and the bill didn't read quite that way. So to back up, with the fiscal note, the first year, 21-22, went from 170,000 to zero, because the bill doesn't technically take effect until January of 2023. So, and as she explained, that is the cost there is the difference in the cost between a salary for a DA and an ADA. Our intentions are to keep the same number, the same head count, but that a DA would earn a little more in salary and benefits than an ADA. So that's the main functional difference. Certainly the bill meets with my intent and our intent, and it's our hope that we can get this moved along so that we can vote on it in the next couple of weeks and get it to the appropriations and work with them on the funding of this, so that we can get this out and dispensed with this session, so that transition can begin. I don't know if anyone had any questions for me, but that's generally the overview of it.
Thank you very much, Representative Toole. And it looks like Representative Hagan has a question for you. Go ahead, Representative Hagan.
Thank you, Madam Chair. I had a question, and I'm not sure if it's appropriate to ask right now, so you could be the judge of that, I suppose. We had a recent bill that talked about knocking down 3 buildings and then building a brand new courthouse, $34 million. Is that directly related to this bill?
No,
no.
that's a completely, I'll answer that, Representative Toole, just because I'm familiar with it from our committee hearings and work sessions. That's a completely different bill. So it's not pertinent to this bill.
Thank you.
Yeah, thanks for the question.
Also, it's in Ellsworth.
Yes, but it is unrelated to this bill.
Yep.
All right, Peggy, do you want to take us through the amendment a little bit more, and then we'll open it up for committee questions? Thank
Sure,
you.
I would be happy to. So the existing law, this is prosecutorial district number 7 right now. And so we're going to keep that intact until January 1st, 2023. So that's the first section of the bill. I cannot find my cursor. Okay, there it is. So section 2 of the bill, that's pretty close. That creates, that is starting January 1st of 2023. We're going to keep Hancock County as prosecutorial district number 7. And then the prosecutorial district number 9. So we're 8, subsection 8 is prosecutorial district 8, that's Aroostook County. So new prosecutorial district 9 is going to be Washington County. And that again takes effect January 1st, 2023. And then we have this unallocated section 4, which says that the first district attorney for prosecutorial district 9 must be elected in the manner set forth in, this is the statutes that direct how district attorney elections take place. So that has to happen in the an election held on the first Tuesday following the first Monday of November 2022. So that lines up with what Representative Toole's plan was. This is when that district, the existing district attorney's term ends. So he'll be running for re-election, or somebody else will be running for that office anyway. So you're not disrupting an existing term. So that's why that language is in there about the election. And then the appropriation, we're only looking at this biennium, and 2022, 2023, that's only half of the fiscal year. So from January to the end of June. So that's the $23,000 in additional salary. And if you look at the fiscal note says going forward, the difference in salary and benefits is going to be about $50,000 per year. So that's going forward. That's in the next biennium. You don't have to fund it, but appropriations is always concerned about what kind of costs you're pushing into the future. So that's why the fiscal note goes out to the future.
Thank you very much, Peggy. Committee members, are there any questions either for Peggy about the amendment or for Representative Toole about the amendment? I think we're probably done with the screen sharing. Thanks very much, Peggy. Committee members, any questions about this? Go ahead, Senator Keim.
Peggy, I just had one. I was wondering, do we pay district attorneys the same amount regardless of the size of their district?
You know, I think the pay also depends on how long they've been a district attorney. So and actually Representative Cardone might know even more about that. But I think that there's a pay scale, and you know, the longer serving district attorneys are going to have a higher pay. It does go through the Attorney General's account. It's not the salary for the attorneys in the district attorney's office do not come from the counties. They do come from the state. So
right. That
Yeah.
I was just wondering, so we're taking one district and splitting it in two. Does each one get the same amount? Because obviously some district attorneys have much larger districts than others. Is my only question. And if you don't know the answer, that's fine.
Right. Well, I don't think it's based on the size of the district.
Okay.
I think it's more tied to how many years of service.
Right.
And,
Okay. That's all.
and the same with the ADA.
Thank you.
Committee members, is there, I guess the first step would be a motion to reconsider. Representative Harnett?
Thank you, Madam Chair. I move that we reconsider the vote we cast on March 4th, 2021 on LD 272.
And is there a second, Representative Newell? Representative Newell seconds. And is there any discussion on the motion to reconsider? I would just like to quickly say that to thank the bill sponsor and also our committee analyst for doing all of the work to get this legislation in shape to be passed and enacted, particularly with regard to the time frame, so that a new, if the legislation passes, a new DA can be up and running in January 2023. You know, it was a lot of hard and careful work, and the committee appreciates your work. And so with that, is the committee ready for the vote on the motion to reconsider? Looks as though we are. Go ahead, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckitt.
Yes.
Thank you. Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative McCright. Representative McCright is absent. Madam Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Ms. Panett. And so the motion to reconsider carries, and now we'll move on to a motion on the bill. Representative Babbage?
Yes, Madam Chair, I'd like to make a motion, and I'd like to speak to my motion before we take the vote. I move ought to pass as amended.
Thank you. And let's get a second, and then you can address the committee. Is there a second? Seconded by Representative Evangelos. Okay, Representative Babbage, you have the floor.
Okay, thank you very much, Madam Chair. In visiting this issue, I know geography is challenging. If that were the only criteria, I'm not sure if I would be supportive. I know Piscataquis County is in Penobscot's region. I know it's about 91 miles or so from Calais to Ellsworth. But I also know from Fort Kent to Holton is longer, and Somerset County, Jackman is in Kennebec regional area. So we have some challenging geography for some of our prosecutorial districts. But Washington County is perhaps a little culturally different from Hancock County. They have been victimized by the opioid epidemic early on, more so than got a lot of national attention actually. And I want to support Matt Dana, and I want to support Betsy Fitzgerald, and I will support this motion. So thank you, Madam Chair.
Thank you, Representative Babbage. Committee members, is there any other discussion on the ought to pass as amended motion? Not seeing any. I think we're ready for the vote. Thanks, Ms. Panett.
I'm sorry. Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentee. Senator Sanborn. Senator Sanborn is absent. Representative McCright. Representative McCright is absent. Madam Chair, 12 members voted in the affirmative, 0 in the negative, and 2 members are absent.
Thank you very much, Ms. Panett. And with that, the ought to pass as amended motion carries. Representative Toole, did you wish to speak with the committee?
Yes, thank you, Madam Chair. I want to thank the committee for voting this once again. This is going to be a critical thing for Washington County, and I know our sheriff and many across the county are very thankful to you for this. I deeply appreciate it. So thank you. Thank you all.
Thank you very much, Representative Toole, for bringing the legislation forward. And with that, we'll close the work session on LD 272 and move on to our next bill, which is a work session on 1676. And let's see, Representative Evangelos, I know you raised the issue of talking about a potential storm. What I'd like to do is to wait until after we have a little break, because I haven't had a chance to check the weather forecast either. And maybe if we can all inform ourselves after our next break, then we can have a more focused conversation on that.
Thanks a lot.
Sure. Thank you. Okay, so we'll open the work session on 1676. And also for those attendees who are here for the various work sessions, I did post in the chat, which is not to be used for substantive contributions, but for scheduling and technical stuff. I posted the order of bills that we're going to take up this morning in the chat so that everyone has access to it. And so at this point, we'll hear from Peggy on 1676. Thank you, Peggy.
Oh, you're welcome. Thank you. This bill is kind of a repeat from last year that the committee spent a lot of time on, but it focuses on limiting access to juvenile case records and protecting the confidentiality of juvenile history record information. There has been a group of people that has been working on this issue for several years, and several of them are in the attendee room and can answer your questions probably much better than I can. But the whole purpose is to support the juveniles in kind of starting over once they're no longer juveniles, by making sure that the records are kept confidential, except in situations where the public interest is greater than the juvenile's interest in privacy. And so I'm not sure the best way to go through the bill, if you want to go through the bill section by section, or if you want to talk more conceptually. In addition, the folks have been working to address some issues that have come up, or to clarify some language that's in the bill. And so you do have an amendment that's been proposed. And in addition to that, the state archivist, Kate McBrien, raised the issue at the public hearing about our general public records laws, public records being those records of the state that the public has access to, and the archivist kind of has a jurisdiction over. That there's a provision in the state law that says all records become public 75 years after they were created, and just to make sure that that law applies to these juvenile records. It would be helpful to amend this bill, whichever, if you want it to apply, then say it applies. And if you don't want Title V to apply, then say it doesn't apply. So I worked with her for that amendment, and that I sent to you this morning as well. So I'm sorry about the flurry of documents. So what's the best way? What would help you go through this bill?
Yeah, let me check in with the committee, because I'm not sure kind of where people are on this, committee members. We had a public hearing on this bill. We've got a pretty extensive legislative analysis. It is a long bill. We could do a kind of a section by section review, or we could start with an overview. Peggy, if we did an overview, is that something that you would want to do, or would you suggest we talk to, for example, Christine Thibault, ADA Thibault, or ADA, I believe, Pearson?
Right. Either one of them would be a super resource. I mean, the whole group is a super resource, but I must admit that Christine Thibault has been my primary contact throughout this project. I worked with her to put the bill together for Representative Talbot Ross. So I think ADA Thibault would be an awesome resource for you.
Okay, so I'm going to bring her over to the panel to help committee members. And committee members, how would you feel about ADA Thibault taking us through not a super deep dive into each section, but a sort of to take us through the highlights of the bill to kind of refresh us regarding the discussion we had in the public hearing? Would that be okay? Getting an okay sign from Representative Moriarty. Is that okay with others as well? Seeing some nodding heads, great. Okay, ADA Thibault, welcome to the Judiciary Committee. And
good morning, Senator Carney.
Thank you for your work on this bill.
Yes, so this bill does do a lot. Some of it, I'll get my glasses here. Some of it is just very housekeeping things, and I'm not going to waste your time with that. So I'm going to start with the first big substantive issue in the bill.
Actually, could you please start with just giving us, again, reminding us of all of the stakeholders who participated in this legislation? Because I actually think that's one of the most unique and powerful aspects of the bill. So if you could start there and then go into the overview, I think we'd appreciate that.
Yes, so this bill was in the last legislative session in the 129th as 1964. COVID did it in, so we came back again this year with some revisions. And the work group that has participated in drafting this bill includes myself and ADA Tanya Pearson from York County, Defense Attorney Ned Chester, Chris Northrup, who's a professor at Maine Law and the director of the Juvenile Justice Clinic, Chris Parr, who's an attorney for the Department of Public Safety. And we have consulted with the judicial branch, Julie Finn, Caroline Hova, and Betsy Boardman. They've asked us to modify the language somewhat to make it easier for the court to actually implement some of the changes that are proposed here. In 1964, when the bill came up, we did have some discussions with Judy Meyer from the press. In all honesty, we have not consulted with her with regard to this year's proposals. I know she did have some concerns when we were in the public hearing, but just to be fair, I want to be transparent. We did not work with the press on presenting this proposal this year.
And with regard to the people who participated in the bill that's come forward this year, is it fair to say that they each look at the bill from a very different angle?
Yes, yes. I mean, these are not easy policy decisions. And you're right, we each have our own unique perspective and our unique interests that we're trying to protect. This bill is, I think, a compromise. It's a starting place, but we're not, I don't want to be the one to say, oh, this is a no-brainer. These are easy decisions for you to make. You all are the policy makers. And I guess our concern is that whatever policy you all adopt, that it is clearly and precisely correct in the juvenile code. We have had a lot of, several incidences where ambiguity or uncertainty in the juvenile code has led to disclosures that have harmed kids. And that's really our overriding mission, is to protect the confidentiality of juveniles and to increase judicial discretion with regard to some of the cases that really those interests need to be balanced. Confidentiality, but also the public's right to know and transparency of the court process. Those are all very legitimate interests. And so the reason this bill is quite complex is because we have introduced an element of judicial discretion that hasn't existed in the juvenile code. It's been kind of cut and dry.
Great, thank you. Let me just ask you to hold on for 1 minute. Senator Keim, did you have a question for Ms. Tebow before she begins to give us an overview of the bill?
Yes, thank you. One for her and one for Peggy. Thank you, Ms. ADA Tebow, for being here. I really appreciate your time and expertise being shared with us. As you're walking us through, I just wondered if you would let us know if there are any areas that there wasn't full consensus on. And then if there were, because I know when there's working groups, sometimes not everyone agrees, or if there were areas where there were different viewpoints or greater concerns. Just if you could highlight that for us as you're walking through, that would be helpful. And then Peggy, I was just wondering, I saw 2 amendments. Are they separate, or is the latest one the one I should be looking at?
So I sent the amendment yesterday. That's and then there's one called additional amendment that I sent this morning. This morning's amendment deals with that public records question with the archives, whether or not that's kind of a different question than all of this, but it would be nice to be addressed. So you can do that at the end. Okay. But the other amendment that I sent yesterday, and that's in the portal, that is useful to have, and I believe that ADA Tebow will be referring to that as she goes through. But I also think that doesn't even show up until section 19 of the bill.
Okay.
All right. I think we're all set. Thank you very much, Senator Keim. And ADA Tebow, you can go ahead.
Sure. So I'm going to start on, I'm going to be working mostly from the original bill, and then I'll introduce pieces of the proposed amendments as we go along. So on page 1 of the bill, the first kind of substantive proposal is creating a definition of administration of juvenile justice. Main statutes, there are different statutes that govern juvenile justice. Title 16, Title 20A, which is the education statutes, and of course, Title 15 in the juvenile code. And we noticed that there are different definitions for administration of juvenile justice and administration of juvenile criminal justice. And what we're proposing as part of this bill is to clean up that language and adopt a single definition for administration of juvenile justice and use that term consistently throughout all of Maine statutes. Juvenile criminal justice is a bit of an oxymoron because they're very different systems. You've got the juvenile system or the criminal justice system, but we really want to distinguish that they're separate and not conflate the 2 definitions. So you'll see throughout many places that we clean up that language. Not a real substantive change, but makes it easier to for the lawyers. Victim, on page 2, order of adjudication is also a new term. Even though the juvenile code as it exists now uses that term, it's not defined. And we wanted to create a definition because you'll see later on that one of the items that is possibly open to public inspection is the order of adjudication. And so we wanted to make sure everybody knew what that meant. Section 9 of the bill is, I don't know if Chris Parr is in the waiting room, but he's helped us the most with this. So I'm going to do my best, but if he's here, he may be able to answer questions better than I.
So let me just interrupt you there, and I apologize for the interruption. He is here. Would you like to just defer addressing that section to him?
Yes.
Okay,
if he's
Christopher Parr, I'm going to move you onto the panel.
Morning. How are you?
Welcome to the Judiciary Committee.
No, we do not. So,
Thank you. I have some ambient noise going on here, so I can't really talk a lot, unfortunately.
Can you just lower your voice a little bit?
Yeah, sorry. I have I'm co-working with a teacher in the same room.
So
So
here we go. What are we trying to say?
Then maybe what we should do is have ADA Tebow go through section.
yeah, that would probably be
Okay,
best.
Joshua,
Thank
you're
you.
all set.
You can stay on the panel and may tap into you for questions. Okay, go ahead. Ms. Tebow.
So to give the committee kind of a picture, and actually Attorney Parr created a visual illustration of what we call the buckets of information that are collected for juveniles. The first is juvenile case records, and those are records that are maintained by the courts. And that term, juvenile case records, is defined in the juvenile code. So that's a term of art that applies to records that are maintained by the court. The second type of information is juvenile intelligence and investigative record information. And that's information that's collected by criminal justice agencies, law enforcement, prosecutors' offices, and that is all governed in section 3308-A. The last part doesn't exist until this proposal, and that is juvenile history record information, which is essentially everything that's maintained by SBI. So you all know that if a person is applying for a job or applying for benefits or whatever, a criminal background check can be done on that person to determine their criminal history. And that's criminal history record information that is subject to law in Title 16. That law, however, does not apply to juveniles. So Section 9 of this bill creates a mechanism for governing the collection and dissemination of juvenile history record information. And it makes it really clear, and Attorney Parr used Title 16, the adult statute, as a template and created the similar, a very analogous system for managing juvenile history record information. And what is made clear from this section is that everything is confidential unless it's specifically made public. And there's really only one thing that is made public. And that is on page 3. On page 3, right in the middle of the page, subsection 3, juvenile history record information pertaining to adjudications. If a juvenile has been adjudicated as having committed a crime that would be murder or class A, B, or C crime, if the juvenile were adult, that information may be publicly disseminated. That is the practice now, based on the current juvenile code. Even though other juvenile adjudications are public, SBI does not disseminate information except for those felony level adjudications or murder. One thing I think we talked about adding in to make, and I don't know if it needs to be in here as well, Chris Parr, but prior to, I believe, 2000, SBI did not retain any information about juvenile history records, any juvenile records at all. So we may need to look at adding a date. And Chris, I don't know if it would be helpful to put in there some language that suggests that this section only pertains to adjudications subsequent to a given date. What do you think?
Okay, so good job.
It's a great
Why don't you
question.
take the
I think I'd want to
responsibility that
think carefully
information in your
about
group,
that
chat.
before opining further.
And you've got to write.
And I would just add that I think that we'll just kind of keep that in mind as we go through this, and I'll put it on a sticky so that we remember to come back to it. Representative Reckett, did you have a question? We're not able to hear you, Representative.
I'm confused because I keep trying to find the place where ADA TiVo is referring, and I think I realize she's been talking about the original bill. Is that accurate? That's where you're, so I've been looking at the amendment and being totally confused. All right, so I'll now go back to the original bill. Thank you.
Yeah, I'm sorry for that lack of clarification. We're going to look at the original bill. The amendment doesn't come in until quite a ways into the bill, and ADA TiVo will indicate to us when we're looking at when we need to turn to the amendment, everyone. Representative Moriarty?
Thank you, Madam Chair. I wonder, ADA TiVo, whether any of this applies in cases in which a juvenile has been bound over for trial as an adult.
If they've been bound over, then essentially the juvenile court has waived its jurisdiction and everything is treated just as if that person were an adult. So that would be under any information pertaining to that offense after the juvenile court waives its jurisdiction would be governed under Title 16.
Okay, so we're dealing strictly with juvenile offenses and nothing having to do with being bound over.
Right.
Good,
Juvenile
that helps me
offenses-
understand. Thanks.
Yes.
Thank you for that clarifying question, Representative Moriarty. Representative Reckett, are you all set, or did you have another question? All set? Okay, great. All right, you can continue. And are you done with the juvenile history information section 10 yet? Because I would like to open it up for questions when we get to the end of that.
Almost.
Okay.
The other piece that is new to this bill that did not exist in 1964 is, and I'm on section 9 of the bill, and it's on top of page 4 in the original bill. Subsection 6, unlawful dissemination of confidential juvenile history record information. You'll see that we've introduced language for the juvenile history record information, the juvenile intelligence investigative information, and the juvenile case records, identical language that creates a civil violation for a person who intentionally or knowingly disseminates confidential juvenile information. And the person who is adjudicated of that offense, that civil offense, would be subject to a fine of up to $1,000. And that's, again, that's new to this year's proposal.
But is that something that is currently found in the statute that applies to adult criminal history record information?
No.
Okay, so it's unique to the juvenile setting.
Yes.
Okay. Thank you.
Okay, so there, that's.
May I ask where you are, Christine? Where is that?
That is on page 4 of the original bill at the very top.
Thank you.
Unlawful dissemination.
Gotcha.
So committee members, let's just focus for a moment on the juvenile history record information. Are there any committee questions related to that? So that's section 9 of the original bill that we did the public hearing on. Any questions about that? Great. I'm not seeing any. All right. You can continue, Christine Tebow. Thank you.
Okay. The next section 10 of the bill, I'm trying to think if that's one that has part of an amendment.
Section 19 is the first portion
First
where
one.
amendments come in.
Okay, so section 10 is by and large existing law, except that what we've tried to do is tie together the ability to disclose the identity of the juvenile to court records being accessible to the public. It doesn't make a lot of sense to have one piece be disclosed and then not have the other. So what we've done here is allows a law enforcement officer, Department of Corrections, or court personnel to disclose the identity of the juvenile when the petition is open to public inspection, pursuant to part of the proposal that we're going to get to. It doesn't really substantively change it, other than current law says when a juvenile petition is filed, law enforcement and others can disclose the identity of the juvenile. No. I'm trying to figure out the best way to explain things and not confuse issues, but.
Well, maybe.
Question on that?
Oh, go ahead, Representative Hagan. Did you have a question?
That was me, Senator Carney.
Yeah, if you can raise your hand. So Representative Hagan had his hand up, I think.
Okay, good.
Okay, thank you. Just a quick one.
But
What
keep your
page
hand
are
up,
we on?
Representative Babbage.
Okay.
Page 4.
Thank you.
And then Representative Babbage?
Yes, my understanding is that the petition will become open to public inspection after a delay of 30 days. And I wondered what the group's rationale was for that 30 days.
So it's a due process issue. So maybe if I give you a case example, it'll be easier to illustrate. Let's say, and I'll use a real case, the juveniles that burned down the buildings in Lewiston. If there's a large event that the public has a great deal of interest in, that can be reported on without, I mean, you could have the reporters say, oh, the buildings were burned down, the police have investigated and have arrested a juvenile. There doesn't need to be a disclosure of the identity for the public to know what has happened with that offender. What we're trying to do is create a sort of a bubble of confidentiality around the most vulnerable kids. So let's say, for example, that offender who's created quite a crime is on the autism spectrum, or is 14 but developmentally an 8-year-old. And this is what we deal with every day in the juvenile court, where we have to consider the individual needs of that juvenile. The group had consensus around the fact that if a juvenile is not competent to stand trial due to either a mental illness, their very young age, or what the statute defines as mental retardation, which is a developmental disability, that it is not fair or just to disclose that juvenile's identity. So to kind of back you into the analysis, we've added language to the section that governs the competence statutes in the juvenile code to say if a juvenile is not competent, and that issue can be raised by the defense attorney, the state, or the judge themselves can say, I don't think this kid is competent. I need to get an evaluation. At that point, everything is shut down and is confidential because that juvenile is particularly vulnerable. So to get to the 30-day, why we've proposed a delay, when a juvenile comes into court, I don't know. I haven't seen that juvenile. I have no way of knowing what their presentation's like, what their cognitive abilities are like. I just know what the evidence is. I present the petition to the court. If that presenting the petition to the court is what makes it public, you could have these very vulnerable juveniles identified, and the press could report on it and say, Johnny Jones has burned down the buildings in Lewiston. And then 6 months down the road, the court says this juvenile, due to their developmental delays, is not competent. I'm dismissing this petition. So it's a lot of damage to that individual juvenile who is particularly vulnerable. So we wrestled with, how do we create some protection? And we came up with the 30-day delay. That was actually Attorney Chester's proposal, to put in a 30-day delay so that the juvenile comes to court, he or she is given an attorney. That attorney has an opportunity to meet with the juvenile, determine whether they're going to raise a competence challenge. And if so, that kind of shuts everything down. Similarly, it's not unheard of to have a juvenile walk into court and I say to myself, oh my goodness, I had no idea that this child was so limited. I'm just looking at the evidence. I don't know that. And I could say, Judge, I think we need a competence evaluation. But if the press is invited into the court at that point, it's, you know, the cat's out of the bag, so to speak. So the 30-day delay is for that purpose. Now, to be honest with you, there wasn't 30 days is kind of an arbitrary number. It could be 14 days, it could be 10 days. But we felt strongly that that juvenile should be entitled to legal representation, and that attorney makes a decision before the public has broad access to the proceedings.
May I follow up, Madam Chair?
Yes, you can have one follow-up, and then
Great.
we'll call on Senator Keim because she may have a question as well. Go ahead.
Great. At the end of the 30 days, the judge would have discretion as to whether to continue that in the bill, right? But my question actually is, you brought up Lewiston, and what did happen there in that, as far as exposure of the identity, and can you tell me that current practice doesn't allow the discretion to do this?
So currently the law says once a juvenile petition is filed that alleges a murder or class A, B, or C crime, or a juvenile second or subsequent class D crime, the public may not be excluded. The court cannot exclude the public. It's not discretionary at all. So to be honest with you, it's not real common for us to have the press in juvenile cases, but when there's a broad public interest, of course they are there. That said, I do know some of the smaller papers in rural areas have been at court and picked up information. And sadly, I think the current statute is ambiguous enough that there have been some disclosures of what should be confidential information more recently than that case, Representative Babbage. There have been disclosures that have resulted in broad publication of some pretty sensitive confidential information around juveniles. So again, we're particularly concerned about those juveniles who are most vulnerable. And you'll see when we get further into the bill that we've created a 3-tier system to allow the court some discretion on which juvenile cases are open to the public and which are not. And we've built in some presumptions. But I don't want to get ahead of myself.
Okay, thank you.
Senator Keim, go ahead with your question, please.
Thank you. I'll just state that I appreciate that we're walking through all of this so carefully. I know it's time consuming, but it is really important that we understand all the aspects of this bill. So I just wanted to go, so first of all, okay, so we were on page 4 and Representative Babbage mentioned 30 days, which isn't on page 4. So that's why I got a little confused and was trying to find where we were on the 30-day wait period. But going to that idea, you mentioned that competency, you mentioned that determination, but then you also said a judge might not make that determination for 60 days. So can you give me, I mean, maybe I misheard you, but can you give me an idea on how long? I mean, obviously a lawyer can be appointed very rapidly. So 30 days is much longer than we need for that. I want to, I definitely want to hear from the press afterwards and walk through this. And unfortunately, I am supposed to be at a meeting. Shoot, it's 11 o'clock. But how long does it really take to make these determinations? I mean, you mentioned, sometimes you'll walk right into a court and say, oh, we really need to take a different route with this altogether. So I'm wondering if we can focus a little more on the 30 days, what actually needs to happen, and can we, the public has a right to know, and we should always sort of err towards that, except when we're trying to protect the juvenile. And then the other, in case I have to go, I just want to bring this up as well as we walk through this. If there's a possibility that we can open up some information, but not others, such as not state the name of the juvenile, but state the charges, or state that, it's a juvenile and they're undergoing competency considerations, and here's some information, but not all the information, just so that if there is something that has to do with public safety or the public's right to know in some way, that we're trying to balance those two, and really what happens in the courts. I mean, that's the other thing. We should have oversight on court proceedings and make sure that there's fair treatment of juveniles. And so all of this are important things to balance. So can you just comment on the 30-day thing and whether or not we could look more closely about what we're keeping confidential, and whether or not it could just be names or something like that?
Okay. Yes. So maybe if I explain the process of juvenile court, it'll help you to understand why these timelines are important. So the juvenile comes to court for their first appearance after the police have done their investigation and they've been given a court date by summons, or they're either that or they're arrested and detained and they're brought to court within 48 hours, just like adults are. At that first appearance, whether it's from a detention hearing or pursuant to a summons to appear in court, that's the first time that the attorney really gets appointed. And sometimes we have background information if it's a juvenile we're familiar with, for example, or the police officers might include information in their report to say, I spoke to the parent and the parent explained that their child is on the autism spectrum. So it's possible that we've got advance notice of some developmental issues. But by and large, it's going to be at that first appearance in court. The lawyer of the day may or may not be appointed to represent that juvenile. There's a structure that the MCILS has. Certain defense attorneys are allowed to represent juveniles on felony cases, but others may not. So if the lawyer of the day, for example, is not approved to represent the juvenile on a felony, but they can do the first appearance, a new attorney is going to have to be appointed, right? So they come into court, everybody says, wow, this, juvenile needs an attorney. The lawyer of the day is not available for whatever reason. The court sends notice to a new attorney, gives the juvenile and the parent contact information, says, Ned Chester's been appointed to represent you. Here's his contact information. But it's going to take a few days for that attorney to meet with his or her client and gather information and determine whether they do want to challenge competence or not. It is a process. It's actually 6 months, I think is what I said. And honestly, I've seen cases for competence go beyond a year, because the first question is asked, is the juvenile competent? If the answer is no, the next question is whether the juvenile might become competent in the foreseeable future. And if that question is yes, then we have subsequent reviews for the competence determination. So it could really go, I've seen it go beyond a year, but I would say it's going to be, if the juvenile is not competent but likely to become competent, we're 9 months at least down the road.
So can I just interrupt you there and say, if that's the case, why would we be looking at 30 days and how does that help? Just so you can tie that into what you're saying.
Yeah. So the 30 days is the time allotted to allow the juvenile to get their their own represented attorney, not the lawyer of the day, but the attorney who's going to represent them ongoing through the case, and allowed that attorney the opportunity to raise competence challenge with the court to say, hey, I'm requesting a competency eval. And if you all agree that that policy that we propose of not allowing any information to be shared if a juvenile is undergoing a competence eval, that closes everything down. So the 30 days is more an opportunity to get the attorney. The other reason the 30 days is there is you'll see when we get to the 3-tiered section that some cases are presumptively open. Class A, if a juvenile is 13 and older and is alleged to have committed a Class A crime, the case is presumptively open, but the defense attorney, or I think it's anyone is allowed to, can petition the court to make it confidential. An example of that might be sexual abuse between siblings. If we have a juvenile who's charged with sexually abusing his or her younger sibling and it's a Class A gross sexual assault, honestly, I think that's the kind of incident that should be confidential, not just for the juvenile's safety, but for the victim's safety. So that 30 days would allow that attorney who's appointed to represent that juvenile to file that motion to get what is presumptively an open proceeding made confidential. So those are two big due process pieces that we believe the 30 days enables the court to provide that additional layer of due process to the juvenile. 30 days, again, is what we came up with, but a shorter period might be appropriate. That's the policy decision for you all to wrestle with, is how much time is appropriate.
Senator Keim, thank you for those questions, and Christine Tebow, thank you for the answers. That was a really helpful discussion for the committee. Representative Cardone has a question, I believe. Go ahead, Representative.
I just wanted to follow up on that question, and thank you for your answer, Ms. Tebow. Based on what you've described, based on my own experience at representing clients, juggling a schedule, getting somebody in for an interview, needing to do an analysis sometimes of a case or consult with other people, I would be very comfortable with 30 days. I'd be very uncomfortable with anything less than 30 days. I can understand why you wouldn't want to bump it out to 45 or 60. But boy, I think 30 days is the minimum that you ought to be giving for this process of getting an attorney appointed, getting an opportunity to meet, getting the attorney, letting the attorney have the opportunity to evaluate the case and make some decisions. 30 days seems highly reasonable to me.
Thank you, Representative. Committee members, are we ready to continue with ADA Tebow's overview?
Yeah.
Looks like we are. Oh, Representative Babbage, you had a question?
Well, Ms. Meyer mentioned the Lewiston cases in her reference, and Ms. Tebow did as well. And I wondered if this proposal would have impacted the two juveniles that were cited in the Lewiston cases. I'm not understanding the relevance of those cases to the problem.
So I think the answer is yes. If this proposal existed in law when those fires occurred, I don't know, because it's outside of my jurisdiction, if either of the juveniles was found not competent, but I believe one of them was. And so if that were the case, then the public, while that competence evaluation was undergoing, and if the court found the juvenile not competent, not likely to become competent, the juvenile's identity and what happened in the court process would not have been public at all. Now, of course, the fact that a juvenile has been arrested and charged is public. I mean, that's kind of common knowledge that I think the press can report on the facts without identifying the juvenile. And to be honest with you, Representative Babbage, I don't know if the Sun Journal did name the juveniles or not. I don't know. And Ms. Meyer would have to answer to that. And I certainly don't want to misstate her concern, but I know that from hearing her testimony, part of her concern was some alleged misconduct or mishandling of the case by the police. And that, in that case, if the competence challenge is raised and the juvenile is found not competent, then the public would not have knowledge of that incident where the police inappropriately questioned the juvenile. I do know that happened. So that, I think, is the balancing issue. You have the privacy of the 12-year-old versus the public's right to know and understand what goes on in these cases where the public has been greatly impacted. But again, I apologize to Ms. Meyer if I've misstated any of the facts or her concern, but that's my understanding. So yeah, things would be different under this proposal than.
Thank you for that. Appreciate it.
Yeah, and committee members, we will bring Judy Meyer in once we've completed the overview so that we have the opportunity to ask her questions as well.
Okay, so I'm still on page 4, disclosure of the juvenile's identity to the victim.
Excuse me, just 1 minute. It looks like Representative Hagan has a question for you before we move on. Go ahead.
Thank you very much. Quick one, very easy. We're talking about 13-year-olds and up, or are we talking 0 to 18?
Well, juveniles are any age right now, as the law exists right now. The 13 and up is where the automatic public access comes in. So if a juvenile is 13 and older and is alleged to have committed a murder, that is open to the public, and that may not be made confidential. If it's murder, manslaughter, or felony murder, those are the offenses that the judge does not have discretion to make those confidential. If they're 13 and older and commit an arson, it's presumptively open, but can be made closed. If they're under 13 and commit a murder or a Class A, it's presumptively closed, but it could be made open by the judge. So it's the burden shifted.
Thank you.
And ADA Tebow, can you, I know that that's kind of jumping ahead a little bit, and I just want committee members to be able to track where we are. So could you please refer us to the section of the bill where that age division occurs?
Yes, it's section 19 of the bill, and it's on page 6 of the original bill.
Okay, so just keep that in mind, committee members, because we'll be at that point shortly. Okay, you can go ahead with your excellent overview.
Okay, so back to page 4. Disclosure of juveniles' identity to the victim. One of the things that I, as a prosecutor, felt very strongly about, and the rest of the group has consensus around, is that victims have a right to be part of the process. In fact, their rights are protected in law as well. So even if a matter is closed to the public, with the exception of the competence hearing, which we'll get to later, but even if the matter is closed to the public, the victims still may be entitled to have information and to be present in court. And if the victim is a child, which often cases they are in juvenile court, then the parent of the victim may be present as well. Okay, so on to page 5 of the bill. Dissemination, we've just tried to, again, in the interest of cleaning up language, tried to tie it back to a consistent definition of what dissemination means. And we've adopted Title 16 language. Okay. Oh, section 15 of the bill just allows criminal justice agencies to share otherwise confidential information with essentially any agency that investigates child abuse or licensing of childcare facilities. That's kind of a technical matter, but currently we are not able to share information, say with DHHS, if they're investigating a child abuse allegation. If I have a juvenile report, I can't share it with them. So this language would allow me to do so. Okay. The next change is on page 6 of the bill, section 18 of the bill. It's that civil violation for disclosing confidential juvenile intelligence and investigative record information. So if I, as a prosecutor, share confidential information that I have inappropriately, I could be subject to a penalty of up to $1,000. Okay, section 19 is the heart of the bill. And this is what we've sort of been talking about. We start with the premise that all juvenile records are confidential. And by the way, many states make it really simple. They just say everything is confidential forever and nobody gets any information. And we didn't take that big of a step, but we start with the presumption that everything is confidential unless the law specifically allows the public to have access. In the first case, subsection A, 2A, if the juvenile is 13 and older and commits murder, felony murder, or manslaughter, the juvenile identity may be made public, or the public would have the right to inspect the petition 30 days after the first appearance. And that is, the court may not exclude the public from inspecting those petitions. If the juvenile is under 13, then subsection C applies and it's presumptively closed, but the court could make it open. So for example, if we have well, again, I'm going to use real cases because I think they're important to illustrate, not just hypotheticals. But let's say, for example, when we had a 10-year-old who was charged with causing the death of an infant, that, because of her age, would not be, even though she was charged with manslaughter, she would not be open to the public. However, if the press filed a request with the court under subsection C, the judge, balancing the interests of the public's right to know and the juvenile's right to privacy, and considering all of the factors of that child, her age, her developmental stage, whatever else the court might consider, whether she's a victim of abuse, all of those factors, the judge could make an individualized decision to make that case open to public inspection because she's under 13. So that's the first tier. The second tier is for Class A crimes. So if a juvenile is 13 or older and commits an arson, burns down a house or buildings, that is presumptively open, but the defense attorney could file a request to have it made confidential, both the juvenile records and the court proceedings. So if that juvenile is 15 years old, but developmentally 10, then the attorney could file the request to have it closed. Similarly, if it's a case involving a GSA of a young sibling, I may say, I don't want this to be part of the public. I don't want the public in here for the protection of this victim. So I could petition the court to say, yes, I know this juvenile is 15, but I would like to have it made confidential because of to protect the victim's interests. So second stage is presumptively open, but can be made confidential. And the third category is presumptively confidential. And that is any juvenile who's under age 13 who commits a murder, manslaughter, felony murder, or a Class A crime, or any juvenile of any age that commits a Class B or C crime. So if there's a juvenile that's committed a string of burglaries, residential burglaries, Class B burglaries in the area, that would be presumptively closed, but the press could say, hey, you know, this has been real disruptive to our community. We want to know what's going on in this case. And again, the judge who hears all of the facts of both the nature of the offense, but also the nature of the juvenile, would make the decision on whether to allow public access to the petition and the court proceedings.
So can I just interrupt here for 1 minute and just, so the framework is on pages 6 and 7 in section 19. Subsection 2A is the public records that cannot be closed. Section B is presumptively open but can be made confidential. And those both apply to 13 and older. And then section 3 is younger than 13, and those are presumptively confidential unless the court decides to open them to the public. Is that essentially a top line?
Yes, the only clarification, Senator Carney, is that subsection C or paragraph C would apply to juveniles 13 and younger, but also juveniles of any age who are alleged to have committed class Bs and Cs.
Oh, thank you for that clarification.
And all, if a juvenile is alleged to have committed just a misdemeanor offense, class D or class E, it's confidential.
Thank you. And this is a section where we've got some proposed amendments. Can you let us know if the amendments are substantive changes or, and then also just describe them for us so that we can all follow along with you?
Yes, so they're not substantive, and the change in the language is proposed in response to some concerns that the judicial branch had about how they would implement the policy. So for example, one of the clarifications is adding some language around or changing the responsibility to redact information about victims. The original first said that the court would redact information about victims, but actually that's the prosecutor's responsibility. It is under the new Court Records, Digital Records Act. So we wanted to make this juvenile code consistent with the Records Act and put that responsibility on the prosecutor. So that was one proposed change. And then the next proposed change involves, rather than, if a juvenile petition alleges both, let's say a residential burglary and a theft, that's a class E theft, you'd have a B and an E. Rather than making part of a petition and part of the information public and part of it confidential, we've included language that says the highest charged offense governs how the petition is handled at the court level. So if it's a B and an E, everything is confidential. Everything is public if the court has made it public. It's too onerous to try to have them sort out, well, we can share this information, but we can't share that information.
It also looks like the amendment fixes or proposes a resolution to the concern about records prior to January 1, 2020. Kind of
Yes.
Page 2.
Yes, and that was brought up by the Caroline Hova and Julie Finn, the judicial branch, which is what triggered my mind about, do we need to have the history, juvenile history record information reflect that same date? Because let's see. And that's in the sealing section. Yeah, that's in regard to the sealing, which we haven't got to yet, but.
Okay. All right. So thank you for addressing, tolerating my interruption and addressing those issues. Please go ahead and continue if you.
It's easier, frankly, to answer questions than it is to go off on a full description. So I appreciate the questions. Okay. So we've gone through the 3 tiers. On page 8 of the bill, sort of the top, toward the top of the page, you see subsection 3, orders of adjudication open to public inspection. So juvenile case, just to back up for a second, juvenile case records consist of a number of different things. We have the petition that's filed by the prosecutor. There might be a copy of the summons. There might be an affidavit if a warrant was requested. There might be psychological reports and evaluations, but there are only specified juvenile case records that are open to public inspection. We wanted to be really careful about this. 1 is the petition, and 2 is the order of adjudication if the juvenile is adjudicated of a murder or class A, B, or C offense. That's consistent with what the juvenile history record information will share. So it wouldn't make any sense to say, well, somebody could get it from SBI, but they couldn't get it from the court clerk. We wanted them to be parallel. So if a juvenile, let's say a juvenile is charged with an aggravated assault, and that offense is dropped down to a simple assault, it would be an adjudication for a class D offense, and that would not be open to public inspection. And that would be subject to, when we get to sealing, you'll see that too. The classification, even though juvenile crimes are not technically classified, for purposes of sharing information, we have to assign them the classifications and as if they were an adult. So we wanted, again, to have parity between the juvenile history records and what the court clerks can share. And again, I think we include, I don't know if we included language in there that says the highest level of crime adjudicated is what governs. So it wouldn't make any sense to say that juvenile is adjudicated of a class B burglary and the clerk has to disclose that, but can't also disclose the order of adjudication that has the class E. You know, if they're together, it's the highest classification that governs. Okay. A lot on further down on page 8, subsection 4, we've got some juvenile information, some definitions, but most of what you see there is all existing law except for the new definitions. Everything on page 9 is existing law. It's just relocated to a new section that we've created, this 3308C. We're proposing repeal of 3308 and implementing 3308C. So a lot of it's just carried over. So all of page 9 is existing law. All of page 10 is existing law. On page 11, the top half, everything before juvenile case records sealed, all of that is existing law with no changes. We are proposing a change to the sealing of juvenile records. With regard to case records that relate to murder or a class A, B, or C crime, we're proposing that the law remain the same, which is that the juvenile has to wait at least 3 years after they've completed their disposition, and there are no new adjudications or no new charges pending. That's existing law. So for the most serious crimes, we're not proposing any change to the sealing provisions. With regard to class D and E offenses, however, and offenses that would be civil if committed by a juvenile, like possession of alcohol by a minor, we are proposing an automatic sealing once the juvenile has completed their disposition. So if they have to do community service, as soon as that's done, or if they have to do a restorative justice event, as soon as that's done, pay their fine. And the court would receive notice about the juvenile completing their disposition from one of 3 different types of sources. And you'll see those sources on the top of page 12. So the Department of Corrections must provide notice to the court if a juvenile is released from a commitment. So if their commitment, once they're discharged from a commitment to DOC facility, or if they're ordered to do a shock sentence, once they've served that shock sentence, DOC provides notice to the court. Similarly, if the juvenile is on probation, once their probation has ended, the DOC must provide notice to the court. If the juvenile court orders the juvenile to do something and provide proof to the DA's office, like restitution, that's often a case. We are responsible for collecting the restitution and paying the victim. Once that juvenile has completed their obligation and we're aware that they're done, we would provide notice to the court. So things like restitution or doing a restorative justice event, sometimes letters of apology come to us. We must provide notice. The third option is the juvenile himself or herself or their attorney on their behalf may file a notice to the court to say, hey, my client was ordered to do X, he or she has done X, would you please automatically seal this record? That's where the added language about prior to January 1st, 2000, that's where that language comes in, because we don't want to go back more than 20 years. If this law were to be enacted, then juveniles who were adjudicated last year, for example, of a Class D assault, could file a petition with the court to say, hey, I've done my probation, I've done my community service, whatever, disposition is complete. Would you please seal my record for Class D assaults? So we didn't want to go back really more than 21 years.
Thank you. I see that we have a couple of questions, and I think they're questions related to this section 19. Are you all set with your overview of section 19, your very in-depth overview of 19, such that we can do questions now?
Just two quick points. One, even if a juvenile record is sealed, the courts and criminal justice agencies still have access to that information. So if a juvenile comes to court at 19 or 20 and the judge says, have you ever been adjudicated of an assault before? Even if that record is sealed, the court has that information and the juvenile cannot lie and say, no, I've never been adjudicated. So courts and criminal justice agencies get sealed records, and records that are sealed do not affect a juvenile's ability to get a firearm. So let's say a juvenile has been adjudicated of I'll use a real case, an armed robbery, and the gentleman was 35 years old, came back and wanted his record sealed. He would still be prohibited person for purposes of possessing a firearm. Sealing does not impact that prohibition.
Thank you. Okay, so let's take some questions from committee members. I think Representative Hagan, your hand was up first.
I would defer to Representative Newell. I think she was.
Okay, I was looking at the documents. Go ahead, Representative Newell, and thank you, Representative Hagan.
Thank you, Representative Hagan. Thank you, Madam Chair. I believe, Ms. Tebow, I think we were speaking about page 12. Yes. I know we moved on a little bit there, but I just had a question relating to DOC making notice to the courts. My question would be, how would those records be reconciled from the DOC notices to the courts? Is there a process of reconciliation?
I'm not sure if I'm understanding the question, but what I anticipate would happen is there would be a standard form that would be created by the judicial branch, because we like that. We like uniformity, that Cumberland County has the same form to submit as every other county. So I would anticipate that there'll be a form created, and then someone at DOC would be responsible for filling out that form when the juvenile is done with their probation, or once they're released from Long Creek, if their commitment is up. So there are only 17 kids committed in Long Creek right now, so there wouldn't be an overwhelming burden on the Department of Corrections to send notice to the courts when they're completed. So I don't know if that answers your question, Representative Newell, but I suspect there'll be a standard form that will have to be completed.
Okay, thank you. It just doesn't reflect anywhere in the language.
Yeah, we didn't implement and I'm going to defer. I don't know if anybody from the court is in your waiting room and might be able to answer that. If Betsy Boardman or Caroline Hova are there, they might be able to discuss that. But we just anticipate, knowing how the court has uniform forms for practically every event, that's what we anticipate would happen, is that the court would create a form.
Okay, thank you.
Representative Hagan, you're next.
Yeah, thank you, Madam Chair. So at the bottom of page 11, the last paragraph, is that where we seal D or E offenses once after the disposition is taken care of? So all Class D and all Class E are sealed from the public, but not the courts.
Correct. And the real benefit to a sealing is this: it allows the language that I want to point out. Where is it?
Is it section
juvenile
C? 10C?
Oh, it's B. Yeah.
Yeah, 10B. Yeah.
So the juvenile, if the juvenile, let's say they're applying for a scholarship.
Yeah.
And the question is, have you ever been convicted of a crime or adjudicated of an offense, juvenile offense?
Yeah.
You could answer no and not be subject to penalty. They can't do that with the court, though. But it is a benefit to juveniles who are applying for positions, applying for scholarships, applying for housing. There are these life events that are really important to emerging adults, that oftentimes just having to disclose that they have a juvenile record can impact those benefits to them. So certainly for the minor offenses, we wanted to make it real easy. To be honest with you, even though the current law is pretty liberal in allowing people to file a request to seal, it rarely happens. It rarely happens. And so rather than put the burden on these young adults who are, got a lot of things going on to have to come to court 3 years down the road, the policy proposal is, let's make it automatic, kind of give them a clean slate as soon as they've completed their obligation to the court, disclose, or they can not disclose their juvenile court history.
All right. And that goes for applying for jobs. If I have an assault record when I'm 14 or 15 and I want to work at a daycare or be a teacher or something like that down the road, I can just say nothing ever happened and there'd be no way for them to find out that I did that.
Correct.
Okay. That's great. Thank you.
Representative Evangelos, go ahead.
Thank you. Very quickly, Ms. Thibault, good morning. Good morning. Yeah. Just a real quick question. We may have talked about this once before, either previous session or this year, but I forget, what is a shock sentence?
A shock sentence is when the juvenile court orders a juvenile to serve a determinate period of time at Long Creek, and the statute limits that to 30 days. So let's say a juvenile commits a very serious assault. The court could say, well, I'm going to put you on probation, but I also want you to serve 7 days at Long Creek Youth Development Center. It's not a practice that in Cumberland County we endorse. It's not effective at anything really. So it's on the books, it's allowed, but I think it's fallen out of favor for a large part. We don't ask for those too much, but that's a shock sentence. The court can say the juvenile has to serve anywhere from 1 to 30 days at Long Creek.
Okay, thank you for that. Is it possible when the Prosecutors Association meets that we could get a new name for that?
We could. It shocks. It's interesting you say that, because shock sentence in some other places has a different connotation. It's the way that it's been, just the colloquial term that's been used by everybody, courts, corrections, DAs. So it's not in the books anywhere. It's not listed. Technically it's a period of confinement up to 30 days. That shock sentence is just.
I'm just going to interrupt you because I feel like if we start to take go off the focus of this bill, that we'll lose our momentum and our ability to complete the work session today. But thank you for sharing that information. I was curious too what it was, and I appreciate the question, Representative Evangelos. I think that Representative Harnett has a question. Go ahead, Representative.
Thank you, Madam Chair. And I had to leave for a while, so if this has been asked and answered, just tell me and I apologize. But Ms. Tebow, you just talked about one of the benefits of automatic sealing is that it helps people who, that people just don't apply to have their records sealed, correct? So this will happen automatically. How will they know that? How will they, the person applying for a scholarship that you mentioned, who can now say, I was never adjudicated. How are they going to know that? Do they receive notification when the records are sealed?
That there's no obligation on the court to send notice. That would be their attorney's obligation. Most kids have attorneys. Unlike in the adult system, it's just if they qualify, there doesn't have to be a risk of confinement for a juvenile to get an attorney. So most of them have attorneys. Or if it's through my office, for example, I would have to say, okay, you have completed your obligation, you paid your restitution. Thank you. Your record has automatically been sealed. You may now answer questions. But most of them have attorneys. But for those few cases where the juveniles don't have attorneys, they've worked with the lawyer of the day and admitted their violation at the first appearance. And yes, somebody would have to tell them.
Okay, thank you.
If this proposal is enacted, there is going to be a major push for education of the defense bar and the prosecution bar, because it's going to be some big changes. So, yes.
Okay, so I think we're on section 20. Is that where you think we are?
Yes.
Okay, we're doing well, everybody, and really appreciate your thorough review.
So, section 20, what this section does is it ties the public's ability to be present in the court for hearings with the petition being open to the public, to public inspection. So if a petition is open to public inspection, that opens the doors to the courtroom as well. Oh, before we leave the sealing, there was one of the amendments is to, I think the language in the original bill was the court shall immediately enter an order sealing. One of the amendments is introducing 5 business days to allow the court to enter that order of automatic sealing. Sorry about that. So section 21 addresses the juvenile code. 3318-A is the competence provision of the juvenile code. So what section 21 does is what I referenced earlier, is if a juvenile court suspends the proceedings to determine whether the juvenile is competent to proceed or not, everything becomes confidential. And again, the 3 bases for a juvenile to be found not competent are due to mental illness, developmental disabilities, or chronological immaturity. So if you have a 10-year-old, for example. The section 22 is, I believe we have some that was part of the proposed amendment as well.
It is.
Yeah. So the intent here is to clarify that the juvenile court proceedings involving competence are not open to the victim, even if they otherwise would be allowed to be in the courtroom. So you have kind of a lockdown on that process. And the reason for that, unfortunately, is we've been seeing an increase in litigation. So competence is really looking at the juvenile's mental and emotional functioning, right? It's not looking at the facts of the case or what the juvenile did. It's not really got the nature of the offense has no bearing at all on whether that juvenile is competent to proceed in the court. Sometimes the juveniles are found not competent, not likely to become competent, and the petition is dismissed from the juvenile court, but a subsequent civil proceeding is brought against the juvenile and or the juvenile's parents. Much of that information that is disclosed during the hearing for competence, again, has nothing to do with the facts of the alleged offense, but has everything to do with that juvenile's individual functioning. It's highly sensitive. There's a lot of history that may or may not be relevant to the facts of the case, but it often involves, disclosing the juvenile's mental health issues, their history of trauma and abuse, their functioning, but it really has nothing to do with the offense. So in order to protect the juvenile's privacy and kind of clarify that this is about the juvenile and not the offense, we wanted to lock down that proceeding and not allow victims who otherwise could be in a proceeding, a confidential proceeding, to be part of that process. I see a question.
Yes, I was just going to ask if you could pause for a moment. Go ahead, Representative Hagan.
Thank you very much, Madam Chair. Just a quick one. Who are the people who determine the three criteria of competency?
That's in the statute. The current juvenile code has that laid out, and it lays out some factors. So the judge ultimately decides competence, right? The evaluator can opine on whether the juvenile has skills that are typically associated with competence in the juvenile court. But the court can consider other factors as well. They could consider, for example, education records or other information about the juvenile's functioning, in addition to the evaluation that's done by state forensics. But at the end of the day, it's the judge who decides whether the juvenile is competent to proceed or not.
I thank you for that, and I think you should be a teacher. You're awesome.
And so just to clarify and follow up on Representative Hagan's question, so the three aspects of competency, mental illness, developmental disability, or chronological immaturity, that's already in the statute, and this legislation doesn't touch that. It preserves it as it exists.
Yeah,
Yes.
I just didn't know, so I appreciate that.
Yeah,
Thank
I didn't either, and I really appreciate your question as well.
you. Right.
Yeah.
Thank you.
With regard to the victim's interests, however, so although the victim or the victim's parent would not be allowed to be present during the court's determination of competence, the victim's family does have the ability to look at the final order. And the judge could craft that to include whatever information the judge, he or she wants to share with the victim, knowing that the victim is going to read that. But one thing we thought is important is for victims to understand why a juvenile case may be dismissed despite there being overwhelming evidence that the crime was committed. It still may be dismissed due to lack of the juvenile's competence. And so we wanted to ensure that that victim or the victim's agent could view the final order and have that understanding of why the case was dismissed.
Thank you. Let's pause for just a minute. Representative Harnett, go ahead with your question.
Thank you, Madam Chair. Do they get the entire final order, or are certain things redacted from the order?
Well, I think the way we've drafted it is that we anticipate it would be the final order, but the court, of course, knowing that the victim is going to read it, could, say what they want to say. The victim would not have access to any of the records that the court relied upon. So all the psychological evaluations, et cetera. We have had attorneys come in and ask for those records, and frankly, I've fought them as, along with the defense counsel. It's kind of an odd situation to be buddied up with defense counsel, but that is true. We fight tooth and nail to not allow those records to go out. But we did think that the final order, the judge's reasoning for why the case can't proceed, should be known to the victim. And frankly, the court should say that and not the prosecutor. Although I could say to a victim, here's what the court said. I think it's really important that they see from the judge, him or herself, why they're making that very difficult decision.
So they see the order, but not the records it was based on, not the evidence that was used to reach that determination.
Correct.
Thank you.
We are just about to the end. Oh, Representative Babbage, go ahead with your question.
Just a quick one. Ms. Tebow, I appreciate your attentiveness to victims and that being included in the bill. I do often worry. I mean, obviously, the injustice to victims is a terrible thing, and oftentimes a motivator for law enforcement and the courts to do justice. But the crime against the state and public safety is truly our charge. And so I want to know if victims would be instructed and penalized should they improperly disseminate information.
Well, they wouldn't have access. They wouldn't have access to any confidential records, whether it's police reports. I don't share police reports with victims. I don't share any information that that they could then turn around and disseminate. So if a victim, let's say, has written a statement and that's part of the police report, we'll let them see their statement. Obviously, they've written it, they know what it says, but we don't share that information. I think, yes, in theory, if a victim somehow did get access to confidential records, whether it's through the courts or through prosecutors or law enforcement agents.
How about releasing identity? I mean, just that simple.
Would they be? I think I'd have to think about that, Representative Babbage. My gut reaction is, yeah, that's the way the statute's written, that they would be, but that does seem to be an injustice. And frankly, it has happened with cases that are very serious in nature. I can think of one case I prosecuted that involved sexual abuse between cousins, and the police department erroneously gave the entire report to the victim's family, and then that victim's family was literally sharing it with the public,
right?
Putting it out there, and I had to tell the police, go back, get that report. You never should have given it to them. So yeah, it does happen, and in that is an example of, yes, where a victim could be held civilly liable for a civil violation for otherwise sharing information that they shouldn't share.
I just thought there should be precautions that they would be instructed as to consequences should they do that. Thank you.
That would be the prosecutor's responsibility to share that information, or police if the police are disclosing an identity to a victim. Yeah.
Can I ask a related question to Representative Babbage's question? So if the victim has information about the identity of the person who is alleged to have committed the crime, just because they saw them, not by virtue of any juvenile proceeding, are they prohibited from releasing that identification?
I don't yeah, I'm gonna have to think about this. No, I can't imagine. I think the intent of the civil penalty was to penalize sharing otherwise confidential information that's maintained by law enforcement or the courts or SBI. But if somebody observes a crime, I don't think we could penalize them for saying, hey, I saw Johnny Juvenile, beat up so-and-so, or to be more current, I saw on YouTube, Johnny Juvenile put up a video of himself beating up, somebody. It would be really hard to say that is, I don't think that would be a disclosure of otherwise confidential information.
That's my read as well. I think it has to be derived from the confidential information.
Yeah.
If I may, Madam Chair, the reason I asked the question is that you have been particularly permissive and attentive to the victim by permitting them to be present. And my point is, if you are doing that, then they have responsibility to abide by the same rules, in my opinion. So that's why I thought that instruction, whatever, by the attorneys or whatever, should be institutionalized so that it's done properly.
That is an excellent point. Yes.
Thank you.
And we did not include that in there, but you're right. It should be clear that is the responsibility of people who maintain those confidential records to instruct victims that they're being confidential information and they can't otherwise disclose it.
All right. Thank
Okay.
you.
We're getting really close to the end.
Yeah. Okay. We'll hand the virtual floor back to you, ADA Tebow.
So on page 14 of the bill, we've got the victim may inspect the final order for competence. And then section 25 of the bill, and I'm glad to see Chris Parr is still with us, is some language that he's crafted that creates essentially a civil cause of action. And this is designed to be more toward publication of broad publication of confidential information. So if someone obtains confidential juvenile information and then publicly disseminates it, let's say to the National Enquirer, makes a lot of money because they've sent a salacious story about a 10-year-old who caused the death of an infant baby. That would be subject to civil remedies that include both an injunctive relief and, let's see, where is it? So the relief is on the top of page 15. Injunctive relief, court costs, attorney's fees, actual damages of up to $5,000 and punitive damages. And perhaps Attorney Parr can tell us where that, I know he's doing an analogy to another statute. I'm just not sure where that is.
Thank you. Welcome, Attorney Parr, go ahead.
Hi, yeah, I'm in a better place now situationally in terms of the ambient noise. So thank you for having me back. Yes, so that provision is basically, the statute I looked at is in the Maine Civil Rights Act. And it's very much modeled after that, although we did, of course, have to modify it to address the types of information that are involved and treated by this bill. And it's also the bill generally, I think, at least for me anyway, as I worked as a consultant on this bill, but including this section, really is a recognition of the world we're living in, where information is just can be anywhere immediately at once, and can really affect especially juveniles, but really all people for the rest of their lives. And that includes not just a publication like the kind that Christine mentioned, but also just social. Everyone can be a publisher now, and it can be used to bully people, to stalk people. And this is information that can be very very harmful, not only to reputation, but I would even say to people just in terms of what they feel, how it makes them feel. So this is a way to, this as well as the penalty provisions is really a way to ensure that, you know, this bill means something. The things being done through this bill mean something and have consequences. So I hope that's helpful.
Thank you. Committee members, are there questions for Christopher Parr? Representative Babbage, is your hand residual? Yeah. Okay.
Thank you.
Any questions for Christopher Parr on this section 25? Not seeing any. Thank you very much. And then ADA Tebow, if you are the appropriate person to continue, I think we're ready to move on.
Yeah, so I think that is it for the substantive changes. Everything in sections 26, 27, 28, everything else in the bill is just clarifying that language around administration of juvenile justice as it appears in various statutes. So everything on page 16. Yeah, it's all just administrative stuff, not substantive stuff.
And then I just wanted to highlight in the proposed amendment that it proposes an effective date of January 1, 2022. And do you feel like that is an appropriate addition to the bill?
That is at the request of the judicial branch, because obviously this would require substantial training of their staff. And as I mentioned earlier, creation of forms for consistency. So yes, they did ask for some time.
Thank you very much. And then I don't know if you are familiar with the amendment proposed by the state archivist?
No.
Okay, I think we'll just ask Peggy to speak to that because it's a slightly different angle. Peggy, did you want to address that for us, please?
Sure, I would be happy to, thank you. And I've been trying to work with the archivist, McBrien, to make sure that we're covering everything. I think, so the idea is, and I can show you the current law that we're talking, if this is what you want to talk about now, I can show you the current law that we're trying to address. So if you don't mind, I'll share my screen real quick.
Go ahead, thank you, perfect.
Okay, so this is in the archives law, and it shows it's the powers and duties of the state archivist. And the language we're looking at, current law, this is what current law says: restrictions or limitations imposed by law on the examination and use of records transferred to the archives. And under subsection 2, paragraph A, subparagraph 3 are the record retention schedules. So those are records that are subject to basically permanent retention, and they're shifted over to the archives, remain in effect until the records have been in existence for 75 years. So after 75 years, those protections, the statute says it's confidential, it's not a public record, those go away after the record has been in existence for 75 years. Unless somebody works with the archives to make it happen sooner. So this is kind of the overlay, and what archivist McBrien has recognized is that we don't really think about this law applying. So when we talk about making things confidential, maybe we need to start making clear that we still want this law to apply, which means they're going to be public after they're 75 years old, if they're still retained. There are plenty of records out there that whatever the record retention schedule is, they don't need to be retained permanently. And I don't even know if all these juvenile records would be considered archival, in that they would have a really long-term retention schedule. But so this just says if they do, and they're at the archives, they become public after 75 years. So in order to draw people's attention to that, we were talking about putting some language in. This is with regard to the juvenile history record information, that juvenile history record information is subject to this 75-year limit on confidentiality. And if you don't think, if the committee says, no, we want them to be confidential forever and ever and ever, then we say it's not subject to Title V, Section 95C. And we were just trying to figure out, we probably need to have this, if you want to go forward with this, one way or the other, we should probably also cover the juvenile intelligence and investigative record information, because juvenile history record information doesn't cover everything you've talked about. And then also the juvenile case records. So have that same, be thinking about it now, what happens 75 years after these records are created.
Thank you. Thank you very much, Peggy. And Christopher Parr, did you want to weigh in on this as well?
Well, just a comment, and I say this more from someone who works with confidential records and provisions a lot, and as well as a member of the Right to Know Advisory Committee. And I just wonder if, I mean, really, if I understand, Peggy, and you can maybe clarify, this is a provision that really would apply to any kind of confidential, right? And if that's the case, I wonder if even through this bill, there might be some sort of directing language to the revisor's office to drop that qualification in, or maybe put it in the right to know law itself to modify 4023A, which exempts confidential records that are confidential by statute. Something to the qualify that definition somehow, saying except to the extent that they're not confidential under under that provision that I've forgotten already that you just had up on the screen.
Right.
Just a thought.
And I'm always a little bit wary about amending one law to recognize an overarching law, because then it makes it look like if you don't recognize it in all the other laws, then it's not, the overarching law doesn't really apply.
Right.
So this is kind of an experiment of talking about how to deal with this and make sure that this archivalist law is recognized by the agencies who have these confidential records. So it's resolved at the beginning rather than when the 75 years end.
Yeah, and if we were going to do a more overarching, I would think that we would want to have a public hearing on that sort of applicable change.
Right, and I think this is the first time I've ever thought about it. So this has been a great learning experience for me too, and I've been working with the Right to Know Advisory Committee for a long time. So, it's not something you absolutely have to do now, but it's really something that we should be thinking about when we talk about confidential records. And if you think it's okay for these records to be public in 75 years, then maybe you don't do anything. And maybe, like Mr. Parr says, we do something in the Right to Know Advice in the Freedom of Access Act. But if you want to keep them confidential forever, really forever, that's when you say Title V, Section 95C, subsection 1, paragraph C does not apply. Maybe that's when you write it into the statute.
Okay, thank you.
I'm sorry to throw a new issue at you, but since we are talking about the confidentiality of all kinds of juvenile records here, I think it's a really good time to start at least talking about it.
Yeah, agreed. Thank you. Representative Babbage, did you have a question?
I had a question for Ms. Tebow before we finish the discussion.
Okay.
That's okay. Ms. Tebow, could you identify a couple Class B crimes for me to give me an idea?
Residential burglary is a Class B. Theft of a firearm is a Class B.
Thank you. Okay, so the crux of this to me is that for 16 and 17-year-olds who are minors, they are minors in my acknowledgement, the presumption would be a closed records for 16 and 17-year-olds that commit a Class B crime. Is that right?
Yes.
Thank you. Okay.
And if I may, I am embarrassed to say I omitted a key member of our work group, and I want to give her a shout out. Jill Ward at the Maine Center for Juvenile Policy and Law, was instrumental in bringing us all together. And Miss Ward is a nationally recognized expert in this and is pretty familiar with how other states manage their juvenile records as well. So she had a big influence on us and how other states are wrestling with these same policy issues that we are. So sorry, Jill, that I missed you earlier.
Yeah, thank you. Go ahead, Representative Hagan, you have a question?
Yeah, thank you very much. A light bulb went out and I was listening to Representative Babbage's excellent question, and then all of a sudden I was distracted. I apologize. Could you restate the question and the answer that you guys just did? I missed it and I felt it was pretty important.
So Class B crimes like residential burglary, theft of a firearm, theft of something that's worth more than $10,000. Those are all Class B crimes that we see juveniles committing. And the question was, that would be presumptively confidential for a juvenile of any age. And that's true, whether the juvenile is 13 or 17, that would be presumptively closed, but the court could allow public access if a petition was made and the court grants that.
All right, thank you.
Okay. So at this point, committee members, I'd really like to bring Judith Meyer back on or onto the panel, because I think that there are some questions that members may want to ask her. And Representative Babbage, did you have a question before we move on to that?
The one question that I have, and I'm very supportive of this entire effort, but obviously in balancing, we are having the courts, we're having attorneys and law enforcement come to us with this proposal, and it does provide for less public scrutiny of the courts and law enforcement. And I was just wondering if anybody had any insights, and I didn't know if it'd be Ms. Ward or anyone actually, as to, since other states are also wrestling with this question, have they acknowledged that issue and dealt with it any differently than what we have in front of us? That's I'm exploring that, but I want everybody to know I appreciate very much all of this work, and I think, as written, I think it would do more good than potential harm, but I wanted to explore that possibility of have there been ways to address, would it mean more targeted concealment of records, or would it mean shorter time periods of being closed, or if anybody had any information on that, I wanted to ask that question. Thank you very much.
Can you, Representative Babbage, I'm not sure I'm following your question. Could you restate it? Just kind of focusing on
okay.
What are you trying to get?
I think what we're achieving.
Hang on a second. Are you trying to get a comparison between this legislative proposal versus the current law? Is that what the comparison that you're asking for?
No, what I think we're addressing is the positive impact that could result from us allowing greater confidentiality and concealment of juvenile records. And I think we're all on board with some positive things we can achieve here. I think the cost of doing so would be a little less public awareness of perhaps policing or court procedure and how it's handled. And I'm just wondering if in awareness, I think Ms. Tebow mentioned about Ms. Ward being aware of other states and so forth. I wondered if that weighing of, I mean, it is the right to know committee, but what we are constantly being asked is to conceal more from public scrutiny. And so I'm asking for that balance. Have other states done so similarly to what we're proposing here, or have they balanced it any differently? That's where I thought the question should be at least in front of us as we weigh the consequences of the bill. Thank you.
Thank you. Yeah, and Jill Ward is not here, but let's see if ADA Tebow could address that, because I know that you were carefully weighing those issues. Go ahead.
I do not know how other states balance these, but I can share only my experience. It's pretty rare, frankly, to have the press in the juvenile court process. It's usually events that are public knowledge already. Something big has happened in the community. It's whether it's an arson or some event has happened that, and the press knows that it's a juvenile who's been involved, and then they ask to be part of the process and given notice. So it's rare. It doesn't happen a lot. However, we are seeing an increase in other people sharing information, and as Attorney Parr referenced, with the digital age, it's really easy for people to get bits and pieces of information, and then it gets everywhere, and it can be very damaging to kids. So that is a big concern of ours, is that with the ease of access of sharing information, that it should be really hard for people to get damaging confidential information about kids. We don't want that to be spread everywhere. Kind of as you were speaking, Representative Babbage, a thought came to my mind was, I wish more people understood what was going on in the juvenile court. One of the, as you all know, there are a ton of bills in the legislature to reform juvenile justice. And I think to myself, oh, I wish they would come and see juvenile court, and then they might understand the impact of those proposals. So I'm kind of going to probably not make any friends in my group saying this, but part of me wants more people to see what's going on in juvenile court, so that there's an accurate understanding of, quite frankly, the degree of care we take with each and every case. So I too see the value of having transparency of the court process. It can help juveniles in the end if people see how the court works. So I'm sorry if I'm speaking just for myself, not for the group, but just wanted to share that thought with you.
Thank you both.
Thank you.
Yeah, Senator Keim, I want to give Judith Meyer an opportunity to speak, but did you have a question for ADA Tebow before we change gears a tiny bit? Okay, go ahead.
Yes, and it does follow a little bit on what Representative Babbage. I mean, I too am supportive of this, but I want to look for ways that we maybe have gone further than we need to, because I want to balance the public's right to know, and I want to highly value transparency, so that it's good for the juveniles, but it's also good for Maine people to know that they can trust their court systems, and they know what is going on with policing procedures. So, but I had asked earlier, and then I had to jump off, my apologies, about the idea of trying to allow more information out if we kept the name of the juvenile confidential. And I don't know, when I first asked that, it wasn't something we chatted about, and I don't know if it was brought up again since. So I just wanted that responded to.
So in theory, it makes good sense, and it seems like it's a good balancing. I'm just thinking of implementation of how that would work for the courts. So let's say a member of the press wanted to know what's going on with a case involving a high-profile event in the community. How would that clerk know that he or she is providing the accurate information about the charges if they didn't know the juvenile's name, if there wasn't some way to connect the two. So I guess I would really have to think carefully and would want to talk with folks at the judicial branch about what a law would look like that would allow some information, but not the name of the juvenile to be disclosed. You know, if the press were to call my office, for example, and say, we understand that a juvenile was responsible for driving a motor vehicle and killing some kids, for example, can you tell us the status of that case? I could easily say, yes, we've charged a juvenile with manslaughter, reckless conduct, whatever, and not disclose that juvenile's identity. But at the court level, I don't know, you know, if let's say Ms. Meyer went in and said, I want to know what's going on with the case with the juvenile who drove the car and killed 3 people. I don't know if the court would be comfortable sharing any information if they didn't know that that information was related to that specific case. So, you know, I don't want to speak for the court, I guess is what I'm saying, but not a very satisfying answer. I'm sorry, Senator Keim.
I think that's great. I would love to hear from the courts on that, because again, just trying to find a balance and make sure we're as transparent as possible. I so appreciate the answer. Thank you.
And I apologize to everyone, but I do have to leave in about 10 minutes to go meet with a family. So I apologize.
Thank you. Let's hear from Judith Meyer and then see if there are any additional questions. Welcome, Judith Meyer, to the Judiciary Committee. I know you've been listening to our discussion today and wanted to give you an opportunity to present your perspective on this legislation.
Thank you, Senator Carney. I really appreciate the opportunity. The Lewiston case came up a couple of times, so I'd like to just talk about this bill as it might have related to that case, because it's a case I'm familiar with and it's a real example. If the media, one of the two 12-year-old boys were charged on the same day, and their hearings were set, their first appearances were set at different times. But so the children were charged on May 11th. The first appearance for one of them was 2 days later. And the child was represented before he appeared. It was not a lawyer of the day. Both children received lawyers immediately. But the attorney for the first boy, the white child, when he learned that he was not Mirandized by the Lewiston Police Department, he filed a motion immediately to have the case dismissed. If the petition were not available to the press or any court proceedings until 30 days after that petition was filed, we would not have been aware of that right away. And there was huge public interest in that information, because this particular misdeed of the Lewiston police followed on the heels of one not too long before that, where they threw away evidence in an aggravated assault case that really turned the outcome of that case. So the Lewiston PD was under some pretty deep scrutiny, and this provided the public the information that they need to understand what happened here and how that case was ultimately dismissed. Secondly, on the 30-day delay, I did file addendum testimony yesterday, I believe, concerning a lawsuit that a number of Maine newspapers filed against the judicial branch, challenging a delay in access to court records.
Of course you called.
As soon as that case was filed, I think it was within a week, the court reversed itself, recognizing that it was unconstitutional to have a delay in legitimate court records that should be available to the public. So that's a critical piece of information to think about. Is a delay something that Maine can implement without, coming up against a constitutionality test?
I'm sorry to interrupt you, but there was some other noise on the screen, and I just want to ask you, the case that you were just referring to, did that also involve a juvenile?
No, it's a civil lawsuit that Maine newspapers filed against the court system based on its new digital platform that wouldn't allow any records at all filed or available to the public until at least 3 days after someone was served. So it could be a delay of 3 days, 90 days, a year, and we challenge that on constitutionality grounds, and the court reversed itself quite quickly.
Okay, yeah, I just wanted to clarify because I didn't think that involved juveniles, but I
No,
wasn't sure.
But
Okay.
it's the idea, it's the notion of a delay in access to otherwise public court records. The court itself recognized that that was not a proper rule to have made. And in terms of this idea that we would differentiate between ages here, in the Lewiston case, both of the boys that were charged were 12. So under this proposal, the media would have had to filed a motion with the court to make everything public as part of that case, and then wait for the court to issue its order. And I can tell you that I have waited 3 months, 6 months, even longer for the court to act on something and issue an order. And in all of that time, the prosecution of these children would have been shielded from the public. And as you know, they were treated very differently by police, treated very differently in the prosecution, and their case outcomes were vastly different. And I don't know, we could dissect the circumstances of that forever, but what stands out to me is that one child was white and had, a premier lawyer, and the other boy was Black and had some language difficulties and some behavioral issues. And he's the one who ended up going to jail. So I don't think the outcomes of that case were in any way the same, and the public really needs to understand that process. I also, just in the conversation earlier this morning, allowing the victim to see the competency order, I think is fair and good. But the public also ought to be able to see that order, because right now a motion to assess competency would be a public record for a 13-year-old or over. So we would need to have the other end of that outcome so that the public would understand why this juvenile is not going to be prosecuted or will be prosecuted, that order would make that decision whether a trial were to go forward or not. And lastly, I learned late last week that a member of this task force that's been working on this told a colleague of mine that I was the only one in the state of Maine that was objecting to this bill. And I just want to be really clear that I represent 43 print newspapers and a number of digital platforms, hundreds of journalists, and we consider our mission to represent the public. So while I may be sitting in this chair talking to you, I'm representing many people, and I am most assuredly representing the public interest. And I just want to make that really clear, because I know I can be a little bit of a squawker. And I want you to know I'm not against every piece of this, just these certain elements. I mean, the Maine Press Association is not an ogre. We understand that juveniles deserve and need protection, but we just believe there are certain elements of this bill that go too far. And I'm happy to answer questions.
Thank you very much. And speaking for myself, I understand that you're here on behalf of the Maine Press Association and that you are representing the public interest.
Thank you.
Senator Keim, go ahead. I think, well, Representative Babbage, your hand is residual, I believe. Okay, Senator Keim, go ahead.
Thank you for being here, Ms. Meyer. And yes, I'm pretty sure everyone recognizes that your voice is meant to be one of keeping transparency, and part of protecting juveniles in the juvenile process is exactly that. It's transparency. So and I think we want to balance that. But so my question for you is a couple. One is, if you were to look at this and offer some limitations that you believe balance these competing interests better, would you be able to offer those? That's one. And then this, I think I'll let you answer that first, and then I have the other.
I don't think the 30-day rule serves the public interest. And I would like, Maine Press would like to see that eliminated from the bill. And I also, maybe I should say that to be more clear, the difference in age seems arbitrary, particularly when, young children do commit felony crimes. The Sun Journal is currently covering charges against I believe she's a 10-year-old girl in Auburn. She been charged with attempted murder. We have not named her, but we have been reporting on her case as it has moved through the court. And I also think that the public needs access to the competency order in equal measure to the victim. I hope that answers your question.
It does. And maybe the case you just brought up, but one of the concerns I've heard raised that more recently, as this bill has been developed, is actually some coverage by the Lewiston Sun Journal around confidential information of a juvenile being released that they, which many people believe has been problematic. I asked a little bit further about that, and I asked whether it was actually because of current policy or because of human error, because sometimes, we're never going to stop people from making mistakes. And it was the child who shot her father, and I just don't know the age of that. I thought 11 or 12, maybe it's the case you were just referring to. But can you help me understand that a little better? What if you believe that it was current policy or if that was human error? Because I do understand the concerns there, and I want to make sure we're addressing them only because it helps so much to put these types of this type of law concretely with issues that are before us so we can understand how they play out.
I don't know what information you're referring to. As far as I know, we've never received confidential information, either on purpose or through human error. If it's the case, the recent case of this young girl, we were told right from the start by the district attorney that when this child was charged, he wanted us to know that she had some mental and emotional development issues. And it was not information offered to tell us what to do, just to give us more information about how we would report it. And based on that information, we did not name her and have no plans to name her.
Okay, that's helpful. And then I guess the only other thing is I had made a suggestion about allowing more information to be released, but the name to be kept confidential. Can you offer, and we haven't yet heard from the courts if that's possible, but if it were, what is your perspective on that?
I share Ms. Tebow's concern about how that would be managed. I can tell you that in the arson cases in Lewiston, this was some years back now. And when the initial arson happened, there was a huge segment of the city that believed it had been started by an immigrant child. And in fact, that was simply not true. And the only way to bust that rumor is to provide the information about who the boy actually was. And we did it for that reason. There were some crimes being committed against immigrants because some people in the community believed that community was responsible for the fires. And we felt an obligation to clarify that. So initials wouldn't resolve that concern.
Thank you. Thank you.
Welcome.
Representative Hagan, go ahead with your questions.
Thank you very much, Madam Chair. I guess that's why they call them senators, because Senator Keim just took about 3 of my questions. I do have one left, though. I'm concerned about sealing records, and I was curious as to your opinion or thoughts on the sealing of the records of pretty high felonies by juveniles once they've been adjudicated and whatnot. What are your thoughts on that?
I don't like automatic seals. And I think that sealing a record even 3 years after the disposition of the case is not going to make any information that has been properly released during the prosecution of the case. It doesn't make it vanish. We will not be able to roll back our reporting of a case that we had been reported on just because the case is sealed. But I think the court, as Ms. Tebow pointed out, already has a process to seal cases, and very few people pursue that. So I understand the idea that we're protecting children here, but they have an opportunity now to do it and they're not employing it. So maybe SEALs are appropriate for class B and below, but not for the most serious felony crimes or felony defined crimes. So I would have to go back to the main press and get, some more feedback, but a system is already in place to do that.
Okay, can I ask one more?
Yes, go ahead.
In your testimony, your written testimony, you had talked about, excuse me, the parents of the minor can block information from coming out. And are you still concerned about that?
I am concerned. There are provisions in this bill that would allow the defense attorney, well, either side, prosecutor or defense, the child himself, the child's guardian, or their parent, to ask the court to keep it all confidential. And knowing what we all know about the judicial system, that request would probably most likely be made by families of means who have private attorneys, and not by, kids with lesser means. That's just kind of how society works in reality. And that, I think, is disturbing, that a well-heeled family would, of course, ask the court to make everything confidential, but perhaps not another family.
All right, thanks.
Representative Evangelos, I know your hand is raised, but I also realized that, she might have already left. I know ADA Tebow has to leave any second, and I just wanted to first express thanks for all the time you spent with the committee today, but also give you an opportunity to share any last comment that you wanted to share before you have to leave.
No, just my thanks to all of you for your attention. This is a very dense bill, and I really appreciate your attention. I'm honored to answer any questions, follow up if there are any beyond today, but I do have to run. Sorry. Thank you.
Thank you. Representative Evangelos, you may proceed.
Thank you, Madam Chair, and good afternoon, Judy. Nice to see you again. I'm really conflicted because I want to protect, the juveniles, but I always respect the free press. And is there any way that the two sides on this can merge and come up with a proposal that works for both, or is it just too much of a contradictory concept?
Well, we did, and we did that last year.
Yeah.
So I don't know what the thinking was behind, moving away from that compromise agreement. I would like to know the thinking behind that, but we compromised, and we would stick to that compromise should we go back to that document.
Okay, so this is that same concepts that we discussed when you and J.W. Oliver appeared then. I'm remembering this right.
Right, but this bill before you goes further than the compromise and deviates in significant ways.
Did that bill die because of COVID, or did we act on it?
It died.
Okay, and now we're here.
Right. Very much alive.
And I think I heard today that you or the Press Association wasn't contacted as part of the process in this development. Is that correct?
We were not.
So I guess it's pretty hard to come up with the old compromise if you're not involved. I don't know. I'm starting to wonder if we should table this, but I don't want to gum the works up. That's all I have right now, Madam Chair.
Thank you.
Thank you, Representative. Representative Moriarty, go ahead.
Thank you, Madam Chair. Ms. Meyer, I have notes from Peggy, I think taken at the public hearing, that this bill is similar to last year's bill, and that there was an ought to pass vote in August, but of course, August of 2020, but it never made it out of committee because the legislature never came back. So just because I wasn't on the committee last year, take me back to last summer if you can. Was there complete agreement on what we have, on something similar to what we have before us?
I would say there was unhappy agreement. as compromises always result in. The Maine Press Association didn't want to see the bill advance at all. But we did meet with the task force, this stakeholders group, and came to a compromise.
Yes.
On even the difference in the ages, which we are definitely not in favor of. And I fully expected to see that very bill as amended in the compromise come forward this session.
Well, I can understand that. Why didn't it?
I can't answer that question, but I will tell you the 30-day wait was added. The no access to the competency order was added. And there were a couple of other things, I think, in my testimony that I noted that were additions, which is where our objection lies, in those additions.
Okay. Thanks for the background information. That's helpful.
Go ahead, Representative Hagan.
Thank you very much. I would like to remind people that there were several committee members on judiciary that did not meet ever last summer, and they were all Republicans. I did go to all the meetings. I was not able to vote because I was not able to be there. But whenever we talk about judiciary unanimously or what have you, voting for things last summer or at the end of the summer, many members were not represented there. Thank you.
Yeah, and the composition of the committee has changed since then as well. Representative, before I call on you, Representative Evangelos, I just want to ask committee members, are there additional questions for Judith Meyer, or are we going to begin to move into our discussion of this legislation? Another alternative would be to take a brief recess since we've been meeting for almost 3 hours. Representative Evangelos, are you initiating discussion, or is it a question for Judith Meyer?
Well, it's kind of a combination, but it was a question for you, Madam Chair. Just some advice as our chair. Do you think it would be productive to allow these sides to get together and come back with what they brought last year, so people like me aren't so conflicted and the parties can work together towards a resolution rather than continue with this? It's just a suggestion. So I didn't have a question for Ms. Meyer. I'm just having a question about the process. Mm-hmm. It's difficult for me to get my arms around this when now it's come back to me, all the work we put into it, and several members of the Press Association were so integrally involved in the compromise that Judy spoke of. And now we have this new bill and no process to involve the parties that made such a great effort to meet in the middle last time. It just makes it hard for me to vote one way or the other, because I support both concepts. Mm-hmm. And we kind of got there with the compromise. The press didn't get everything they want, neither did the other side. But, we came together and voted, albeit with some absentees. But so I'm uncomfortable with the process because there were players left out of it this year. So I'm seeking your guidance on whether we should ask them to make a good faith effort to get together and come back and see us, noting that I'm looking at our schedule today and the rest of the week. That's why I'm putting it on you, because I don't want to make the call. Thank you.
Yeah, thank you. That's not a softball question, but I've caught the egg in the egg toss. I think what we should do, because as Representative Hagan pointed out, not every committee member participated in the final vote last time. And in addition, the composition of the committee, as I noted, is very different. And I feel like it's too early, because we've literally had no committee discussion of this bill yet. It's too early to make that decision. I think that we do have a really clear idea based on the public hearing and the contributions of Judith Meyer and Christine Thibault today, kind of what the policy issues are. And I think that we need to discuss them and come up with direction that we're going to take. I also am cognizant of the fact that we've been meeting for quite a while and would like to know if the committee wishes to conduct a discussion of this bill for a little bit and then decide our path forward before taking a break. Is that okay with everyone? Okay, I think it would be good for us to have a round of discussion before we take a break because it's all so fresh. And Representative Moriarty, I'll turn to you since your hand is up, can initiate our discussion. And Judith Meyer, I'm going to return you to the attendee space where you can, and oh, does somebody have a question for Judith Meyer before we send her? Okay, go ahead, Representative. Well, first of all, Representative Moriarty, do you have a question for Judith Meyer?
No, I don't. No.
Okay.
No.
Representative Hagan, do you?
I do. Thank you very much. I just have one last question. My wife, of all people, calls me just before I talk almost every time. It's this weird thing. I was really interested in Judith Meyer, your thoughts on the 30-day thing, and I thought Senator Kime may have asked the question, but my phone went crazy and I missed it. Could you explain why you don't like the 30-day thing? That's all I have.
And I'll just explain it briefly, but it was in the context of the arson fires in Lewiston. The 12-year-olds were charged, made their first appearance very quickly after that. The attorney for one of the boys almost immediately filed a motion to dismiss the case because LPD or Lewiston PD did not Mirandize the child. And that case was then fast-tracked to hearing. Within that 30-day period, there was a lot of court procedures that went on that we would not have had access to. Plus, the child was 12, so we would have had to ask the court to give us access to it anyway and wait for the court to issue that order. And sometimes it is a very long, it can be a months-long wait, in which case that child would have been charged, prosecuted, the case dismissed, and we wouldn't have reported a thing on it. And nobody would have known what LPD did.
Thank you. Any final questions for Judith Meyer or Christopher Parr before we return them to the attendee space? Not seeing any. And while I do that, Representative Moriarty, you can initiate our discussion. And again, Judith Meyer and Christopher Parr, thank you so much for being here today.
Thank you very much.
Okay, well, thank you, Madam Chair. I think that Christine Thibault's statement that this bill was dense was one of the great understatements of the session. The one key difference, well, two key differences between this summer and last. One, this summer is going to be a much healthier environment, it would appear. Secondly, there will be no election of a new legislature this fall, and therefore we won't be dealing with a newly constituted committee in the second session of the 130th. So I'm asking, Madam Chair, where we stand in terms of our allotment of holdover bills at this point.
I think we probably have used them all up plus one, perhaps.
Okay. Okay.
But let's talk about the merits before we jump ahead to that, because I don't.
Okay.
I mean, I agree with you that it is a dense bill, but it's also a really important issue for us to address. And I'd like to see if how the other committee members feel about it. Please resume your advocacy for a carryover once we've heard from folks.
I will.
And we've heard from Representative Evangelos and Hagan, I think, how you feel about the bill. Do you mind if we hear from some other committee members first?
I've only got a one-liner.
Oh, go ahead, Representative.
I agree with Representative Moriarty.
Thank you. Representative Hagan, did you have a one-liner that you wish to offer as well?
Well, I like a lot of the bill. There are things that I don't like on it. I probably would vote against it today, and I would be kind of sad. I would like to have more time to fix this thing and bring the media in and work together. But I understand also that we have 10 million bills to deal with, and we have session next week and all of that. So, you know, heavy is the head that wears the crown. Good luck.
It is a team effort and we are all a team. So could other committee members please raise your hand and express how you're feeling about this proposal? Go ahead, Representative Harnett.
Thank you, Madam Chair. I think I'm going to assume like everyone on the committee, this is a very important bill. I think we have to do something to recognize that young people whose brains are not fully developed make bad choices sometimes, some very bad choices sometimes. But as a society, I don't think we can impose what are basically life sentences on those individuals who make those choices without having reached full maturity. So we have to do something about protecting these records, making them confidential. And now we know that confidential means confidential for 75 years, which was news to me. But like Representative Evangelos expressed, the freedom of the press is a very important right in our country. And having chaired the Right to Know Advisory Committee for 2 years, we do spend a lot of our time, and we're going to do it again this afternoon, finding more records to be made confidential, which is necessary at times, but every time we do that, it makes government a little less transparent. I support so many of the proposals in the bill, and dense doesn't do it justice. I mean, there's a lot here to unpack, but I am concerned when we had a group of stakeholders that represented, well, one interest that represented the press in different forms of media, that all of a sudden was not involved anymore. And that's problematic to me. I'm also cognizant of the date on the calendar and the time of day, and the amount of work that we have as a committee to get through by this Friday. I'm not sure how I can get through this bill at this time, honoring the good work that's been done on the bill, but also listening to the concerns of the media, which is such a critical part of our system of government. They are in another check and balance against what we do. So I'm not offering a path forward as much as an expression of concern. I wish I could do better.
Thank you, Co-Chair. Representative Recca, go ahead.
Well, as most of you have unfortunately had to learn, although I've been on this committee for 5 years, I am definitely not an attorney. And so this bill, of course, is very dense to me as well. But I also share the concerns of most of you, I think, about the whole issue of juveniles and when and if they should be prosecuted and what, in fact, should be kept in way of, or exposed in way of damaging information. I also look at who put this piece together, and it has a parcel of people I trust on it, I have to say. And so I have a relatively high degree of trust that they did what was right to the extent of they could. But I also understand what others have said and thought, and the concerns of the media. And I think that probably was a rather major mistake not to have them at the table. So I don't know. What I don't want to do is postpone this or carry it over and have them have to start this whole blessed thing again. I mean, there are human limits to what you should be called upon to do. So I don't know whether or not there is a simple fix on the media issue. If there is, then I'd be happy to hear it, and I would be quite supportive of the bill as a whole. But I'm not ready to say that just because I don't want them excluded, and I don't understand every nook and cranny of this bill. And I trust those of you who are lawyers to look at the nooks and crannies of this bill and tell me if there's something I should be paying attention to. So other than with my non-lawyer brain. So that's all I got to say, I think.
Thank you, Representative. Representative Babbage?
Thank you, Madam Chair. I very much appreciate the stakeholders' work on this, and I think they did great work and brought it forth, honestly, and expressing themselves to us very responsibly as far as answering our questions and so forth. So I appreciate that. If I were given this amendment or the bill as presented with, I guess there are 4 things I would entertain as amendments. I would approve a 14-day period, which is 14 days more than they have today. I would approve auto sealing of Class B and below, which is more than they do today. I would approve public access to competency orders, and I would add the Title V provision that preserves history by making it accessible to public scrutiny after 75 years. That is from a person who has only examined this for a number of hours. Not a considerable number of hours when you consider the 129th and the number of times we've done this, but I'm not a stakeholder. And so I'm exploring consequences too. So if this were given more time and people who know more than I came up with these recommendations, I would feel better about it. But that's where I am. Thank you, Madam Chair.
Thank you. Senator Keim?
Thank you. Yeah, I am leaning towards sort of what Representative Babbage said. I mean, when you ask how we move forward, I'm thinking we don't have to do this whole thing. So this whole thing is ideal in the eyes of the stakeholder group, mostly, although I would say Christine Thibault did say this is a big policy decision, and not necessarily stating that this absolutely had to be done, but if we're going to do it well. So I'm wondering why shouldn't our committee, I prefer not to hold it over. I feel, but I have also heard this before, but why, if we consider doing the parts that we're comfortable with and then telling them, let's see how this works and then add more, because it's so much harder to ratchet it back and say, okay, now we're going to make these public and they used to be confidential. It's a lot easier to go incrementally, I think, towards confidentiality. And we don't have excessive numbers of cases in front of us where children have been harmed, juveniles have been harmed by access. And there are some really good parts here that I think everybody can get on board with. It does give the courts a lot more decision making. And so that's one part that's just really good. And so I don't know, what if the committee just considered, hey, let's do the parts that we think are good, leave the rest off, and let them come back another year and work those out, because I think they still take time and it's competing interests. They're not, she said an unhappy compromise, and I think that definitely was telling, but it doesn't mean we have to be all or nothing. We could just pick the parts we like.
Mm-hmm. Thank you. So this is what I'm thinking, and I just want to run an idea by the committee. A couple of different things. One is that Jill Ward is the person who could have answered the question about what other states are doing, and she had to leave. She is back in the attendee part of the meeting. So one suggestion would be to have her join us, to have her speak to that issue, and then for us to table this with the potential to take it up, because we've just been referred the errors bill. And so our committee will have to meet again at some point. We're actually meeting on Tuesday for a confirmation hearing, but we'll also have to meet on the errors record and if the errors bill. And so if we could table this, not decide today whether it's a carryover, see what progress can be made between now and when we meet on the errors bill, and then make a decision at that time. Does that seem like a good process to committee members? I'm seeing a few nodding heads. Is there anybody who thinks that that is not a good process? Go ahead, Senator Keim.
I think it's a good process. I just wanted to add into that we asked the courts the idea of keeping the name confidential and just have that little bit of feedback. And I don't mean confidential forever. I just meant in that 14 or 30-day window, if we were considering that, what does it look like to allow a little more of the information to be shared, but not the name? Just if the courts could give us an opinion, I think that would be helpful.
Thank you. Co-chair?
Thank you, Madam Chair. I support that approach. I would, and you may have said this was going to happen, I would like to hear from Jill Ward in advance of a tabling motion, just to have that information for us to consider before we meet again.
Okay.
On this, I mean, we're going to be meeting again, but before we meet again on this particular bill.
Okay. So I see two more hands up. If at this point, the plan would be to hear from Jill Ward and then table. So if you would like to be heard before we do those two things, just let me know. Representative Moriarty, did you want to be heard before we do that? For some reason, we're not able to hear you. Hang on. Nope. Let me see if there's something I can do.
Something happened. Sorry. I was going to say that this, I think, is a situation that cries for resolution by the stakeholders. It would take me and presumably many others on the committee a long time to acquire the level of knowledge and expertise that people like Christine and Judith and Chris have. That's not going to happen between now and mid-June. And I'm not sure that I agree with Senator Keim's position that we vote on the parts that we like and save the rest for later on, because I think we end up with a hodgepodge. And I don't think that in this case, half a loaf would be better than none. So I'd like to hear what the other states are doing. I'm not sure it's a deal breaker or a deal maker for me, one way or the other, but it's useful information. And maybe once we've shaken off our 3-hour experience here, we'll have clearer minds next week. So I'm happy with your suggestion.
Thank you. Representative Babbage, is your hand residual or new? And Representative,
I'm sorry, Madam Chair.
Representative Harnett, your hand is up? Oh, okay. And so we've been joined by Jill Ward. And Jill Ward, I want to welcome you back to the Judiciary Committee. And I was wondering if you could please comment on the question that had been asked about how this proposal lines up with the approach that other states are taking. And then if you could share any reflections you have on our concerns about the media not being included in this proposal.
Yes, thank you, Senator Carney and members of the committee. So I can provide a short summary of what other state jurisdictions are doing around confidentiality of records. I will say that this is very much in line with what other states do and actually is more on the modest side with respect to confidentiality around juvenile case records during that sort of stage of the process. Generally speaking, because juvenile systems have rehabilitation as its primary purpose, There are largely presumptions of confidentiality during the court process with juveniles. And there are different rubrics like the one you're looking at now that allow for public access, media access, school access, different kinds of access, depending upon offense level, whether it's, a third or fourth offense. So states come up with exceptions to a general confidentiality presumption. So this rubric that Christine has done a very excellent job presenting to you all is very much in line with the policy underpinnings of adolescent development, the purpose of the juvenile code and the juvenile system generally. And it puts Maine pretty much right in the middle as far as I would say, and I can give you a Department of Justice summary of state laws around confidentiality that demonstrate, again, each jurisdiction is different and they come up with different exceptions for different reasons, for different categories of people. There is a general presumption to keep them offline, which this codifies, which is great. And that is not where the sort of focus of this conversation has been, but with respect to then that in-person inspection access for the public and press, this rubric is very much in line, sort of the presumption of confidentiality for lower levels with the ability to petition access, and then the presumption of public access with the higher level offenses, and then with the 13-year-old competency question, which is a policy question, sort of fit in around the 30-day piece. I think that may be kind of unique to Maine, but it is trying to address an adolescent development purpose, along with not having defense attorneys file automatically competency motions in court because they want to determine that before things proceed. So there's also sort of a court expediency thing along with that when you know you're dealing with much younger offenders. So those are sort of my general policy responses to the questions. I think, and I apologize, kids are home today, so I had to step away earlier for about 30 minutes for my 11-year-old, but I'm happy to answer any other questions along those lines.
I did have two quick follow-up questions. One, if you could forward that summary to us, I think that would be helpful.
Yes.
But the second is, if we did nothing this session and had no legislation going into effect on January 1, 2022, what would be the status of electronic access to these juvenile records, given the new e-court system? Do you know what that would be?
Yeah, part of the reason we tried to come to consensus and move this legislation forward was to work in conjunction with Rule 6, which the judiciary has put forward, and they have already established a presumption of online confidentiality for juvenile records. And what we were trying to do was have the code come up to date with the rule and the technology and have them work together and try to do it all at the same time so that there could be clear training for judges and clerks, and which is why we've worked really closely with the judiciary to get their feedback on language so they can be prepping their people. This rubric makes the confidentiality norms stronger because we established this rubric, but it seemed like an appropriate time to do it as we as a state were making clear online versus public versus confidential. So I do think there's a moment here where we could do things efficiently from that implementation standpoint, but it's not, I'm not one to say that we couldn't come back next session but there was an emergency expediency thing to it because we were trying to make all things work together, and the juvenile records code in this area had not been updated for a very long time. So.
Okay, thank you. And then do you have any, you've, I think, maybe heard some of the dialogue about the negotiations that happened with regard to the bill in the 129?
Yeah.
Is there anything that you could share with us?
Yeah, as the convener of the work group, I just feel like I want to say that it was not clear to me, at least, that we had consensus last session. The last sort of opinion I had heard from Judith Meyer was still one of concern. And so if it turned into begrudging consensus during COVID, that was not clear to me directly. Again, that may have been communicated to other members of the work group. So there was not an intention, but my presumption was we had not actually reached consensus. So we were convening around the same bill, 1964, as we had done prior. And the new provisions were added in part with discussion with the sponsor and other concerns that were raised to come up with, again, the policy proposal with the 30 days and some of the penalties, so that the actual changes in law had some sort of enforcement mechanism. And those were new things that arose in conversations afterwards. But certainly if we are very open to including anybody in these conversations. I really honestly, and if it was my mistake, I will own it. But my understanding at the end was we had not actually reached consensus. But again, it was COVID, it was August. The process was not exactly, completely transparent based on what was going on with the pandemic. So as the person who convenes this table, I'm very much open to including Judy in future conversations and seeing where we land. So I just really wanted to be clear about that.
Yeah, thank you. I think the committee is pretty clear that we would really like there to be some more work on this. I think I've heard that from a lot of folks. Thank you very much.
You're welcome.
Jill Ward. And committee members, at this time, I think it would be, we have a lot of work ahead of us, and it seems pretty clear that we are in a place where we're going to table this and see if more work can be done this session. And if not, consider whether it's possible to carry this over. And so with that, I would entertain a motion to table. Representative Babbage?
Yes.
Sorry, Representative Babbage had his hand up. Go ahead.
Thank you. May I precede the motion to table with a quick one-sentence answer from Ms. Ward on something she brought up?
Go ahead.
Thank you so much, Madam Chair. Ms. Ward, you mentioned about the time period that we're talking 14 or 30 or whatever. You wanted to have enough time so that a motion, there wouldn't be an automatic competency motion. I find that reasonable. How late in the process do competency motions usually, or can they be made? I mean, there is no limit, right? I mean,
let's let her, Representative, let's let her answer that question, because
thank you.
we can move on with our afternoon's work. Go ahead.
No, I think the idea of having the time was so that it wasn't an automatic course of practice for a defense attorney, because they wanted to have the time to make that assessment. But no, it could come later, but you'd want to do it right away, because if you determined the juvenile was not competent, they shouldn't even be part of the proceeding to begin with. I mean, then that takes them out of the whole thing entirely.
Thank you very much. That's what I wanted to know. And Madam Chair, I move to table.
And is there a second? Seconded by Senator Keim. And I think, Jill Ward, thank you so much for returning to the meeting today and for providing that information. I'm going to return you to the attendee space. And committee members, we're going to vote on the tabling motion. And I had forgotten that when we raise our electronic hands to vote, the members of the public who are watching on YouTube cannot see our electronic hands. So I'm going to ask those who are in favor of the tabling motion to please raise your actual physical hands so that it is apparent to members of the public who are watching us on YouTube.
Counting 10.
Okay. And those opposed to the tabling motion?
Sorry, I just didn't raise my hand, but meant to.
11.
I was surprised because you had seconded the motion and I could not figure out what was going on. Thank you. All right. And so with that, LD 1676 is tabled for some additional work. We will close the work session on 1676. We have quite a bit to do this afternoon. As we know, we're busy heading toward the close of our work. And so I would like to give committee members a little break, and then we'll return for FOA reviews and And then for the work on the indigent legal services bills, and then our afternoon work sessions. Peggy and Soupy, how much time would you like by way of a break?
I did let the two committee analysts know about the freedom of access reviews that we could probably start at 1:30 instead of 1. And I think they might actually be in the room now, the attendee room now. Anyway, 1:30 is fine for me. I appreciate that, but I'm not the one who's on the hot seat. All of you are. So whatever works for you. Thank you.
Soupy, is that?
I'm absolutely fine. I'm fine. Thank you.
All right. Committee members, would you prefer 15 minutes or half an hour for a break?
Half an hour or more.
Half an hour? Okay. So let's resume at 1:45, if that's okay with everybody. Thank you all very much. Don't forget to deactivate audio and video, and see you at 1:45.
Okay, very good.
Representative Babbage, you get the award for being the most prompt.
I was laughing.
I could see your smiling face. Oh. So Representative Harnett, co-chair, I was kind of assuming that we would do the right to know reviews first when we resume and then move on to the work sessions. Was that what you were anticipating as well?
I have learned not to anticipate anything anymore, so that's just fine though. We had these scheduled, so it probably makes sense to allow the folks from the other committees to get out of here. So that's fine.
And does that work out okay for you?
It does. It does.
Thank you.
At some point, I still have to go to labor and housing, but that looks like it's going to be later. So I should be able to get through the three legal services bills, indigent legal services bills.
Oh, great. Okay, so let's resume and we'll do the FOA reviews, and then we'll jump back onto our regular schedule and do the bills that are still left from this morning. And so I'll just turn the virtual gavel over to you. Okay.
And let me just ask Peggy a question. Were we doing 1458 first? Did you have a?
1458 is last year's bill. Yeah, I think it's 857.
Oh, yes. I'm sorry, 875.
Yes. 875, there you go. Yes, that one, we had agreed to do state and local government first.
Okay, so I will remind have we moved over the folks from state and local?
We haven't yet. I can try to do that. Senator Baldacci is here, and Lynn Caswell, my colleague, is here.
Thank you. I'll wait till they arrive and then I will welcome them. Welcome, Senator Baldacci. How are you?
Good. How are you doing, Representative Harnett? Let me just try to get my video going here.
Sure. I am doing
Thank you, Mr. Chairman, for allowing us to come over.
Thank you. And welcome, Lynn, to Judiciary again. And just to remind committee members, we are doing a freedom of access exceptions analysis, which is something we do every time another committee of jurisdiction creates a new exception to the freedom of access laws. They come to us with their explanation as to why it needs to be done, and we review it and provide our advice. We don't have the authority to reject what they do, but we always try to find common ground wherever possible. And this is a bill actually that we had before us last year. It died of COVID. It was LD 1458 at that time, and right now it is LD 875. So I will turn it over to Baldacci and Ms. Caswell to provide their analysis under the exceptions law.
Okay, thank you. Just briefly, I would indicate Lynn has provided a memo to the Judiciary Committee that I'm assuming that you folks have. Most of the exceptions having to do with the critical functions of the bill, which is to ensure both a competitive process is maintained and to accommodate the goals of the bill, which is to encourage American manufacturers as well as, encourage, that was a different bill. I apologize. To encourage the ability to have the contract costs evaluated fairly. I would ask Lynn, I was thinking of a totally different bill, Lynn, but why don't you go ahead and provide the analysis?
Thank you, Senator Baldacci. So LD 875 has 5
FOA exceptions, Freedom of Access Act exceptions. This is a bill to establish a process that state agencies must follow if they are seeking to privatize services that the agency is now providing. And so this will involve a competitive bid process. And 3 of the exceptions are time-limited exceptions that expire when the competitive bid process is over. So a day after the competitive bids are due. The 3 exceptions that are time-limited apply to the state agency has to determine their cost to provide these services they're seeking to privatize. Their calculation of cost is protected from disclosure to make sure that the competitive bid process is truly competitive. The second item is that the collective bargaining organizations for the employees whose jobs may be lost can then submit a bid to provide the services. So that's protected until after the bid process is over. The organization can also propose an amendment to the collective bargaining agreement in hopes that the amendment would lower the cost to the agency and therefore the agency would not be able to privatize. So 3 time-limited exceptions. The other 2 exceptions, there is one exception that the name, address, and social security number of the employees of the contractor who is awarded the bid is kept confidential. So if you're awarded a bid under this law, you must on a quarterly basis tell the state agency the salary you pay each individual employee, and you must include the name, address, social security number. And I will stop and say that this bill language, both in the 129th and this session, was created through the work of the Department of Administrative and Financial Services, the main state employee union, and the Office of the Attorney General. So that segues me to the 5th exception, which is the Office of the Attorney General has the ability under this bill to conduct an investigation of the state agency's process to privatizing, and the Attorney General's office under this exception, any documents they collect that are otherwise confidential and any information disclosed to them by state employees are considered confidential, and the purpose of that is to protect the integrity of an Attorney General investigation.
Thank
so those
you.
are the 5 exceptions.
Thank you very much, Ms. Caswell. And committee members, those of you who've been here in prior sessions, and we've done a few of these reviews this session, remember that I go through a matrix. We go through a series of questions, and I am going to provide that analysis. I'm going to try to do it quickly because we have so much on our plate, and we have 5 exceptions on this one particular bill. And I'm going to start with the agency cost estimate. The first question I need to ask is does the record need to be collected? And that's a conclusion that the Committee of Jurisdiction reaches, and they've reached it on all 5 of these. So I'm going to skip that when I go over the next 4. Then I ask, is there a value to the agency or the public in maintaining the record? And this is for the agency cost estimate. The maintenance of this information is essential for DAFs and the public agency overseeing the privatization contract to perform their duties. I then turn to find out if the proposed exception meets one or more of the following 5 criteria on my matrix. And I have found that it meets 2 of those. The first is paragraph E, which is whether public disclosure puts a business at a competitive disadvantage, and if so, whether that business interest substantially outweighs the public interest in the disclosure of the records. If the agency cost estimate is made public prior to the due date for the bids, the competitive nature of the bid process will be diminished, and it could influence and benefit the private entities making those bids if they knew what the dollar amounts were. The other exception that applies is that the public disclosure compromises the position of a public body in negotiations, and that public body's interest substantially outweighs the public interest in the disclosure of the information. In this exception, Public disclosure of the agency estimate before the sealed bids are received might compromise negotiation between the state agency seeking to privatize the state services and the employee organization or union representing those state employees who may be displaced or terminated from their jobs. And then I need to ask, is the proposed exception as narrowly tailored as possible? And as Ms. Caswell pointed out, this and some of the other exceptions are time limited. As soon as the competitive bid process is concluded, those records are made public, so only confidential for a short period of time. So I believe that the agency cost estimate exception meets our criteria. With respect to the collective bargaining agreement amendment, there is value to the agency or official in the public in maintaining this record. Again, it's because DAFs and the public agency overseeing the privatization contract need this exception to perform their duties. Public disclosure and the two exceptions that apply here are again E and F. Public disclosure puts a business at a competitive disadvantage, and that business's interest substantially outweighs the public interest in disclosure. If the terms of the collective bargaining agreement negotiated by the employees becomes public record prior to the due dates for the bids, again, the competitive nature of the bid process will be diminished because the private parties would have additional confidential information on which to base their bids. The other exception that applies is the public disclosure compromises the position of a public body in negotiations, and that public body's interest substantially outweighs the public interest in the disclosure of the public records. Here, the public disclosure of collective bargaining agreement amendments before the sealed bids are received could compromise negotiations between the state agency seeking to privatize state services and the employee organization or union representing the state employees who may be displaced or terminated. And again, this is time limited. Once the competitive bid process is over and a contract is or is not awarded, all of the records are made public. The third exception deals with the employee organization making a bid on the services. Again, the record needs to be collected for the bid process under Title V, Chapter 155. And again, the value in this exception is maintenance of this information in a confidential fashion for DAFs and the public agency overseeing the privatization contract are necessary to perform their duties. And the same two paragraphs E and F apply again. Public disclosure would put the business at a competitive disadvantage. That's because if the terms of an employee's organization bid is a public record prior to the due date for the other bids, the competitive nature of the process would be placed out of balance, and those making bids would have additional information which could influence the outcome of the process. And again, this is another time-limited one. Once the competitive bid process is over, the records are public and available to any member of the public. The fourth exception has to do with if a contract is awarded to a private entity to provide what were otherwise state services in the past, they need to reveal certain payroll records to make sure that they are complying with the terms of the agreement and complying with the bid that they put in. All this exception does is it makes the names, addresses, and social security numbers of those employees receiving payment from the private entity confidential. All of the aggregate information is provided. The only thing that is deleted is the personally identifying information, which again includes social security numbers. This one is not time limited, but it only applies to narrowly defined personal information. And then the fifth and final one, as explained by Ms. Caswell, is the Office of the Attorney General investigation. The Attorney General's office has to determine what information is necessary if it investigates whether a state agency followed the requirements of the state law. And there is value to this being made confidential because it provides employees with the assurance that information that they provide to the Attorney General's office as part of that investigation will not be shared with others, including their employer. This exception is intended to increase the likelihood the investigator will receive complete and accurate information from state employees, and that's necessary to carry out the public's interest in making sure state law is complied with. The proposed exception as narrowly tailored as possible. This exception applies only to a record in the possession of the Office of the Attorney General that was obtained during an investigation pursuant to the law. This exception does not render the record confidential if it becomes in the possession or custody of another state agency or public official of the state. So again, my recommendation to the committee is to approve these exceptions to the Freedom of Access Act for the reasons that I just stated on all 5 and for the thorough analysis provided by analyst Lynn Caswell. So with that, I would entertain a motion to recommend to the Committee of Jurisdiction that their Freedom of Access requests for exceptions are appropriate. Representative Evangelos?
I vote ought to pass on the recommendations of the chair. Thank you.
Thank you, Representative Evangelos. Do I have a second?
Second.
Seconded by Representative Moriarty. Is there any discussion? Seeing no hands, blue or otherwise, I would ask Ms. Panett to please call the roll on the motion to accept the recommended exceptions to the Freedom of Access Act.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Senator Keim is absent. Representative Cardone. Representative Cardone is absent. Mr. Chair, 11 members voted in the affirmative, 0 in the negative, and 3 are absent.
Thank you very much, Ms. Panett, and thank you, colleagues on the Judiciary Committee. And thank you, Senator Baldacci, for bringing these exceptions to our attention. Best of luck with the bill, and additional thanks to analyst Lynn Caswell for her thorough work in presenting this to our committee. Thank you.
Thank you, Mr.
Thank
Chairman.
you.
Thank you, members of the committee.
And I believe the next bill that we have is regarding LD 1718, an act to establish the Accidental Drug Overdose Death Review Panel. And I would ask that whoever is representing the Joint Standing Committee on Health and Human Services to be moved over as a panelist along with their analyst to present the bill. Welcome, Senator Claxton, back to the Judiciary Committee. How are you this afternoon?
Thank you, Mr. Chair. I'm fine. How are you?
I'm doing okay, thank you. If you could just activate your video and your mic is activated. Welcome back to the committee.
Thank you very much. This is a revisit on a bill that you voted on and considered in the last session. It's LD 1718 in the current session. Prior to that, it was LD 2153 in the 129th. You all convened in some manner in July and worked this bill in 2020. I'm not sure what the outcome of that was, but this is exactly the same wording and bill as you previously have seen. We're looking for a FOA exemption related to an accidental drug overdose death review panel that would empower the Attorney General to release only conclusions and not specifics of individual cases, HIPAA information, or particular circumstances. The intent is to learn, as we do from many other panels, if there are opportunities to improve our laws, our processes, our policies.
Thank you very much, Senator Claxton. Indeed, this was before us in the 129th, and I believe that it was approved after circulation of a memo by me to the committee members because we were unable to meet in person at that particular time. And as the good senator pointed out, this review panel is very similar to other review panels we have run out of the Office of the Attorney General, including the Domestic Abuse Homicide Panel, the Maternal, Fetal, and Infant Mortality Review Panel, Child Death and Serious Injury Review Panel, and the main Elderly Death Analysis Team. And again, I will run through the matrix and point out that the only thing that is being kept confidential here is personally identifying information, mostly about people who have lost their lives to a drug overdose. And again, whether the record needs to be collected and protected, that was the conclusion of the committee. And the value to the state and the agency in maintaining this record is that, as we all know, we are in the midst of an opioid crisis. This panel will be allowed to perform the analysis of deaths, other accidental overdoses needed to develop policies to combat that crisis that we find ourselves in. Unlike the prior analysis that I just did, one of the questions that we ask always is whether federal law requires the record to be confidential, and just about all of the information being kept confidential here, names, addresses, identifying information of the deceased, are records that are confidential under the federal HIPAA laws. I then look at the proposed exception to see if it meets one of the 5 criteria in our matrix. And the first one I look at here is paragraph D, which asks whether the proposed exception protects an individual's privacy interest, and if so, whether that interest substantially outweighs the public interest in disclosure. Again, here, the only thing that we are protecting is personally identifiable information related to persons who have lost their lives or suffered injury from an overdose. I will note that criminal records, if they exist, relating to any of these incidents are still public and available to the public. The next criteria that I believe applies here is paragraph G, and that is whether public disclosure jeopardizes the safety of a member of the public or the public in general, and if so, whether the safety interest substantially outweighs the public interest in the disclosure of the records. And here, public safety is actually enhanced by allowing the committee, the panel, to do this analysis and present its recommendations without making, again, personally identifiable information available to the public. And the most important question often is whether the proposed exception is as narrowly tailored as possible. And I believe the answer to this is yes, because most importantly, it allows the panel to release all of their conclusions, and their conclusions are made public and are accessible to all. And again, all that it does is keep personal information confidential. So based on Senator Claxton's comments and my analysis, I would entertain a motion to approve have the Judiciary Committee approve the exception requested by Health and Human Services. So I would entertain a motion. Representative Moriarty makes the motion. Do I have a second? Representative Evangelos, second. Is there any discussion? And again, the motion is to express our approval of the exception created in LD 1718 related to an act to establish the accidental drug overdose Death Review Panel, and I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Cardone. Representative Cardone is absent. Mr. Chair, I have 12 members voting in the affirmative, 0 in the negative, and 2 are absent.
Thank you very much, Soupy. Thank you, colleagues on the Judiciary Committee. I know I ran through these pretty quickly, but we all see the list of bills we need to work this afternoon. So I thank you for bearing with me doing that. And I want to thank Senator Claxton and his analyst for their work on bringing this important bill forward and bringing it to our attention as it relates to the Freedom of Access Act. And
Thank you for the committee's consideration and for Anna's expertise at producing a letter like this.
And the analysis was great. I thank her very much.
Thank you.
Enjoy your afternoon. And with that, I will turn the proceedings back over to my Senate co-chair.
Thank you very much, Chair Harnett.
Unless, did you want me to run the next three? They were my bills, so I thought I should.
Yes, I've been off camera because I've been thinking about them. But
Okay.
yeah, if you run them, then I can share my thoughts with the committee as we go along. Thank you.
Okay. Okay, the first bill that we are working this afternoon is LD 1685, which I presented recently, an act to protect the constitutional rights of indigent defendants. And I would turn to our analyst, Peggy, to provide the overview of her bill analysis.
Right, so this bill has two main functions. It, if I remember correctly, and I don't have a copy of the bill in front of me. It transfers the screen. So two of the recommendations from the Sixth Amendment Center, and David Carroll is here if you want to question him about any pieces of it. But two of the recommendations were to move the financial screeners out of the Maine Commission of Indigent Legal Services because of the conflict of interest presented, that they are not only identifying needs, the commission, under the auspices of the commission, there's a determination of whether or not the defendant is indigent, and also try to collect any kind of partial payments. And that is seen as kind of a conflict of interest, with the commission also providing attorneys that represent the defendant. So that is what section 1 of the bill does. It moves the screeners all to the judicial branch and then adds to their duties to include screening or for determinations of indigency for other purposes that the judicial branch would use them for. Section 2 and section 3 are also amended based on that, and section 4 to move all those functions, all those financial screening, all those following up. Did somebody's circumstances change so they now actually can pay for some or all of their counsel? All of that would be deleted from MCILS and moved to the judicial branch. Section 5 is a completely different issue, and that is the issue about prosecutors having communications with uncounseled defendants before the defendants have been able to knowingly, voluntarily, and intelligently waive their right to counsel. They don't have to have counsel, but they have to have knowingly waived that right to counsel before the prosecutors are supposed to have a conversation with them. And you heard District Attorney Sarbeck talk about their programs where they actually do reach out to defendants. And Tina Netto from the criminal defense lawyers said, well, maybe you can do this in a different way. But one of the things that the district attorney's office did was they checked with bar counsel to make sure that their communications with defendants was not violating the ethics rules. And what we had discovered a couple of years ago in working with this issue is that the main rules of professional conduct do not actually track the ABA model rules of professional conduct. And I've included those in the bill analysis, so you can see that the ABA model rules actually do prohibit contact between the prosecutor and the defendants. And when the main rules of professional conduct were adopted, those were specifically not adopted because whichever committee was working on this thought it wasn't necessary in Maine. So although in another state, maybe that process would have been in violation of the bar rules, it was not in violation of the bar rules. And, you know, the district attorney's office made sure of that before they went forward. And then with that said, there was, you know, some discussion at the public hearing about could that second piece be addressed a different way. And Tina Netto and Jonathan Sarbeck worked together, and I'm not sure who else was involved in putting together an amendment. And I think I sent that out. I sure hope I did.
If I could just interrupt, the amendment was put together with the bill sponsor, myself, Ms. Netto, District Attorney Sarbeck, and also ran it by Josh Tardy of the Commission on Indigent Legal Services as well.
And I'm seeing that because I did not save it as a PDF, I might not have shared that with you. Is that correct?
I don't have it.
You don't have it.
I received it this morning in an email as a Word document.
Yeah, but I don't think I sent it to the whole committee.
Okay.
So I can send that to the whole committee and I can share it on my screen if you would like.
That would be great. And this was to protect, was to allow diversion, pre-charge diversion programs to continue. They've been very successful. District Attorney Sarbeck mentioned that he's had over 200 cases where all potential defendants have completed those successfully, resulting in no criminal charges and no records. And he did not want to lose the ability to continue that program. And you'll see in the amendment how we addressed that.
Okay, if you give me a second, I will send it to the, is it useful to send it to the portal too? Okay, almost there. Time to share my screen. Okay, so there were completely different issues talking about the first part of the bill about the screeners. But so this is just looking at, oh, actually, the way I drafted this, it removed the screeners too.
Well, I was going to ask you about that. That was not the intent, correct?
Yeah, okay, don't look at that.
Okay.
Amend the bill by striking out section 5. And whoops, my spelling is atrocious today. Okay, and we're going to replace it with this new section 5, which is this, what looks like section 1 is really everything that's in the bill. But I changed the format, so because we're going to make subsection 2 the exception. So here's the key language. A member of the district attorney's office may communicate with an unrepresented defendant if the purpose of that communication is for the district attorney's office to offer the defendant an opportunity to participate in an established pre-charge diversion program, so pre-charge, in which the successful completion of the program results in the district attorney's office not prosecuting the charge or charges against the defendant. So that would be an exception. They would not have to go through the either the video or any kind of discussion by the judge ahead of time, and they would not have to sign anything in writing that says I'm waiving my right to counsel. This would be an exception.
And this is all pre-charge.
Correct.
Correct. Are there questions from committee members for Peggy? Senator Carney.
Thank you. This, I think that the changes to section 5 are terrific. I just wanted to go back a little bit to sections 1 through 4, and I was multitasking, and I apologize if I missed something, but I thought that that the court was also concerned about having a conflict of interest. And I also know that based on some other legislation and the updates we've been receiving from the courts, that they are feeling very overwhelmed with doing any expansion of their role in light of the fact that they're expecting a flood of work following resumption of normal court operations.
I'm going to stop.
Oh, yes,
sharing,
please.
Right. Was that a question for me, Senator Carney?
Yeah, it was, and again, I apologize if I missed something earlier, but I thought that the court was not interested in taking this on.
They are not, and when this was proposed in the past, they said if you're expecting us to do this, and the bill actually does expand their duties a little bit, the screeners' duties, it wouldn't be a complete wash of just moving positions and the money. They identified maybe 1.5 or 2 more positions. So they identified costs that be involved in this. So in addition to the what they feel it's a slightly different conflict of interest because they're the neutral arbiter, and yet here they're the ones who are tracking people down. That there is an additional cost to it, as well as which I guess is related to the additional burden on the courts that this would place.
And am I correct, Peggy, that in your analysis, it was sort of agreed to by both MCILS and the court system that they both have a type of conflict, that there is a...
Well, I think that that it was pointed out that Mr. Carroll had said that, yes, you're right, there is a conflict. Everybody has a conflict with the screeners.
And that ideally, it would be there might be a neutral agency down the road that would be doing this work, but we're not in a position to do that right now. Am I correct about that? In your analysis of 5?
Right. My understanding is the courts aren't ready to take this on, or right, and they're not really interested in taking it back.
Yeah, and so I was just wondering why we're not just for the amendment just removing all of 1 through 4.
Well, maybe that's why Peggy drafted it that way in the first place, because she was guessing her amendments.
The conflict of interest is different though, isn't it?
It is.
One is a financial conflict of interest and one is not.
Representative Evangelos.
Thank you, Mr. Chair. I read the amendment last week and I liked it, and then I still like the objective of it, but something just crossed my mind. I wanted to run by you as a lawyer too. As far as the waiving your right to counsel. So you're in there seeing the DA, and we have seen nothing but high caliber and honorable district attorneys come before us. So I don't want my concern being misconstrued. But all it takes is one deputy county prosecutor. So you're in there and, you do the program. We're not going to charge you. Everything's going to be good. But, I really need that information about that other person. So I'm wondering in those instances, then right when that conversation occurs, that person needs the counsel. Because we don't want those kind of deals being cut as part of this exception. You understand what I'm getting at?
I do, and my understanding from District Attorney Sarbeck, and I talked about this with the representative from Macdel as well, that this is simply a referral to a pre-diversion, a pre-charge diversion program, sometimes restorative justice, sometimes something else, but where none of the information developed during that process is turned over to the district attorney's office at all. It's just a referral. And if the person successfully completes it, then there are no charges filed and no criminal record.
I see. So there's no face-to-face meeting with the prosecutor then?
That was my understanding from District Attorney Sarbeck, and I don't believe he is here. I know Ms. Neto is here, and I know Mr. Carroll is here. Perhaps you want
it's just a paperwork function. I'm fine with it. But if there were these face-to-face meetings going on behind closed doors, then that's my concern. Thank you.
You're welcome. Are there additional questions, Senator Kime?
Thank you. Yes, I understand the courts. Well, a couple of comments. One is I understand the courts probably do feel overloaded, and switching the screeners now is maybe difficult. But for myself, I want to make that move, and I don't know if we delay implementation by a few months, but I think we're the ones that have captured and heard this. I really think we should make the move. And then the other thing I just wanted to double check is that even if someone can still waive their right to counsel and make a deal with the DA by signing some papers, right? That's still just a process. Am I right, Peggy?
So you're saying they could knowingly, intelligently, voluntarily waive their right to counsel and work with the DA on any, yeah. Yes. Right. I mean, right now, this would require that the court has to have provided all that information to the defendant before they can do that. And that's the court's responsibility. So somebody couldn't just walk into the DA's office and say, I'm ready to cut a deal.
That's what we're trying to prevent.
Right. Unless I had an attorney.
Right.
So what they'd have to do is make sure the court provided all that information about their rights before they sign the waiver. Right. But they could then sign the waiver and talk to the DA.
Yes, perfect. Thank you. I make a motion not to pass as amended.
Okay, we have a motion. Do I have a second? And I will still get to discussion. Now there are hands up. Seconded by Representative Moriarty, and your amendment is simply the change to section 5, but keeping in the
That is
20
correct. That is correct, yes.
process? And did you have a delayed effective date on that you wanted to put in?
Let's do that.
Yes, what does the committee think? 3 months, 6 months?
It's your motion.
How about 3 months?
Representative Moriarty, did you want to? You're muted, Steve. We can't hear you.
Yeah, this is not emergency, so we really have a built-in 3-month period anyway.
Okay, all right.
I believe.
So the motion on the table is ought to pass as amended, and the amendment being what is contained in section 5. Dealing with,
Do we want to make it January 1st of the following year?
Well, let's get the motion out and then we can have discussion and see if the mover and seconder want to consider something else. But I just want to be clear, the motion is ought to pass as amended, incorporating the amendment that was just described that Peggy shared with us regarding section 5 of the bill. Okay. And then I will go to questions, and I saw Representative Evangelos.
I have 2 areas I want to discuss as briefly as possible. The way things just got described a minute ago made it sound like to me that an uncounseled defendant is going to be negotiating with the DA without the presence of counsel. As I thought I heard Senator Keim say, you know, I want to cut a deal, or Peggy said it, I'm sorry, I want to cut a deal. I'm here to talk. You said that's the situation we're trying to prevent. Have we prevented it?
Yes, because we require the defendant has to be informed of his or her right to court-appointed counsel. And the court has provided to the defendant a statement of, and those are what are listed in the bill, substance of the charges against the defendant's right to retain counsel, to request the assignment of counsel, and to be allowed a reasonable time and opportunity to consult counsel before entering a plea, informed of the defendant's right to remain silent, and the defendant is not required to make a statement, and that any statement made by the defendant may be used against the defendant, the maximum possible sentence and any applicable mandatory minimum sentence, and the defendant's right to trial by jury. So no discussion can be had.
So we're not forcing them to have the lawyer. We're just giving them all these conditions so they're clear on when they waive it.
Informing them of their constitutional rights, the court informing them of their constitutional rights.
And very briefly, on this particular bill, you know, last week I had concerns about a narrative portion about a bill we're taking up. And I'm just wondering, I'm really concerned about the money bill, but I think the narrative language that appeared in 1687 perhaps should have gone in this bill, so we could just avoid that whole discussion. Have you given any thought to that?
Not at this point, maybe when we get to the next bill, but right now I just want to focus on the bill that we have in front of us and the motion that we have.
Right, but if we vote on this, is there a way to make that happen after we vote?
I don't know the answer to that question, but I think we will address some of the concerns you had about that bill when we get to that bill and the language in that bill.
Well, I'm concerned about the emergency, but we'll talk about it. Thanks.
Okay. Representative Babbage.
Yes, I appreciate, thank you, Mr. Chair. I appreciate Senator Keim's comments and also Representative Evangelos. The last time we talked about this bill, I asked that question about consultation or you know, the DA meeting with the defendant, I found the answer sort of unresolved. I mean, the question was, I think I was the one that said something along the lines of, so it could be done through paperwork rather than a face-to-face meeting. I didn't say those words, but that was the, so I'm not sure if we've totally, I mean, to strictly Mirandize the person isn't the kind of protection that I'm talking about. But I do think the screen is going to the judicial branch is a good thing. And right now, the motion stands that it will take effect when every other piece of legislation takes effect at the end of September. Is that correct?
That's my understanding. And this is not being Mirandized. This is a court explaining constitutional rights to a defendant after charges.
And the prohibited conduct is communication. There was, when we talked about this last year, there was a letter circulated that a district attorney's office was sending out to defendants about making some kind of agreement or talking about the charges that went out before that they had counsel or had been given the right to waive counsel. And so that was one of the things that this was trying to stop, was that a letter directly from the district attorney asking you to negotiate your charges is inappropriate. But what this new subsection 2 is, it's the communication is to offer the defendant an opportunity to participate in an established pre-charge diversion program. It's not even that the DA participates in that program. So that's why it's not, the communication is limited to the opportunity to participate in the program.
Thank you.
Yeah, which can be done on paper.
Is there additional discussion? Representative Moriarty.
Thank you, Mr. Chair. Just briefly, this is what I like about this amendment. First of all, the statement of rights comes from the court and not from the prosecution. Yes, it can be on paper, and probably, and it really should be on paper so that the person can sit down and digest it. Secondly, the defendant has the right to waive rights and to choose to speak with the prosecutor. We don't prohibit such communication across the board or comprehensively. Adults have the right to waive their rights, and this guarantees that. And where we're talking about participation in a program that frankly may lead to a good overall resolution, that ought to be encouraged.
Thank you, Representative. Representative Babbage, is that a residual hand?
That's a residual hand. Thank you.
But that's going to be your new nickname, you know. It's going to be Residual Hand Babbage.
Resid.
Is there any further discussion? We have a motion and a second. Seeing no hands, I would ask the committee clerk to call the roll.
Thank you, Mr. Chair. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckitt. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Cardone. Representative Cardone is absent. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Mr. Chair, 11 members voted in the affirmative, 1 in the negative, and 2 members are absent.
Thank you, Supi. And Senator Carney, is your report ought to pass with additional amendments?
My report is ought to pass as amended with just the new proposed language for section 5.
Okay, so striking out everything but the new section 5.
Yes.
Okay, thank you. And with that, I will close the work session on LD 1685. And turn to our next work and open the work session on LD 1686, an act to implement a geographically limited public defender office. And I will turn it over to Committee Clerk Peggy Reinsch for her bill analysis.
Great, thank you. So we tried very hard to name this something other than a pilot project because we didn't want people to think it was an experiment so much as a step to providing more public defender. That's the purpose, was to provide a public defender in more parts of the state eventually, but this was the step. The only statutory change is to section 1804 that allows the commission to directly employ attorneys to provide the legal services directly to the defendants or the people who qualify for indigent legal services. Right now, the commission can explore that idea, but they really have to enter into contracts. And so this makes it clear that those could be employees of the commission itself. And then it adds the money for a total of 17 positions each year of the biennium. So this, if you really wanted it to take place, to start on July 1st, we probably should add an emergency preamble. If you don't have an emergency preamble, then, oh, I'm sorry, it recognizes that it begins January 1st, 2021. Right. My mistake.
22.
So, right.
22.
Thank you. January 1st, 2022, which is half of the fiscal year 2021-22, which is why that number is lower than the full year of 22-23. And we can, Justin Andrews is in the attendee room if you want to talk to him about what those positions do. We had a nice chart a while back that we can talk about if you'd like.
Certainly, if we could move Interim Executive Director Andrus in as a panelist. Soupy, has he been moved over?
Here, I can get him.
Thanks.
My apologies for not jumping on that.
Welcome, Mr. Andrus, back to the Judiciary Committee.
Good afternoon.
Hi.
Hi. I hope you will all forgive me for not putting my jacket back on. There is no air conditioning where I am.
I understand it's pretty warm out there today.
Yes.
Peggy was wondering if you could just run through the positions that are contained in this initiative.
Yes. So, excuse me, I am having a computer moment while I try and get the list up in front of me. While I'm doing that, I'm going to be descriptive in the meantime. The positions are designed to provide management and line defenders to accept approximately 80% of the caseload in Kennebec County, together with the support staff to support them in that, including investigative functions that are today outsourced to contractor investigators. So that's the overview, and I'm very sorry. I'm generally better prepared for this, but I cannot get this to open. The public service manager positions 3 and 2 are the attorney positions, and then we step down through staff and investigators.
Thank you very much. Are there questions from committee members for Mr. Andrus or for Peggy? Representative Moriarty.
Thank you, Mr. Chair. So, Mr. Andrus, just want to confirm, if this passes, you'll be covering the district courts in Waterville and Augusta, as well as Superior Court in Augusta.
That's right. We think of it as the unified criminal docket because the actions that occur in district court courthouses on the criminal front are part of the unified criminal docket that is subsumed later, typically into the building at the Superior Court. And the reason I make that distinction is because child protective cases remain in the district court, and this office would not be addressing those cases.
Okay, okay. And clearly you're not including Somerset County as part of that same prosecutorial district. It's strictly the Kennebec County portion of that district.
That's correct. This initiative is designed to be limited to Kennebec County as a sort of discrete area in which to start. Yeah.
Good. Just wanted to verify. Thank you.
Mm-hmm.
Thank you, Representative Moriarty. Representative Evangelos.
Thank you, Mr. Chair. And Mr. Andrus, I just want to go back to when we were discussing the incubation of this idea, and I just want to make sure my memory's right. We were discussing a pilot project, and it was sort of an experiment, and if it was successful, something we could build on. And Kennebec County ended up being the site selected. Is that accurate?
It is. The only reason that I was not involved in using the word pilot at the outset of the first MCIS initiative, and we did certainly use that word. The reason I don't use it is because it suggests that it's a limited duration experiment of some kind, when the intent is that it be permanent. But yeah, in pilot in the sense of first, that's absolutely correct. And as part of that, the component of this bill that allows MCILS to hire attorney employees to provide direct client services is not specific necessarily to that pilot program, because we're already looking at places in the state where it may at some point in the relatively near future become necessary to employ attorneys outside of the pilot program. So,
and lastly, given the constitutional issues we're trying to repair, and given that many fine attorneys currently practice under the current system, including some of the best, given that this is our, well, I'll call it an experiment, maybe it's the wrong word, but I won't use pilot project again, but you know why the criminal defense attorneys weren't willing to give this a shot?
So I don't mean to quarrel again with the language, but I'm not sure they're all not willing to give it a shot. There are many criminal defense attorneys who are willing. So I can't speak to MACDL as a group. I certainly understand that change is difficult and threatening, and that for some people who perceive that there may be a loss in their business opportunity, there may be a fear about that. There are also probably people who feel like they are best suited to provide the excellent services they provide from the structures that they've developed. And I would like to stop and appreciate your comment that we have some of the best people doing this. Some of those people have developed a lone wolf work style. And so that change could also conceptually be threatening. So as far as why MACDL has a specific position, I'll leave it to them, but I certainly understand the anxiety that change brings about. It is necessary. It is definitely necessary, not just necessarily in the pilot program, but statewide for us to have some of this flexibility. I've talked to you about declining roster numbers in various places. We're down to 321 people, maybe it was 21 or 22 people statewide today, including areas of the state where, for example, we have no attorneys available to service child protective cases. And so we really need the flexibility that the general ability to hire people brings. And then I think we should experiment with whether this model works. I'm hoping that some people will come from private practice into the model. It could serve them as well as the defendants.
Yeah, thank you for that. You're right. I meant MACDL, and you're correct in that. Thank you.
Thank you, Representative Evangelos. And I'm sure you noticed, because I know you do your homework, there's a pretty thorough analysis on page 3 and 4 of the opposition expressed by Ms. Neto on behalf of MACDO. There are additional questions for Mr. Andrus before I move him back over? Well, I don't move anybody around. Representative Babbage.
Yeah, thank you. Mr. Andrus, you know, as we look at the public defender model, one of the concerns always about the current model was an infinite or a budget that was not really controllable. One of the concerns of the public defender model was a finite number of attorneys to address whatever need there is. Will the Kennebec pilot be a hybrid, or will it be strictly a public defender model? Can you tell us that?
I would like to answer that and also provide a little bit of additional information framing it. But most directly, it will be a hybrid model in that it is not designed to consume more than 80% of the caseload. And to the extent that the caseload surges past the expected point in years that the Kennebec project or any other project exists, we will be looking to either individual contractors, groups of contractors, or employees to serve those clients, or some combination of that. I wrote a memorandum for Representative Cardone last week, and it's in your materials somewhere, I believe. It is about essentially the budget surplus that is perceived and what's going to happen with that. But it talks about the coming surge, what I perceive as the coming surge in cases. And I guess I want to point out two things that relate to the overall climate of MCILS's budget and how it can grow and how there's no limits, because ultimately MCILS and its attorneys have absolutely no ability to control the case count. Cases are brought by agents of the state. Cases are assigned into lawyers in our cases only when the state is infringing a fundamental liberty interest. And ultimately, the perception that our budget has a tendency to move and balloon, that is somehow the fault of the attorneys in either system not working efficiently, it's not really a fair criticism, because we do the cases. And just by way of example, when you look at cases starting in fiscal year 2012 forward, the reality is that cases have not been declining. There's been some press about declining caseloads, crime rates, and filings in the courts. That may be true overall, but MCILS numbers are up. And this year we're on track for fiscal 21 by the end of June to have 28,000 cases open this year, which will be very substantially above our previous high score. And it's continuing. So that is a problem from a budgeting perspective. I acknowledge that, but I want to really make it clear that it's not the product of inefficiencies on the part of counsel. Our budget's actually only gone up 39% since 2012, if you correct for the rate increase that attorneys got from $50 an hour to $60 an hour over that period. It is true that one of the reasons for a public defender's office is to be able to more precisely predict and control cost. But I think that some of the information that's floating around the why doesn't really reflect very well what I've been able to determine. I'm happy to. I'll stop there because I know it's not what I was asked precisely.
Thank you. That's good.
Yeah.
Thank you.
Do you have additional questions, Representative Babbage?
I wonder why you asked that, Mr. Chairman, but thank you. No, I do not.
Nicer than asking about your new nickname. Are there additional questions for Mr. Andrus or for the bill or for our analyst, Peggy? Representative Moriarty?
Mr. Chairman, I move ought to pass, and I will go out on a limb on an assumption that there are no amendments to this particular bill.
I'm sorry, I missed the motion.
Ought to pass.
Okay.
And I'm assuming that there are no amendments.
That is correct. Is that correct, Peggy? I say that's correct, but.
There will be a fiscal note. The appropriation is here, but we'll have to add a fiscal note. Sorry.
Okay, we have a motion ought to pass. Do I have a second? seconded by Representative Babbage. Any discussion? Senator Carney.
Thank you very much, Chair Harnett. Colleagues, I have a question for you. This was when we discussed our budget initiatives. This was a three-way divided report. Some of us supported implementation of the program in the second year of the biennium. Some supported implementation starting in the first year of the biennium, and some were a straight ought not to pass. And my personal thinking about this trio of MCILS bills was that we, as the policymaking committee, would be really strategic in what we advanced to the floor of the House and Senate and to the appropriations table as a way of making sure that we really clearly expressed what our top priorities were. And I was one of those who voted to implement it in the second part of the biennium. I know that there are others who were very much interested in implementing it right away, which is what this legislative proposal, I believe, does. Implements it beginning January 1, 2022. And I would love to hear how other committee members are feeling about that, particularly those who voted the way I did on the initiative of a second year implementation, and also those who voted against it. And how I just would love to have a sense of how people are feeling now, since we are the policymaking committee. Thank you.
Thank you, Senator Carney. And before calling on members, I'd like to give at least my view on this, because I believe I was one of the people that voted for immediate implementation. And the bill I see in front of us sort of strikes a middle ground to me, in that it will not be going into effect on July 1st of 2021, but on January 1st of 2022 to get the program up and running during the first 6 months of the final 6 months of the next fiscal year, the first 6 months of next year, and then expanding on July 1st. To me, that's a compromise that I am comfortable with, but that's, again, I'm one member. So I'm interested in the views of our colleagues as you just raised the question, and I'll turn next to Representative Evangelos on that question.
Thank you, Mr. Chair. It's a good idea, Senator Carney, and if I was one of the ones, we voted on so many things, I think I was most likely voted to want to do the full 2 years, but I want to fold in with Representative Harnett's suggestion, and thank you for offering that. I don't want to be fighting an uphill battle here, and let's get this thing going, and I'm good with changing.
And I would appreciate if other committee members could weigh in. Thank you very much, Representative Babbage.
Well, I'm just, I'm guessing I was a second year person, but is it wise that we're unanimous on this report, or do we follow our initial directions there? I mean, I just want to know strategy.
Well, I think unanimity is always helpful, but I think I would need to hear from perhaps a member or two who voted ought not to pass as to their thinking on it, and I will turn to Senator Keim.
Thank you. Yeah, I originally, I think I'm still in my original position, which is I wanted to see the office beefed up first and allow them to come up to speed before we throw on this new objective. I think it's more than they can take on, and I actually don't know if they've even gotten the two other limited time positions that I think was given to them. But so that was my thinking, and I also the location is not one that I agree with. It didn't seem to come out of the MCILS report, and so I don't agree with how the location was chosen. And so for me, that would also take a lot more discussion to kind of come around to that location. But I think it's more than they can take on right now.
Okay, thank you. I appreciate you being candid with us. Representative Hagan, I saw your hand up, but then it disappeared.
Yeah, we could rename me inadvertent hand guy.
Okay.
But I was concerned also with that place. Macdel testimony did affect my way of thinking and the monetary note. So I'm probably going to go no on this one. Thank you.
Thank you. Representative Babbage? I can't hear you. You're muted, Chris. Representative Babbage, sorry.
Oh, that's the one that I did. I didn't take my hand down. I muted myself. Thank you.
Too many buttons. That's two of them,
Yes,
right?
exactly. So, yeah, I mean, I think Senator Kime's argument about a lot on the plate and all of that makes some sense. And I do think the second year initiation is a wise choice, but I'm wondering if Senator Carney and I, want to stay where we are or not. What's the best course for us to send a message? And is anybody else willing to move to the second year, July 1st, 2022?
Let me hear from other members and then see if there is room for movement. Representative Moriarty.
Thank you, Mr. Chair. I suppose I'm not wed terribly tightly to the date of initiation. I think the first of the year is makes a lot of sense to me, but I could go with the flow on that. I recognize that the Sixth Amendment Center recommended Cumberland County as the location for the startup project, and I won't call it a pilot project. I'm comfortable with Kennebec because Portland is I'm certain that it is the busiest district court in the state, and that might be a tough, demanding place to start. The other district court in Cumberland County is in Bridgeton, which is considerably further from Portland than Waterville is from Augusta. So to the extent there could be sharing between of staff between two relatively closely located district courts, Kennebec is a better choice of county than Cumberland. So as the location for a startup project, I'm comfortable with Kennebec.
But did you indicate you would also be comfortable perhaps moving to a start on the next fiscal year?
Yes, I could do that. I think it's doable as proposed, but I would not vote differently because we back it up by 6 more months.
Okay. Other committee members? Peggy, could you remind me if I know it was Representative Moriarty who made the motion? Is that correct?
Yes.
And who was the second?
It was me.
Representative Babbage.
Representative Babbage.
Thank you.
And for the record, I am amenable to the Babbage amendment should it be presented.
Babbage amendment?
So you would be
the new fiscal year.
Okay. Would you be amenable to changing your motion, Representative Moriarty?
Yes, I would. Given the input from the members of the committee, I'll amend my motion ought to pass as amended with an implementation or effective date of July 1, 2022.
Okay, so we have a motion and a second that have been amended, and I know that's going to generate some discussion. I will begin with Representative Newell.
Thank you, Mr. Chair. I just had a question. Peggy had mentioned that there would be a fiscal note. Is there a projected fiscal note at this time?
So it's really just a technical thing because you already have the appropriation in the bill. We wrote it with the money in the bill. So there'll just be the little thing that here says, here's what the fiscal note is. This is money from the general fund, and here's the projected cost going forward. It has to be added as an amendment, but it's not any, the money already shows up in the bill. If you change it, I'm assuming we just chop off the money, turn it to zero in 2021, 22, and you still have the same number. So that in this case, it's really a ministerial thing. It's not any information that you don't already have.
But Peggy,
Okay, well,
may I ask, does that 6 months actually reduce the fiscal by a third though?
Overall, it would.
Yeah, thank you.
well, thank you, Peggy, but let me rephrase my question. Has this been, have the funds been appropriated?
No. Well, the bill has an appropriation section in it. So if you pass the bill, it would appropriate the funds, which means if you pass the bill and it gets through the House and most of the Senate, it'll go to the appropriations table.
Okay, thank you.
Representative Evangelos.
Thank you, Mr. Chair. Mr. Chair, I supported the suggestion you made, but I'm not going for the new fiscal year. That means we're going to wait a whole nother year. You know, there is some sense of urgency here, and I compromised. I came halfway. That's what I'm prepared to do. But if they're going to insist on amending this bill and starting it a year from now, I mean, David Carroll's watching. He must be rolling his eyes. But if they're going to insist upon that, I'm going back to my original position. I came halfway.
I understand that, and I share your concern about urgency. My goal here is to try to get as much support as I can from the committee to get something done, knowing that we have a bill coming up right after this that will provide additional funding to the commission to be in a better place to support these changes moving forward. But I understand your vote may very well differ from mine. And I understand your reasoning. Representative Newell.
Thank you, Mr. Chair. Could I just get a better understanding? Senator Carney mentioned that a similar bill was proposed where this committee voted out a three-way divided report. Is that correct?
That's correct.
This is at the budget. Oh, during the budget. Okay.
Right.
Okay.
There were three reports. One report was to fund the Kennebec project, and correct me if I'm wrong, Peggy. One report was to fund the Kennebec project beginning in the next fiscal year, the 22-23. There was a report that I believe was the majority report. There was a report that I believe I was on that had it going into effect July 1st of this year with some other committee members. And then there were those who voted ought not to pass.
Okay, I have a better understanding now. Thank you.
Okay, thank you. Representative Babbage.
Thank you, Mr. Chair. I'll lower it now. Yeah, if Representative Evangelos is not going to join us, my intent was to get all of us that support, regardless of the placement of where it's going to be, which I also had some reservations about. Get all of us that are going to support this getting started on the same report. I do think it needs to survive the appropriations table, and there is support for us in appropriations. I mean, we can revert to the original motion and let appropriations push it back by 6 months if you want to strategically do that. But I think this appropriations is going to be huge, and that will be a factor in how far it gets. So I'm just asking us to think about that. But if we can't get on the same page, then perhaps my amendment is moot.
I think Representative Reckitt.
Well, I'm not exactly confused, except that my position really is with Jeff with the commissioner. That's a job you don't want, Jeff. With Representative Evangelos, and but on the other hand, I mean, so it does none of us any good to put out a three-way report again, right? So I'm not sure what I'm gonna do. What's that for?
Additional
Definitive.
discussion? I mean, I would prefer not to have a three-way report as well, but I can't control that.
Yeah.
Is there additional discussion by committee members? Seeing none, we have a motion ought to pass as amended with the program beginning in fiscal year 2022-23 by Representative Moriarty, made by Representative Babbage. And I would ask if there's no further discussion, I would ask the clerk to call the roll.
Thank you, Mr. Chair. Senator Carney.
There's a hand up.
I'm sorry, Representative Sheehan. I missed that. I apologize.
I'm sorry, I just wasn't clear on the content of the amendment.
The amendment, the bill that I proposed, LD 1686, began its first appropriation on July 1st of this year, on January 1st of 2022, with a full appropriation for fiscal year 2022-23. The motion on the table eliminates the 6-month period from January 1st, 2021 through June 30. I'm sorry, January 1st, 2022 through June 30, 2022, and begins the program in full on July 1st, the beginning of the fiscal year 2022-23.
Okay, thank you.
Okay.
I mean, I'm just gonna say that I would like to achieve a minority and majority report instead of a plurality situation. And if that can be achieved with the bill as drafted and presented to us at the beginning of this work session, then I would be inclined to support that.
And I received the sense that that was not going to happen, and I'm not sure what is going to happen. Representative Moriarty.
All right, Mr. Chair, we seem to be stuck on the effective date, and we haven't heard from everybody. Is there a way within the rules that you can informally poll the members as to what the preferred start date would be?
I do not know the answer to that question. Co-Chair Carney?
So I believe that is unacceptable to informally poll people. I know that Peggy has participated in many years of Judiciary Committee meetings. I'm familiar with doing it in other committees.
Yes.
Yeah.
Yes, I think it's happened in the past, just kind of a general, if it helps you get to a decision.
Can you poll through a series of questions?
Sure.
Okay. I guess then the first question I would ask in a poll is how many people will be voting to support this project in some form, this bill in some form? I would ask us to raise our, and I see 1, 2, 3, 4, 5, 6, 7, 8, 9. Is there anybody on screen too? Representative Newell, was your hand up on that? Okay. All right. Thank you. Then my next question would be how many would prefer the program to go into effect on, there's going to be 4 questions, on January 1st of 2022, would prefer. If you could put your hands up.
Wait, is that the earliest that could happen? That's what I'm.
That's
Yes.
the bill.
Yeah.
That's in front of us.
That is the bill as it is.
Okay.
Jeff, I thought that, yeah, that's right.
1,
Okay.
2, 3.
Oh,
Oh, I'm sorry.
I see 6.
Okay. And the third question would be how many would prefer it to go into effect on July 1st, 2022.
I'm voting twice.
Well, if you're voting twice, maybe you can vote that.
I just think the compromise is the best solution. So, I mean, I told you before, I'm not going to get forced into voting for the worst alternative in my view when I came halfway, but I voted for your middle ground, Mr. Chair.
Well, I know, but you just raised your hand for July 1st of 2022. I don't think you meant to do that.
No, I meant you offered a proposal for January 1st of this year, right?
That was a proposal ago. But yes, I did.
Is that going to be one of the polling questions?
It was.
It just was.
Was one of the polling questions. I think you meant.
Put your hand up.
Yeah.
You know,
So did we get a show on July 1?
I believe that I saw 2 hands on July 1.
Okay. Then
Then I see a couple of hands up, Senator Carney, then Representative Newell, and then Representative Moriarty. Senator Carney.
Thank you. Just briefly, what we're asking the commission to do, because we're soon going to be voting on another bill where we had, I think, 4 unanimous committee votes in support of pretty significant, actually 3 of them, pretty significant structural changes and addition of positions to the commission. And I feel like we're asking the Appropriations Committee and then also the commission to make some really big changes that are all going to start happening on July 1 of this year. And I am concerned with that. We are kind of fighting for money to be spent on January 1 that the commission, because we're hoping they're going to be hiring all these other people, would not even be able to spend during that time frame. It's a very practical objection, and that is what I'm weighing in my mind. Just what makes sense.
Representative Newell.
Thank you, Mr. Chair. My question would be, thinking back again to the divided reports during the budget portion of this, where would the July 1st, 2022 date align itself with the second part of the budget? Is it closer to pushing it off a little bit more with that later date?
I'm not sure I understand your question, Representative. I apologize.
I think I could answer that if you'd like, Chair.
Yes, please, Senator.
Okay. So I have the report out from our initial budget initiatives. And on this, 5 members voted in favor of the position starting on January 1, on July 1, 2022. 3 members voted in favor of a start date of July 1, 2021. And so the initial proposal contained in the bill we're considering prior to amendment would be exactly halfway between the one report that got 5 favorable votes and the other report that got 3 favorable votes. And then the remainder of the votes were just an ought not to pass on that initiative.
Representative Evangelos.
I'm a little confused, I'm sorry, but so the motion on the floor would move from July 1st, 2021 to January 1st, 2021. No.
No. The bill as published begins on January 1st, 2022, which is different than what some members voted on during the budget initiatives.
And is that the motion we're prepared to vote on?
The motion that is before the committee right now is to start on July 1st, 2022. It is not the bill.
Okay.
Mr. Chair, may I ask Senator Carney to give us the 5 and 3 dates again? The 5 people voted in favor of which date and 3 in favor? I thought you said 2021 on one of those, and that confused me.
So the report on the budget that received 5 votes was to start this project on July 1, 2022 for the second year of the biennium. The next report, which had 3 votes, was to start it on July 1, 2021, so the first year of the biennium. And so when Representative Evangelos describes the bill as printed as being a compromise, he's right. It's exactly halfway between those 2 reports.
I want the strongest majority report we can get. I don't see a way to avoiding a 3-way report here. So Representative Moriarty, you have your hand up.
I do. Thank you, Mr. Chair. I cheated and looked ahead to refresh myself on LD 1687, which comes up next, and that primarily deals with salary matters and the retention of additional employees, the establishment of an audit system, and so forth. By contrast, the current bill 1686 really takes a dramatic step for Maine and creates the first ever public defender office, something that's been talked about for some time. So I think that the bills do not overlap in terms of their scope and fundamental purpose. So having seen which way the wind is blowing in the poll that we just took, I'm prepared to take a step backward and withdraw my last motion and restate the initial motion, because I agree with you, Mr. Chair, that it's important to get the most possible votes that we can in favor of the public defender office in Kennebec County.
So your motion then is ought to pass as presented in the bill.
So I will withdraw my motion ought to pass as amended. And if this person who seconded that agrees, I will remake a motion.
Mr. Chair, I want to thank the mover of the motion for accepting my amendment in the spirit of getting to where some greater consensus. But I too will withdraw my my second to the amendment.
Okay. Then, Mr. Chair, I move ought to pass.
We have a motion ought to pass on LD 1686 as written. Representative Evangelos.
Second.
Okay. We have a motion and a second. Any further discussion? I would ask the committee clerk to call the roll, please.
Thank you, Mr.
Representative
Chair.
Newell. I'm sorry, Representative Newell's hand went up.
Thank you, Mr. Chair. Can you give me the dates again?
This will be the bill as printed beginning on July 1st of this year.
Oh.
I'm sorry, January 1st of next year. The second 6 months of the next fiscal year, and then the fiscal year after that.
January 1, 2022,
22, yes.
rather than July 1st, 2020.
Right, July 1st was not in this bill at all. That was back in the budget votes, because it wouldn't be in effect by July 1st anyway, unless it was emergency legislation.
Okay, thank you.
So just so everybody's clear, since I've been confusing everyone for about an hour now, the motion by Representative Moriarty is ought to pass on LD 1686, which calls for funding beginning January 1st of 2022 for the second half of the upcoming fiscal year, and then full funding for fiscal year 2022-23. We're all on the same page? I would ask the committee clerk to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative Harnett. I apologize.
No.
Senator Kime votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
No.
Representative Newell votes no. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Cardone. Representative Cardone is absent. Mr. Chair, I have 8 members voting in the affirmative, 4 members in the negative, and 2 members are absent.
Thank you. And for those who voted no, starting with Senator Kime, what is your report?
Ought not to pass.
And is that true for Representative Poirier and Representative Hagan as well?
Yes.
And Representative Newell, what is your report?
It would have been ought to pass, but with a later date.
With July 1st of 2022. Thank you. With that, thank you as I dragged us through the mud here, trying to get to a conclusion. But with that, we will close the public hearing on LD 1686. And I need to, Senator Carney, I need to leave to go to another committee. At this point, I would be back as quickly as I can. But I need to turn the gavel back over to you at this time.
Thank you very much, Chair Harnett. So we'll close the work session if Chair Harnett didn't do it on 1686 and take up the work session on 1687. And Peggy, did you have an analysis on this one?
Yeah, is it not available?
No,
No, I just didn't have a chance to look because I've pulled in a zillion different directions. I know you've been multitasking as well. Could you just give us a top line?
Right. So these, so first of all, just kind of back up, all 3 of these bills could be printed the way they were because they came from recommendations that were in the MCILS annual report, and you have authority by statute to report out legislation based on the MCILS annual report. So this is actually the recommendations that came from your discussions with Mr. Andrus and the commission members during the budget discussions. And so this bill does a whole lot of different things. So we can go through it section by section if you want. The first section is actually something that was in the change package, which is changing the salary range for the executive director from, believe it or not, 52 to 37, gives you a higher top out rate. And then section 2, this is the same as in the bill you just looked at, 1685, which makes sure that the commission has the ability to directly employ attorneys to provide legal services to clients. So rather than going through contracts or vouchers or anything, these would be employees of the commission. And then 3 and 4, we're just adding a new paragraph O, which is for the commission to establish a system to audit all financial requests and payments that includes the authority to recoup payments when necessary, and may summon persons and subpoena witnesses and compel their attendance, require production of evidence, administer oaths, and examine any person under oath as part of the audit. And the subpoenas will be enforced by the Superior Court. And Section 6 makes the rules about standards, routine technical rules. So right now, when the commission adopts rules about attorney training and standard requirements for their practice, they are major substantive rules, which means any change has to come back to the legislature for your approval. Section 7 is authorizing the audits. 1805, I believe, is what the executive director does as opposed to the powers of the commission. So this allows the executive director to conduct audits, and actually directs the executive director to conduct audits and gives the executive director the subpoena power of the commission. Sections 8 and 9 are about carrying any money that's left at the end of the fiscal year into the next fiscal year rather than having it swept like most general fund accounts are. That also was in the change package, but in a more permanent way because it was amending the whole budget statutes in Title V. So if the change package is actually enacted, you would not need 8 and 9. And then the rest of this is the appropriation sections for the various pieces of the recommendation. So there's the central office staff, which I believe is this first one is one office support supervisor, and also 3 public service manager 2 positions. These are really hard to figure out which one goes with which. So let me just back up a little bit and say the purpose is to create a central office. We didn't create an appellate defender division, which includes an attorney and 1 paralegal, and that would be statewide. And that would start in this fiscal year. So that is why this is an emergency, because most of these positions would all be starting July 1st. So it needs to be, I'm sorry, I said this year, this calendar year, it would be the beginning of the next biennium. So it creates the appellate defender, but it also starts the units that Mr. Andrus had talked about, being training and supervision and the audit and review functions that the commission would then carry out under this. I'm going to try to find the great memo he had sent us with the pictures of his plan, his kind of flow chart, his organization chart, and I'll see if I can find that and screen share that.
Okay, thank you. Maybe while you're looking for that, Peggy, I'll just speak a little bit about something that I mentioned on the previous bill, which was that I do, in this proposal, there are some things that had some budget initiatives that had divided reports, but there were other budget initiatives that the committee unanimously supported. And I just like to point those out to committee members to remind us of the work we had done earlier in this session. So if you look at page 3 of the bill, lines 7 through 13, that is one initiative that we voted unanimously to approve, but that has been included in the change package. That was initiative 4 from our work on the budget. The next initiative, which is on page 3 at lines 14 through 20, that's the initiative that increases the hourly rate for attorneys who are retained by MCILS to represent indigent defendants. And that is something that also received unanimous support. And that's initiative 5 from the change package. Excuse me, from the budget work that we did. And then if you look at page 3 toward the bottom, so lines 32 through 38, that item is a restoration of the baseline budget for MCILS. And that again is something we voted unanimously on. And then if you flip over to page 4, lines 1 through 6, that's kind of that office build out structure that Peggy is looking for the graphic. And so, there were some things we voted on where we didn't all agree, but those 4 things, one of which is already in the change package, are things that we all agreed on. And I would just really encourage committee members to think about standing together and supporting those initiatives in our work on this bill. The bill does include everything that was a subject of an initiative, but I wanted to highlight the things that we all agreed to so that folks had that in mind. And I see lots of hands up. I think I will start with Representative Evangelos, and I'm just gonna, I think you're in order across the screen. Go ahead, Representative.
Thank you, Madam Chair. Regardless of how I voted in the Appropriations Committee, I never would have voted for an emergency clause for the narrative language that's in this bill. My emergency is the money. I've been clear about this the entire time that I've been supporting the money, and I'm okay on the money being the emergency. I am not okay with this other language in there that doesn't address money as an emergency. So we didn't address emergency clauses in front of appropriations. So I know I raised some concerns regarding the issue I'm talking about at the Appropriations Committee. I may have folded in just for the unanimity we were looking for in front of them. But once I found out this emergency clause was on there and this language is in there, I can't support it. I do not want to risk getting this money, which a 2/3 vote in both chambers, with language that clouds our chances of success. I'm perfectly happy to have this language, put into one of the other bills, 85, because it's a narrative type bill would be best. But I just, regardless of how I voted on in appropriations, we didn't talk about emergency, non-emergency. So I'm struggling with that part. And you know how I felt. I told you before. If I have to say more, I will. But that's where I stand.
Thank you very much. And Representative Moriarty.
Thank you, Madam Chair. You pointed out that I think it's the executive director's salary is already in the change package. Does that mean we can delete that initiative from the bill?
Well, so we could. I mean, we supported it yesterday in the work that we did late in the day yesterday.
I'm sorry.
However, we don't know if it'll stay in the change package. So that, it may make sense to keep it in this bill and let AFA delete it if the change package goes through with that language in.
Okay, so no harm done to leave it in.
It doesn't hurt, yeah.
Okay. A question, if I could, for Representative Evangelos. Are you suggesting that we only ought to consider section 10 with the emergency clause?
Sections 8, 9, and 10.
Oh, okay, yes, okay.
Money. And when we get into committee discussion, I'll explain my reservations about something. But yeah, I just want, the money's the emergency. Let's not risk this important initiative where this is the budget part of it, the big money other than the Kennebec County piece. And I don't want You know, the whereases can stay, but, section 1 through, as Representative Harnett corrected me last week, section 1 through section 7, 9A, I wanted put into a non-emergency package.
I see. Okay, thank you.
Representative Hagan, and then Peggy, I'll let you go ahead. Okay, go ahead, Representative Hagan.
Thank you. I have two things. One might have to wait. I think it probably will have to wait. I don't remember voting for any of this. I must have not been present when this happened.
That's right.
So anyway, would a question on some of the monies be appropriate now, or should we wait until we've gone through it a little bit?
I think a question now would be appropriate. I did want the voting sheet that I have indicates that you called in or emailed in your votes after the work session on the budget.
All right. I was curious, it catches my attention every time I look at this thing. Why the need for a raise from $60 an hour to $80 an hour? That seems very excessive to me.
Okay, let's put that on hold, and you can ask either other committee members or Mr. Andrus, but I feel that Peggy right now has some information that she was trying to obtain a while ago, and so I've got it noted down, and we'll return to that.
Gladly wait.
Thank you. Go ahead, Peggy.
Okay, my only, and I'm not sure if Representative Evangelos said this, that the language in section 2, if you're going to provide funding for the commission to hire attorneys, then you need the language in section 2. You could have an emergency bill where not all the sections take effect as an emergency. We just need to identify which ones take effect right away or on a particular date, and identify which ones take effect later. You could even make them take effect July 1st of 2023 if you wanted. But I just think that section 2 is really tied into the commission using those funds to hire attorneys that represent clients. That's all I wanted to say.
Thank you.
Thanks.
Okay, and then, so let's loop back to Representative Hagan's question, and I can speak to this briefly. Oh, did you want to address it, Senator Kime, to answer his question?
Yes, I did. Sorry, we haven't had a lot of time to discuss bills. We're just like sort of keeping up as we go. But yeah, I think that what we discussed was that the attorneys are quite underpaid. And additionally, we're increasing the what's required of them for record keeping. And they don't have right now any payments towards overhead. So there's a lot on being asked of the attorneys to pay for out of the $60 or $80 an hour. And so this was sort of a compromise that we came to. Lots of people wanted more, MCILS suggested more, and we came to a compromise because we were looking for a unanimous amount. So I just wanted to share that. Thank you.
Thank you, Senator Kime. Representative Hagan, do you need any additional information?
Not yet. No, that was one of the thoughts. I was not at the event when it happened, so I'm at quite a disadvantage. But the good news is we're going to end World War II tomorrow in class. So thank you very much.
Okay.
Representative the Middle East, please.
Yeah, that's right. Representative Evangelos, is your hand up anew?
Yes, I just wanted to help Representative Hagan understand part of the dynamics that goes on with this. So for the $60 an hour, the attorney has to pay, office help, and different things come out of the 60. So they're not even getting the 60. And private attorneys are averaging $330 or $350 an hour. And the Attorney General's office and the prosecutor's office are provided, free assistance and help. Not free, I mean, it costs the taxpayers, but it doesn't come out of their $60. So these indigent legal counsel gets $60 an hour, but they have expenses coming out of the 60. And, they're making very little money after those expenses. So that is why we have to raise it to make sure they get compensated. Thank you.
Is there a chance to find out exactly what those expenses are and what the actual take home is?
I think it depends upon what the case is, whether it's a simple, quick case or if it's a lengthy one. I'm not sure there's a straight answer to that. Some cases go on for months, and other cases last a day.
Yeah.
I have a real difficult time understanding how $60 an hour, that's a lot of money. And for months of work or weeks or what have you, Mainers don't make that kind of money. And I'm speaking from a teacher's salary standpoint. And I know that a lot of your heads are rolling and you're clearly not pleased with my perspective, but I can't seem to get out of that perspective.
Thank you for sharing that, Representative Hagan. Representative Moriarty?
Thank you, Madam Chair. I wanted just to share with Representative Hagan my personal story, which I previously shared with the committee, but Representative, you may not have been present. It was almost 43 years ago that I began doing court-appointed criminal defense work. And at that time, the hourly rate was $40 an hour. So 43 years later, it's only 60. And that's not $60 in your pocket. From that 60, you've got to pay your rent, your lights, your staff, your supplies. We've already heard about how there are some parts of the state in which there are no attorneys willing to do court-appointed work. And you're not going to get them at 60. That's not happening. They're leaving this line of practice because they can make more money doing other things. So 80 actually was a compromise. We had a recommendation for a much higher figure. So it's just the economics of the practice of being self-employed and keeping the lights on and providing services at the same time.
$60 an hour, you're right, you're going to have expenses, you're going to have overhead costs and whatnot. But if you add up the hours, at some point your overhead costs are going to be taken care of, and now you're at profit. And I would say that's a heck of a profit as time goes on.
Well, it really is.
Committee members, I think what maybe makes sense at this point is to have a discussion about the other initiatives that we did have a unanimity on, to see if there are questions and concerns we can address. So I think we've talked about the hourly rate. And so I'm going to move on to the next one, which is the on page 3, lines 32 to 38. And that is the restoring the baseline funding amount to the commission. And I think what I will do is ask the interim ED, Justin Andrus, if he can kind of explain that baseline funding concept to us. And then we can have him answer any questions. Go ahead.
Good afternoon. If someone could acknowledge that I've got my mic working properly before I thank you. I've learned to ask. So I can go get some hard numbers in a second, but over the course of the commission's life, we've required approximately $18.3 to $18.5 million a year to meet our expenses. And as briefly as I can, we have an account for personal services, which is salary and benefits for staff, put that to the side. And then we generally have an all other account from which we pay attorneys. We pay non-attorney service providers like investigators, expert witnesses, translators, things like that. And also we pay operating expenses like our bill to the information technology department, for example. So in the biennium, we have been funded at $15.5 million for expenses that predictably cost year in and year out $18.3 million. And so that number has shifted a little bit. Our expected, costs have shifted beyond that. We don't have an initiative at the moment designed to address the issue of the COVID backlog case surge. Somebody wants me to talk about that, I can. It's in the long memo that I provided to Representative Cardone and also to Peggy. But what we're trying to do is get back to zero. Now, folks are expecting us to have a carry forward, and we will have a carry forward based on our current cash on hand, our expected expenses over the next 4.5, 5 weeks. We look like we're going to come forward out of this year with a little over $4 million, maybe $4.25 million. It's hard to tell because the rate at which vouchers are submitted varies. But on average, based on the recent average, we think that's what's going to happen. The problem is that as we move forward into the biennium, we're going to exhaust that in the first year, meeting our basic operating expenses, or have a very small surplus. And we're going to move into the second year with a deficit. Once you start looking at what we expect to see for a few things, the backup that's existing in the judicial branch of cases overall, particular attention to the backup of the more expensive cases that go to jury selection and ultimately to trial. And also the fact that we're continuing to see the actual number of cases ramp. I said earlier that we're looking at 28,000 cases on the year, which will be our high score. It's going to turn out that our original estimates for what the baseline ought to have been will be below what we actually experience. But it made sense, I think, to address those environmental issues as we go forward and we see what they really are, rather than trying to appropriate for them now.
Thank you. Thank you. I'm going to interrupt you there just because I think that you're maybe going a little bit deeper than we are able to focus on, and kind of we already have a lot of information on the issue, and I didn't ask you the question properly, so I do appreciate you providing that information, and I should have framed my question better. Thank you. Senator Keim, did you have a question?
Just a suggestion, and I recognize Representative Hagan wasn't present for our more thorough conversation around the budget, but in the interest of time, if I could, if we could, I think, skip the, as long as there aren't objections, if we could skip the initiatives that we had unanimous consent on, and then maybe just talk about the things that we didn't, just to save us time. If other people are agreeable, I would be, and then I would be happy to chat with Representative Hagan and catch him up on some of the things that he might have missed on those initiatives, if that's helpful for everyone.
Okay. Yeah, I think that makes a lot of sense. Thank you for that suggestion. And I'll just ask a global question of committee members. Are committee members interested in reporting out a bill that just contains those items that we feel that we can get a very significant majority report on? Because if that is the case, then perhaps we don't even need to go over all of the other budget initiatives. How are people feeling in that regard? We've got some yeses, but I'm not seeing a universal support for that. Senator Keim, go ahead.
I just needed clarification. Do you mean that we would report out a bill that included no language, but except that which applies to these budget initiatives? And we would only be doing budget initiatives?
Yeah, I mean, I think what we could do is we could report out a bill that contains the language that is directly tied to the budget initiatives, and then those 4 initiatives on which we had unanimous support, and say, we're being consistent with our vote on the biennial budget, and that is the bill that we can all get behind. And personally, I think that that would be a very strong expression of our setting priorities as the policymaking committee in this area. And so that would be, I think for me, that would be the ideal outcome of today's. But, you know, it is the pleasure of the committee. We do everything by a majority vote, and we can certainly take an approach that goes through each item individually. Senator Keim?
Sorry, I think Representative Evangelos had his hand up first.
Okay, yeah, okay. Go ahead, Representative Evangelos.
Senator Keim, if you had something you wanted to wrap up on the current discussion, I'm okay with it, or if you want me to continue.
I actually want to talk. I actually am concerned that we hear from maybe David Carroll and Justin Andrus on the language pieces. I think they're really important. So I am not wanting to just erase them and not consider them. I don't know if we could split it into two bills. I understand Representative Evangelos doesn't want it to be an emergency. I personally don't have a problem with that, but I would love to explore that more than just simply agree that it isn't necessary and take it out.
Okay. And then how do you feel, Senator Keim, about the proposal that we focus on including in the bill just the four initiatives that had unanimous committee support?
I like that. I just want to make sure that we do talk about the other language that I think is still important for transparency and accountability.
Okay. And committee members, can you give me some kind of an indication as to how you would feel going forward with a bill that focuses on those four initiatives that had committee support? Is that something, you know, just looking at the financial part, not the language, is that something that committee members could get behind?
Actually, I was going to speak to that. I yielded.
Okay, go ahead. Yes.
Well, first of all, I support all of the financial initiatives because they sort of were produced by compromise to begin with. So I would need to know how much it's going to cost us if we took out anything that wasn't unanimous. We're at 10.5 and 10.7. Which ones would we lose if we followed that?
Yeah. Okay, so I'm going to go through the bill and just let committee members know. So what didn't get unanimous support was the first item on page 2, lines 26 to 34, and that's the office supervisor. The next one would be page 3, lines 1 through 6, and that is I think this what you would call the second stage of the office build out.
Give the amounts. I'm sorry.
Yes, 7. Okay, so the first one was 95,000. I'm just going to give round numbers.
Yep.
The second one was 72,000, and this is per year. I mean, 762,000.
Okay.
The next one would be an additional. So I feel like this is a really awkward way to do this, committee members. I'm sorry, but is this helpful to people, or should we just serially go through each of the dollar amounts?
I think you've already done 2 of them. What are the other 2?
So these are the ones that we don't have support for.
Right.
Okay. The next one is on page 3, and it is another aspect of the build out of the office staff, and it's 453,000 in the first year of the biennium, 626,000 in the second. The next one would be the final, no, and that's it. So those are the ones that would be taken out of our budget initiatives that we considered in the biennial.
So there were 3?
Mm-hmm.
I had 762, 453, 95,000. Was there a 4th one?
There's 195, 2, 3. Yeah, there were 3 of them.
Okay, thanks.
Let's see.
It's $1.5 million the second year, Jeff, a little less the first. first year.
Yeah, it's, you know, if we're getting close to unanimous on the rest of it, it's a good suggestion, Senator, and, you know, we'll see how everyone else thinks.
Okay. Go ahead, Representative Moriarty.
Madam Chair, I thought that the initiative from lines 31 to 36 or 37 was also a non-unanimous vote.
Oh, thank you. Yes, I missed that. I'm sorry. Well, I think that I
95,000.
think that was included in the
Unanimous.
the amounts that I read out. So, okay, so I'll give you the first year of the biennium, the ones that did not have unanimous support. The first is on page 2, and that's $95,000 a year. The second one is at the very top of page 3. That's $762,000 a year. And the third one is right at the second half of page 3, and that's $453,000 the first year of the biennium, and $626,000 the second year of the biennium. So those are the ones that we would not be including, and those were the ones that did not have unanimous support. And so as far as the money portion of the bill, are committee members comfortable reporting out a bill that contained the other 4 items, which are the 4 that we unanimously supported in our work on the biennial budget? And let's just do an informal poll with a show of hands. So if you are comfortable with that, or think you could become comfortable with that, will you raise your hand, please?
Makes it about 9.2 each year, I think.
Okay. Thank you, committee members. And so let's put that to the side and turn our attention now to the language aspects of the bill. And looking at the language aspects of the bill, which start on page 1, about halfway down, we have the salary range, that's lines 19 and 20, and that was part of the change package and that we voted on yesterday. But we have decided that just in case it comes out of the change package, we would want to include it in our legislation. I see lots of hands up, and so I sense that I should not go forward with talking about language yet, because people would still like to talk about the money. So we'll start with you, Representative Hagan.
Thank you very much, Madam Chair. Actually, it has nothing to do with it. I had no ill feelings or anything, and I felt like my tone of voice with Mr. Moriarty, Representative Moriarty, I didn't like my tone of voice, and I want to make sure that I hope I did not offend you, and I would apologize if I had. And I wasn't mad or angry or anything. I was just getting clarity, and I felt like I didn't speak politely as I should. So
You're all set, Dave.
Thank you.
Representative Babbage, do you have a comment about the money aspect?
Not about the money, ma'am.
Okay. So let me just go through the language, and then we'll take your question, Representative Babbage, or your comment. Okay, so lines 19 and 20, it's important for us to include that because we're incorporating what's in the change package just to be safe about that. Section 2, and Section 2, I believe, Peggy, you said was something that we needed to include if we're going to vote on the financial elements that we're considering. Is that correct?
Right. This just gives the commission authority to hire attorneys that will provide legal services directly as employees of the commission.
Thank you very much. And then now we get to sections 3, 4, and 5. And Peggy, could you please give us a bit of an analysis on the significance of those sections of the bill?
I will certainly try. So 3, 4, and 5 are amending section 1804, which is the commission's responsibilities. And this is in subsection 3, which is the duties. The commission shall do these things. So 3 and 4 are in there just because N is currently the last paragraph. So those, you'll see a whole bunch of that in the errors bill. So section 5 is really the new language, and this requires the commission to establish a system to audit all financial requests and payments. That includes the authority to recoup payments when necessary. That authority includes recouping payments when necessary. And I know there was concern raised at the public hearing that a system to audit all financial requests and payments might be unwieldy. I don't know that it really means that the commission has to audit all, but it gives them the authority. The system would be able to audit all financial requests. That's probably not what you need to focus on right now. This also gives the commission subpoena power, which then later on in the bill, it directs the executive director to exercise that power. I think that's it for what that really does.
That's great. And so when you talk about the commission having the power to do that and it being exercised by the executive director, is that section 7 of the bill where the executive director is exercising the power of the commission?
Right.
Okay, thank you. And Senator Keim, I know that you had questions about that section. Would you like to hear from the interim ED on that, or follow-up questions with Peggy?
Thank you. Yes, I think it would be fine for the interim ED, but I think it would also be helpful to hear from David Carroll. And part of this is, and we've had a lot of discussion around this in the Government Oversight Committee as well. And there is a lot of concern that we allow the commission the ability to look at records, and part of the consideration of whether or not an attorney is taking on the amount of work truly that they can handle is being able to look and see what other cases they're taking. But I am not the expert in that, but I know that we've had a lot of discussions around that, and that this was brought up as a way that we're ensuring that their system is able to take on the appropriate oversight that it should have. So, and it was, and some of this may have been direct recommendations of OPEGA to as this discussion unfolded. So I think Justin Anders would be great to hear about this section, but also probably David Carroll. Thank you.
Thank you. So Justin Anders, I'm going to just ask you to briefly address this, and then I'm also going to bring in David Carroll, and we'll ask him to address it as well.
So I want to check my impulse to say more than I should and just ask for a little bit clearer direction on what question I should, really what the question I should answer is before I start an exposition.
Thank you. Yes, and I think we've both, yes, so let me frame the question. So is section 7 of the bill, does that require the executive director to essentially execute on the commission's authority to subpoena people and documents related to the audit responsibility?
So I think it does. I will say that it permits rather than requires the executive director to execute. It imbues the executive director with the investigative authority and the ability to use some of the tools. So the subpoena tool is listed, but for example, the placing people under oath tools that are in the changes to section 1804 are not listed. I do think it's important that the executive director in performing the investigative function have that ability to subpoena documents and information. I also think that I understand the concern about giving unchecked power to somebody, but that it's problematic to require the consent in each instance from the commission for a number of reasons. But it really has to do with something we talked about in the previous bill, which is the ability of the commission to retain its appellate function. And so we start to get into an area where if the commission is prejudging the reasonableness of the subpoena, they may be conflicted from then performing the appellate function of reviewing a decision where that comes from. I would point out that there are a few checks in place automatically. First off, there are governmental ethics issues with the misuse of the subpoena power. Secondly, it's interesting, our statute says that the person in this position must have experience in indigent defense. It doesn't actually say it has to be a lawyer, but I don't know how that person wouldn't be a lawyer. And so that person's going to be responsible to the Board of Overseers as well for professional conduct and the exercise of the subpoena power. And finally, somebody has the opportunity to move to quash a subpoena. If a person feels that the subpoena is improper, they can ask a court to make a determination about the propriety of that subpoena before answering. And so there are a number of checks there that provide some safety.
Thank you. That I think that addresses the question. Appreciate that. And now welcome David Carroll to the Judiciary Committee. And I think, and Senator Keim, I believe the question has to do with the reason for the audit requirement, but I would like you to phrase it, if you could, please, to David Carroll.
Thank you for being here again, Mr. Carroll. Nice to see you.
Nice to see you.
Yeah, I just, you predate Mr. Andrus. And as we've kind of talked about all of these different aspects. And so I really just wanted you, just because this language I believe is important and it's definitely come in front of the government oversight. And so I just wanted you to add your perspective on this, which of course offers many state perspective that you have to the committee as we consider this language. I think that would be helpful.
Great. Thank you. Just for the record, I'm David Carroll, the Executive Director of the Sixth Amendment Center. It's nice to be back with you all. The auditing function in subpoena power is critical to fixing the ills that we've recorded in our report. Not to play greatest hits, but again, when we were studying it, we found that the legislature had asked MCILS to oversee both financial and quality representation of nearly 600 attorneys handling 30,000 cases in 47 courthouses before 90 different justices, judges, and magistrates with 3 people. It's impossible. It's why you're having problems with the system. And knowing and working with Mr. Andrus, having the subpoena power and the oversight that he has just talked about is critical to do this. I mean, one point I just want to put out is we had made the recommendation that a public defender office should be in Cumberland County because we had the greatest economy of scales. Choosing not to do that is certainly the legislature's prerogative. But our expectation of what Mr. Andrus would need for staff was premised on that. So even if everything in this bill was voted through, I still think they're going to be short-staffed for providing proper oversight and of both finances and effectiveness. If you then cut him off at the knees by not giving him this auditing function and subpoena power, you really have not accomplished anything. So I'm all for sausage making. I think good choices have been made along the way here, but this is the one that's critical. If you don't do this, then you really haven't taken any steps forward on fixing this.
Thank you, Mr. Carroll. Committee members, are there questions for David Carroll? Representative Babbage, your hand has been up for a while. Did you have a question?
I can ask it. My question had to do with main agencies, but in other states, of course, they don't have the main system that we do, but they all have subpoena power as part of their oversight, do they not?
Yeah, so there are some states that are completely top-down public defender for primary systems, and it takes a lot of this, but everyone has some component of an assigned counsel system, and they have to be able to have the ability to tell the taxpayers that the money is being spent effectively and efficiently. So yes, the ones that have large portions of assigned counsel systems have these powers.
Thank you.
Thank you, David Carroll. Representative Evangelos, go ahead.
Thank you, Madam Chair. Hello, David. How are you now?
Very good, thank you.
You've seen the bill then, right?
Yes.
Okay. So here's my objection, and follow me on this. So Section 5 of the bill, the commission may summon persons and subpoena witnesses and compel their attendance. The commission is the fair hearing body. So we have a situation where the agency or commission, which represents lawyers defending the poor, coming up with an oversight remedy where the people doing the investigation and issuing the subpoenas are the same people conducting the hearing. That's like a district attorney becoming the judge and the jury. And you're going to be writing a Sixth Amendment report about how our lawyers aren't getting due process and the right to a fair hearing, because the power to do these subpoenas comes from the commission through the executive director. They're already involved, and they can't exactly be sold to me as a fair hearing anymore. They're part of this process. We can't allow the district attorney to be the judge and the jury.
Right, but you're not making a criminal case here. You're just auditing and making sure that the resources are well spent and spent effectively and efficiently, and that people aren't saying that they're spending money doing something that they're not.
Right, but the appellate body is the commission by which the investigation and subpoena power is derived. And then they're going to be holding a fair hearing. That's a conflict. And everything we've been fighting for in support of what you bring forth is in contradiction to that kind of a situation. I just don't see a proper barrier, because the commission is no longer the impartial jury. They've been involved in the subpoena power and in the investigation, and now the lawyer gets hauled in. And I don't see it as a fair hearing with due process, which is exactly what we're fighting for here. Do you understand what I'm getting at?
Not really. I mean, you want the commission, the executive director, to be the supervisors over this work.
Yes,
and
supervisors.
If they're finding fault, they should be able to get rid of the person off the panel.
Right, but if they're the supervisors of this work and they're the ones accusing somebody of fault, how can they then hold a fair hearing? They're no longer impartial. They've bought into it. That is not an impartial jury.
But that's what MCILS is there for, right? To ensure the effective representation and the effective use of taxpayers' money on this issue. That's what you're asking them to do, and how you can do that without an auditing function, I'm not sure.
Well, I get it, but we've got these bills to protect the due process rights of indigent defendants. But when it comes to individual attorneys that have come under the purview of the commission, they're not getting the same rights to due process, because the commission's already in on either an accusation or a proffering of some problems. So where in this process does the attorney get a fair hearing in their due process? It's just a contradiction to everything else we've been working on.
Well, there's a constitutional right to effective representation in a criminal case in which the threat of liberty is there. There's not a constitutional right to do whatever you want with state money without being held accountable with it.
No, but the appellate body, by definition, has to be unbiased and impartial.
I just think we have a difference of opinion on how that's characterized. All what I can say to this body is that what is being asked here by Mr. Andrus and MCILS is standard.
Well, this looks like it's ripe with conflict of interest to me, because the appellate body who would hear from a lawyer is essentially the district attorney. You know, they're the ones proffering the charges. And now, okay, now you're going to get your hearing. We accuse you of this. Now come in and get your fair hearing from the same board. Reminds me of Charlton Heston and the Planet of the Apes. You know, it's the same people right through here in his case. He didn't stand a chance. So I'm sorry you can't see the conflict in that. If you read paragraph 5 and consider yourself one of the lawyers who, by the way, the lawyers are entitled to due process and the, the presumption of innocence.
Yeah, Jeff, I would just, Representative Evangelist, I would just like to.
I made my point. That's my concern around this.
I understand your concern, and I would just agree with Mr. Carroll that I think that the only way the commission can really carry out its audit function, which is extraordinarily important, and I would just point out, is one of the ways that the commission can build up its credibility with the administration and with others who really rely on it to function well, is by effectively carrying out this audit function. And in order to carry out, excuse me, I would ask you not to interrupt me. Thank you very much. But in order to carry out this function, they do need subpoena power. And we've talked about different legal issues, and I would just ask you to be open to my perspective as a lawyer, that I look at the situation and it seems to not present to me the type of conflict of interest situation that I would be concerned about. And I agree wholeheartedly with Mr. Carroll. And I would ask you to be open to the perspective of others on this issue, because it would be really great if we could get this legislation through with a strong committee.
Sure, I understand that, but this isn't an emergency, A. B, we aren't here to please the administration. We are here to develop legislation. That's a separation of powers issue. I'm surprised you said that. And I'm sorry if you can't get to the point where I am on this regarding the conflicts. Picture yourself as the attorney being subpoenaed and hauled in to the commission that's already made these investigative actions against you. Do you think you're going to get a fair hearing in front of them?
I would just like to respond to my point about the administration was just that we have been working very, very hard to get funding included in the budget to support MCILS, and the consistent message we've received back is that there are concerns about the commission upgrading its processes, and we are all working really hard to do that. I know that Senator Keim has had her hand up for a while, and I just want to call on her at this point. Go ahead, Senator Keim.
Thank you. I going to allow myself one comment that is slightly outside of the line, but we're also not here to protect Amy Fairfield. We're here to create good policy that stands the test of what is required and needed at MCILS. And this isn't about just the administration.
Point of order.
This isn't just about the administration.
Point of order, Madam Chair.
Excuse me, Senator Keim, can you please provide me more information?
Well, she just brought a specific attorney into the discussion and has also mischaracterized the actions Opega took. She can say whatever she wants, but she shouldn't be naming specific attorneys.
Thank you, Representative Evangelist. Can you please continue, Senator Keim, and focus on the statewide policy issue that you were getting to?
So the administration, yes, is looking at this and making statements about, the validity of of MCILS being able to carry out their functions, but they're only, I mean, if that's the chief executive, that's one person. We have the state of Maine looking at MCILS saying, this is our taxpayer money. This is our constitutional obligation. I don't mean to mischaracterize what happened at GOC and would be happy to amend anything I've stated. But in general, what we're trying to attempt is that there is transparency in the process and that there is an incredible level of oversight available to MCILS to ensure both the financial accountability, but also the job that how well these lawyers are representing people. And I see this as really critical. So it isn't about the one issue, and it was brought up previously, Representative Evangelist, the name by you. So that's why I mentioned the name.
Point of order. I have never mentioned that specific attorney by name in conjunction with this matter. You go back and watch the tape. That is simply not true. I said there was a situation. I never mentioned an attorney by name. And don't mischaracterize my comments, Senator Keim. That was not an honest thing you just did.
Okay. Thank you.
Committee members, I know that Representative Moriarty, you have your hand raised, and I'll call on you in just a second. I think that this may be a matter that we are not able to agree on, and so I would like the committee to move toward a motion. And I think what I would like to do is have a motion and a second, and then actually table this so that people can think about it a little bit and let us move on to some of our other work. Does that, Senator Keim, does that seem like a reasonable path forward to you? That we think of, table it, think about it, or do you feel like we're ready to vote?
I don't know what motion to make.
Okay, so I'll describe the motion that I think that we should make. Representative Hagan?
Yes, thank you very much. After you describe and do all that stuff, I would like a corner caucus because clearly Senator Keim needs to bring me up to snuff or up to speed on some things so that I can be more comfortable with my vote.
Thank you. That's a helpful suggestion. So we'll have a motion and then we'll do a corner caucus. And so I think that I, as the chair, cannot make the motion, but I'll recite what I believe that our motion should be. And I think that the motion should be and ought to pass as amended on LD 1687. And the amendment would be to remove from the document that we have been working on the following sections of the bill, and that would be from not section 10 in its entirety, but lines 26 through 41 on page 2. And lines 1 through 6 on page 3. And lines 21 through 31 on page 3. Those are the 3 financial initiatives that we did not have unanimous agreement on. So that would be my suggestion for a motion. Senator Keim?
I'm sorry that I missed the first part. Did you include the language or not?
I did. I think we should include all of the language as well.
Okay. I would like to make the motion as suggested by the chair.
Thank you, Senator Keim. Is there a second? Seconded by Representative Moriarty. And now at this point, we'll take a corner caucus. And I would like to know, Senator Keim, how much time do you estimate you'll need?
I think we should do 10 minutes.
Okay. So let's say we'll return at 4:45. Thank you, everyone. And Dems will caucus as well.
May I join the Dem caucus?
Find the link.
I'll send out a link to everybody in a moment. David Carroll, thank you so much for joining our meeting today. I know you've joined the committee on many occasions before, and it's always been when I've been pulled away to other business. We appreciate your participation. I am going to move you back to the attendee portion of the meeting because we're heading toward a vote, and we typically just have committee members on when we vote.
Totally understand. Thank you.
Thank you. I'm going to move Representative Poirier, how warm is it up your way right now?
I don't know what the temperature is, but when I was outside earlier, I had to go to an appointment. It was just hot and humid. It was warm enough that I had to run the air conditioner in my Jeep. So that doesn't happen often. I like to have the windows down. So yeah, it was quite warm.
Yeah.
The sun is still peeking out a little bit. It's starting to get a little gloomy, but the sun's still out. So
what do you drive for a Jeep?
I'll be
Grand Cherokee.
I've got a Wrangler.
Nice.
It's really nice. Yeah, I love it.
I used to have a Commander, but they stopped making them again. So
What kind now?
I used to have a Commander.
A Commander.
Yeah.
And I had a Liberty, and they stopped making that.
Yeah.
All right, committee members, it looks like some of us have returned from our meetings, and I would like to know if the committee is ready to move toward a vote. Yes, okay, great.
Yes.
All right, and Ms. Panette, when you are ready, we are ready for you.
Hello.
Nice to see you again.
See you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett. Representative Babbage. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos. Representative Newell. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Cardone. Representative Cardone is absent. Representative Evangelos.
I'm sorry. I was trying to join the caucus, wasn't able to get on, lost my link to this meeting. I don't even know what we're voting on.
I can catch you up, and I'm sorry, I sent you a link twice and I don't know what happened.
I hit open and it said I was waiting on you to let me in.
Okay, well, let me just catch you up because we're going to lose some people at 5 o'clock. So we're voting on the motion that was made right before we took a little break.
Well, I would like a phone call caucus for 3 minutes with the chair.
We are right in the middle of the vote, and so I think it's important for
Well, I
us.
got excluded from the meeting.
I don't think it's appropriate for us to stop in the middle of our vote. And so just going to ask that we let the clerk continue to call the vote. Ms. Panette, if you could continue, please.
Thank you, Madam Chair. Representative Evangelos.
Well, I'm voting not to pass. I'll explain what I'm doing.
Okay. Representative Evangelos votes no. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 1 in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. And Representative Evangelos, could you tell us what your report is, please?
You ought to pass as amended. Sections 5 through section 7(9)A are eliminated as an emergency.
So when you say 7(9)A, I just want to make sure that we're clear. Are you referring to section 7 of the bill, which includes language in paragraph 9A? Is that
Correct. That section 7 ends with 9A. Yeah.
great? Okay. So sections 5 through section 7 would be excluded from the emergency provision, but would still be within the bill, or would be taken out completely?
Well, I think it should be taken out completely because it's not
Okay.
an emergency. Handle it how you want.
No, it's your report. So thank you. I think that clarified it. Okay, committee members. And so the vote is the motion ought to pass as amended. Motion carries 9-1 with 4 absences. That concludes our work on the Indigent Legal Services Commission. And I just want to thank committee members for all of your incredible hard work on these issues throughout the entire first session of the legislature. And we will now close the work session on 1687 and move on to our next work session. I need to shift some paper around for a moment, everyone. And unfortunately, we're just starting our afternoon work sessions. And I understood, Representative Evangelos, that you might have a meeting or something that you needed to attend to, and that you're requesting that we take up 1273 and 1270 right now. Is that correct?
Yeah, well, to be honest with you, I've been in the hospital and I've had several really bad days and nights. And with the bill being listed last, I don't think I was going to make it.
Okay.
That's the truth. I don't have a meeting. I'm just, I've been going through some struggles the last few days.
Yeah. Thank you. We are very happy to accommodate your request.
And these bills shouldn't take, excuse me.
Yep. So committee members, when Representative Evangelos returns, we'll start with LD 1273. And I know that we have an amendment to this. Peggy, do you have an analysis to present to us on this one?
I guess I do. I know that I was thinking we had already had a work session on this once. But I can certainly pull up the analysis.
Yeah. The amendment's dated May 22.
Right.
Yeah.
And we haven't.
I was thinking that you could give us a kind of a very top line analysis to orient ourselves, and then we'll turn to Representative Evangelos to present the amended language.
Great. So LD 1273 is an act to establish conviction integrity units in Maine. And the bill as presented would have created a conviction integrity unit in each prosecutorial district, as well as the Attorney General's office. And these conviction integrity units would review a conviction in that office if it contained facts that suggest a plausible claim of innocence, evidence of a constitutional violation or prosecutorial misconduct, or facts or circumstances requiring review in the interest or fairness of justice, in the interest of fairness or justice. And it laid out a process for these reviews to take place, and then the conviction integrity unit could recommend relief, including a petition, a recommendation to the Attorney General or District Attorney to actually ask for a post-conviction review and provide for resentencing or a standard of a claim of innocence. And Representative Evangelos worked with the Attorney General's office on this, and they came up with a draft amendment. Chris Taub, the Chief Deputy in the AG's office, worked with Representative Evangelos and put language together. And I think that's what Representative Evangelos would like to talk to you about. And Chris Taub is here if you have questions for him. But if you have questions for me, let me know.
Thank you very much, Peggy. Representative Evangelos, would you like us to bring Chris Taub over now onto the panel?
Just a real brief statement.
Yes.
So the Attorney General did testify in support of the idea. We ended up having a good conversation, and we agreed that the counties should be dropped from the bill because they lack the adequate resources. And he asked me if he would like his department to put an amendment together, and I suggested Mr. Taub because we've worked together on other matters and we do well together. So that's the brief history. So we've slimmed the bill down. The office will be in the Attorney General's office. And Representative Babbage, I did what you told the kids in the history books. When in Rome, do what the Romans do. So when the Attorney General is getting on board with a very important piece of reform and wants to draft the bill, I gave way, and I thought Mr. Taub did an excellent job. So you can follow up with him, and I'll answer questions when you're ready, if there are any.
Thank you very much, Representative Evangelos. We are excited to hear about your amendment. And Chris Taub, welcome to the Judiciary Committee. How are you this afternoon?
Good, thank you, Senator Carney and members of the committee. Thanks for having me.
Yeah, you're welcome. Thank you for being here. Could you please walk us through the amendment?
Sure. So
Excuse me, would you like me to share the screen? Or are you okay?
It might be helpful if you could do that, Peggy.
Great suggestion.
Sorry to interrupt.
So what we did is we did this as an amendment to Title V, the provisions in Title V that address the authorities and powers of the Attorney General's office. And so we did that by creating a new subsection or a new section 200M, which authorizes the Attorney General to create a conviction integrity unit within the Attorney General's office. And one of the goals is to make sure that this unit is going to be independent. And so the bill makes clear that the unit will be separate from our office's criminal division, and that the director of the conviction integrity unit will report directly to the Attorney General. So we felt that that would ensure that there is sufficient independence and autonomy, because ultimately this unit is going to be investigating prosecutions, including prosecutions that our office maintained. Instead of having a separate conviction integrity unit in each DA's office, which we thought was just going to be overly expensive and overly complicated, the mission of the Attorney General's conviction integrity unit will be to review convictions that occurred as a result of either prosecutions in district attorney's offices or through the AG's office. And primarily, although not exclusively, the purpose of the unit is going to be to consider claims where the defendant is claiming that he or she is actually innocent of the charges. And so it sets up some sort of different factors that the unit would take in terms of considering which cases to take. We thought, and I know that Representative Evangelos thought this as well, that it was important that the office not be constrained to just reviewing requests for review that are received from third parties, but also that if the AG's office becomes aware itself that there might be an issue, that the office would have the ability to sort of initiate the review itself. So this basically contemplates that matters can either come to our office through some sort of request for review, or the unit can independently initiate the review. The legislation authorizes the conviction integrity unit to conduct a full investigation. It describes sort of all the different materials and information. that can be reviewed as part of the investigation. It also specifies in section 5 there that if in the course of the review, the unit finds that there's credible evidence of prosecutorial misconduct, then the unit would refer the matter to the main board of overseers of the bar, which is charged with sort of looking at those kinds of issues. After the investigation is completed, the unit prepares a report which goes to the Attorney General. And then if the Attorney General in his or her discretion determines that it's warranted based on the report, then the Attorney General would be authorized to file a petition for post-conviction review pursuant to the existing post-conviction review statute, which we also made an amendment to, which I'll get to in a second. Finally, I think this is finally, well, second to last is section 7, which directs the Attorney General to do an annual report by March 1st of every year, basically describing what the conviction integrity unit's activities were during the preceding year. So how many applications were received, how many convictions were reviewed, different information about each of the reviews. And then section 8 authorizes the Attorney General to adopt rules to implement this. So our thought was that those rules would sort of cover things like how a request for review would be initiated to our office, sort of what the application process would look like, what the review process is going to look like. And then, as I mentioned, because right now there's really no role for the Attorney General in post-conviction review matters under Title 15, we added an additional section 2124A, which would expressly authorize the Attorney General to bring a petition for post-conviction review with the consent of the defendant. And then in that petition, the court would be authorized to grant all sort of the same relief that would be available under sort of a more traditional petition for post-conviction review that's filed by the defendant. So I probably went through that way too fast, but let me stop there and see if members of the committee have questions or if there's anything I can go back over.
Thank you very much, Chris Todd. That was really helpful. And let's, Peggy, you please end the screen sharing. Just it facilitates conversation. Thank you. We have at least one hand up. Representative Moriarty, go ahead with your question.
Great. Thank you, Madam Chair. Mr. Taub, what happens if a convicted defendant has previously filed a petition for post-conviction review and has not prevailed?
That's an excellent question, Representative Moriarty. So in this version, any kind of restrictions that would normally apply to a defendant, for example, a defendant who hasn't exhausted remedies, who's already filed a petition for post-conviction review, maybe on timeliness grounds, even if for any of those reasons the defendant would be prohibited, that wouldn't be a restriction on the Attorney General. So even if there was a previous unsuccessful petition for post-conviction review, that wouldn't preclude the Attorney General from, in his or her discretion, from initiating a second one.
And a related question then, is there a statute of limitations for the Attorney General?
Not in this context. So the way that we drafted this, and I think it specifically says that the failure to file the petition by the deadlines is set forth in 2128B, which I think imposes like a 1-year statute. I could be wrong, but I think it's a 1 year. That's not going to apply to the Attorney General. So timeliness would not be a bar for the Attorney General.
Okay, that's all I have for just now. Thank you.
Representative Poirier, go ahead with your question.
Thank you, Madam Chair. One of the concerns I had with our original work session was that there was no victim input whatsoever in the process. Has there been a change to that?
So if that's a question to me, that was not something that we were really, I guess, sensitive to at the time that we were drafting this. It's certainly something that we could consider. I don't think, our starting point was the draft that Representative Evangelos put forward. And my memory of that is that there was no sort of designated role for victims in that draft. So that was our starting point, but that's certainly something if the committee thinks that, it's worthwhile to have some sort of role for the victim, I'm sure that's something that we could sit down and think about.
Thank you, Representative Poirier, and thank you, Chris Taub. Representative Evangelos?
Thank you, Madam Chair. I just wanted to respond to that. This process is only kicked off when the Attorney General has made a finding of innocence. So in effect, the person that was accused and convicted is the victim. I guess that's all I have to say. So the none of this happens until the Attorney General Conviction Integrity Unit makes a determination of innocence, refers their findings to the Attorney General for a post-conviction review. So this isn't like a pardon where somebody is being pardoned for something they acknowledge they did, and the victims are heard, like at the pardon board hearing. This is a process in which a factual finding of innocence has been established, and that kicks off the process. So in that case, the victim is the convicted person.
Let's see, I don't know whose hand was up next, Representative Moriarty or Senator Kime, but whoever was next, could you please ask your question?
I have no idea. I'll yield to Senator Kime.
I was next, but I just noticed that in mine, the boxes line up according to when people raise their hands, but I don't know if maybe it doesn't do that on everyone's screen. Mr. Taub, welcome and thank you for being here. Representative Evangelos just said that there's an actual finding of innocence before a review would happen, but that kind of ties in with my questions, because that doesn't seem to be what I'm seeing here, that there is suggesting that there's a plausible claim of actual innocence, which isn't a finding of innocence. There's but my question around that is can you help me understand what a plausible claim of actual innocence looks like? Because again, I think what I want to get at here is, how broad is this? How many people are going to be bringing this forward, and what's the workload going to look like, and how many people are we going to be staffing this with?
And could I add on to Senator Kime's question, if you could just clarify whether Representative Evangelos accurately described the role of the finding of actual innocence?
So I think to answer Senator Kime's question first, that's an excellent question. What does it mean to be a plausible claim of actual innocence? And I think, that probably is something that we might flesh out in the rules that we would adopt. But I think that the idea is to have some sort of guardrails so that, you just can't submit a petition saying, I didn't do it. You're going to have some sort of showing of, subsequently developed evidence, or maybe someone else confessed to the crime, or there's some physical evidence that's turned up, or something that really suggests that there is a plausibility to the claim of innocence. And with respect to sort of what would trigger the filing of the petition, our intent is that these petitions would only be filed if there was evidence of actual innocence. So it wouldn't be the case if, for example, someone was convicted of a crime that was maybe more serious than what they should have been convicted of, or something like one of those situations. This would be really reserved for cases where there's someone in prison who the evidence suggests is actually innocent of the crime. And I don't know, Senator Carney, if that answered your question or not.
Yeah, so it seems like the potential actual innocence is what kicks off the process. Is that right?
I think that's right. I think we would be looking at these applications. We would say, okay, this is a plausible claim here. There's actually some good evidence that's been submitted to us that would suggest that maybe this person is actually innocent. And then that would kick off the investigation. And then the purpose of the investigation would be to determine whether or not, in fact, the person is actually innocent.
Thank you.
So to clarify, you're saying that it isn't that they were charged with a higher crime than they did commit, you're saying they committed no crime at all?
I think that that's probably something that we'd have to maybe firm up, but my understanding, and I've looked at a lot of a lot of other conviction integrity units in other states, and I think they really are reserved for situations where someone is innocent of all crimes. It's not a mechanism to, for example, someone was, convicted of murder, but they only should have been convicted of manslaughter. At least, and I don't know if Representative Evangelos has a different view, but our view is that this would be reserved for those situations where the person is innocent of any crime.
So if I could, Madam Chair, one other clarifying question. So the other thing you mentioned, Mr. Taub, is that you gave us such as someone else admitted to being guilty of the crime. I think you said that anyway. And then, but I'm wondering, isn't that covered, or is that covered in another way for someone to have their case reconsidered if there's evidence showing that they are not guilty? Just trying to understand the difference between this and what we may already have in process.
Yeah, so I think you're right, Senator Kine, that there already is a process that someone could bring their own post-conviction review petition. I think there's a timeliness. I think it might be a year from when they became aware that, for example, someone else had confessed to the crime. But I think that the purpose of this unit would be to sort of go out and affirmatively conduct these investigations. So it's sort of a way to do an affirmative investigation and have the Attorney General's office involved, so that there can be sort of a thorough review of cases that seem to warrant that kind of review. But yes, you are correct that this really doesn't do anything additional that the person couldn't do themselves, assuming that they weren't time barred, had exhausted remedies, those kinds of things. Does that answer your question, Senator?
Yes, I think I'll have others, but thank you.
Okay.
Thank you. Representative Moriarty, go ahead.
Madam Chair, Mr. Taub, Senator Kime and I are on just the same track. Now is the time to hash this out, not at some point in the future, or I for one can't vote for it. Do you intend to require that the Attorney General find innocence before this process can proceed? It's not what the bill says as written.
Well, and I think you also have to look back at the post-conviction reviews
No,
as well.
No, we don't, because we've just clarified that the defendant's own post-conviction review, if unsuccessful, wouldn't prevent this process from moving forward. So we don't have to look back. We have to look not forward. We need to look at how this process starts. And is a finding of innocence on the part of the Attorney General a prerequisite to getting started?
Well, I guess all I can say is that our intent, it's going to be ultimately up to the discretion of the Attorney General whether to file these petitions or not.
No, sir. No.
Well,
we're passing a law here.
Well, with all due respect, though, what the law says is the Attorney General may file a petition. So it's going to be ultimately up to the discretion of the Attorney General whether to file this petition or not.
Okay, I'm sorry. I found that to be non-responsive. I have a second question. And I'm looking at the top of page 2. If the unit conducts an investigation, it suggests that there must be credible evidence of prosecutorial misconduct. And that has nothing to do with guilt or innocence. What if there's no indication of prosecutorial misconduct, but there's some evidence which, had the jury believed it, would have resulted in a finding of acquittal?
Well, I guess I'm not sure I follow your question. The evidence of prosecutorial misconduct is really separate from the post-conviction review process. It's just saying that if in the course of the review, the Attorney General finds that there's misconduct, then
Yeah.
it can refer the matter to the board. But
Which
the Board of Overseers.
They deal with post-conviction review?
No, but they deal with misconduct by attorneys.
Okay, we're mixing up, I'm sorry, maybe it's me. I think we're mixing up two things. I'm totally hung up on your understanding of the difference of post-conviction review initiated by the Attorney General's office and evidence of prosecutorial misconduct.
So evidence of prosecutorial misconduct is a factor that would be considered in determining whether or not to review a case. But that by itself would not be grounds for filing a petition for post-conviction review. It would be grounds for referring the matter to the Board of Overseers.
Which doesn't do the defendant much good, does it?
Well, I guess I'm thinking of a situation where there was prosecutorial misconduct, but still there's no evidence of there's no evidence of actual innocence. So I think if we discovered that there was prosecutorial misconduct, but it doesn't change the fact that the person is guilty, I suspect in that situation, the Attorney General's office would not be filing a petition for post-conviction review, because again, the purpose of the post-conviction review process is to exonerate those who are actually innocent.
Okay, thank you.
Representative Hagan, I think you were next.
Thank you very much. I don't know if I'm going to be asking the exact same question that Representative Moriarty just did, but I'm going to go with it anyway. Not necessarily prosecutorial misconduct, but when innocence is found on a technicality where mistakes may have been made or whatnot. Could you talk about that?
Well, so I guess I'm not sure. Are you asking, for example, when evidence gets excluded because the Fourth Amendment was violated or a confession was found to be coerced?
Yeah, at some point, maybe there. I suppose it is misconduct where the prosecutor did something wrong, and now all of a sudden it's found out years later, and they say, okay, we're going to drop everything and you're free to go.
I mean, I guess I'm not following, because this is a process that is only triggered when someone's been convicted. So
right, they've been convicted, and then years later, their guilty thing is vacated because something wrong happened years earlier. Maybe a higher court.
I'm not trying to be difficult. I'm just trying to make sure I understand the question.
No, I'm thinking of court cases where we have people appeal their conviction and whatnot years later, and it is found by a higher court that the conviction was wrongly done because of some small matter or whatnot, and they vacate the conviction. The person goes free.
Okay. So your question is sort of whether that would be grounds in this kind of situation.
Yeah.
So I think the answer, and I think that is related to the questions that Representative Moriarty was asking, which is that unless there's evidence of actual innocence, that's really what this process is being reserved for. Is cases where the person is actually innocent of the crime, not cases where there was evidence that should have been excluded that wasn't, or there was some kind of other sort of procedural problem. Does that answer your question, Representative Hagan?
Yeah, I was thinking about cases that I've heard about in the past, that I've read about and blah 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 in my 58 years, where they were found guilty, but years down the road they appealed it because or something happened where my rights were violated and I was wrongly convicted. I did it, but problems occurred in the process, and the courts have to let it go.
Yeah, and so this wouldn't stop. And so I think typically those are brought either as a petition for post-conviction review or a habeas corpus action. And this process is totally separate from that. So if there is a defendant who believes that they were wrongly convicted because, for example, their confession was coerced or their Fourth Amendment rights were violated, they would still be free to pursue all those kinds of remedies.
Okay.
But the post-conviction review process that we contemplate here is really reserved for cases of actual innocence.
Good, thank you very much.
Representative Evangelos, your hand is up. Did you go ahead? I'd like to recognize you. Go ahead.
A couple of things. Representative Hagan, in the situation you just addressed, of course, the prosecution would always reserve the right to retry the case. The situation you just mentioned is that the court threw something out because of technicality, and if it was a serious crime in those cases, certainly the prosecution would bring a separate case, a new case. They're not precluded because of the release of somebody from bringing the case again. And Representative Moriarty, one of the problems we have was outlined yesterday by Justice Meade when he told us how narrow our post-conviction law is. He was suggestive that it may need some remedy because many people are timed out. If you missed your 1-year limit, you're out of luck. I mean, so this bill essentially is a very small effort at an in-house innocence project, embraced by our Attorney General. It's been embraced by a variety of other states and prosecutorial jurisdictions across the nation, and these kind of reforms are sweeping the nation. So the fact that our Attorney General, normally he's sometimes in more of an adversarial position of the things I bring forward, not always, but in this case, they want to embrace this. And I want to remind everybody, in the Maine Bar's rules, there are some specific stipulations that apply to prosecutors. And one of them is, in the interest of fairness and justice, we get these things right. So all we're doing here is setting up a unit to make sure there's an avenue to allow that. But we are not interfering with other remedies in Title 13, I believe, Title 15, the normal post-conviction review processes. These cases will probably be rare, but they do happen, and they've been happening all over the country. And I mean, it's a real statement when the police, in this case, the Attorney General's office, are taking up this cause. That should tell us something, that there was a serious problem with this case. Why would an Attorney General put themselves out there otherwise? Because it's in the interest of justice that a certain case require their attention to review. And if it doesn't meet the standard, it doesn't meet the standard. So the fact that this isn't coming from the defense counsel side, this is coming from law enforcement itself. Prosecutors across the country are adopting these standards because they want to get it right, and it's in the interest of fairness and justice that they do. So I did want to address those couple of questions, and Mr. Taub has represented my intentions correctly in all regards. Thank you.
Thank you very much, Representative Evangelos. Representative Babbage, I believe you were next.
Madam Chair, good to see you, Mr. Taub, again. First, just a basic question. Currently, who has the authority to grant a post-conviction review? Is it the court or the prosecution?
The court.
Does the AG have any ability to initiate currently this process?
Not that I'm aware of. I mean, I have to put this caveat that I come from the civil side of things here, and we have folks in the office that know a lot more about the criminal piece of this. But my understanding, and that's why we had to write in the provision authorizing the Attorney General to file a post-conviction review petition. But to my knowledge, that there's not currently a process that would authorize the AG to do something like that.
Okay, thank you for that. My last question is regarding the sharing of the findings of the report of the Conviction Integrity Unit. Is there a threshold that has been established that must be met in order for the AG to follow through on an initiative to open a post-conviction review?
No, so I think that would be completely within the discretion of the Attorney General. It might be something that would get fleshed out a little bit in the rules, but I think, you know, and I would suspect that even those rules would really leave a lot of discretion to the Attorney General to decide, you know, which cases are appropriate for review and investigation, and then which of those cases are appropriate for the filing of a post-conviction review petition. So I think built into this is just a lot of discretion on the AG to decide what cases to consider and then what action to take after the investigation's over.
If I may, Madam Chair, the last one would be, is this another obstacle that must be met in order to have a post-conviction review? Or does this provide the Attorney General not only with a vehicle, but with a recommendation that it move forward from a group that has done an investigation?
I'm sorry, Representative Babbage, I'm not sure I understand the question.
Well, I mean, this is an entirely new procedure that must be met prior to a post-conviction review. But it also allows the Attorney General to initiate the process after having received a recommendation to do so by the Conviction Integrity Unit. Is that right?
Correct, right.
Okay. That helps me. Thank you.
I don't think, Representative Babbage, I don't think it's a prerequisite for bringing any kind of a post-conviction review process. Is that your understanding as well, Chris Taub? That it's
well,
not
so I mean, so right. So first of all, the defendant can always bring the post-conviction review petition. That doesn't require any involvement of the post-conviction review. Of the Conviction Integrity Unit. But I think that's right. I mean, I don't think there's anything that would prevent the Attorney General from filing a petition, even without, you know, having gone through the integrity conviction, the conviction integrity process, because again, we are amending the post-conviction review statute to specifically authorize the Attorney General to file the petition. So I think what we contemplate is that the typical process would be to go through this investigation, but I think technically it is true that wouldn't be a prerequisite necessarily.
That clears it up a lot for me. Thank you.
Thank you both. Senator Keim, go ahead.
Thank you, Madam Chair. So I have a few questions. One is Mr. Traub, you mentioned, and this is just to clarify, you mentioned that this unit will be completely separate than the Attorney General's office, and yet it seems to, maybe I misunderstood that. That's why I'm asking. But then it's like it is that the Attorney General is bringing these forward. So it isn't actually separate. Is that right?
Yeah, I think what I said is it's going to be entirely separate from the Attorney General's criminal division. So,
okay.
So we have a division in our office that charges and prosecutes homicides, drug crimes, some other kinds of crimes. And so the thought was it would just be, we want to make sure it's separate from that unit, but no, it would be part of the AG's office, and the head of the unit would report to the Attorney General.
Okay. Yeah, I understand that better now. And a couple more questions. So one is, if the Attorney General makes a finding of innocence, what then?
Yeah, so if the Attorney General finds that there's clear and convincing evidence of actual innocence, then the Attorney General would have the option of filing a petition for post-conviction review, but it would ultimately be up for the court to make that determination. The Attorney General doesn't have the power to vacate a conviction. Only the court can do that. So what the Attorney General can do is at least initiate the process, file the petition, ask the court for relief, and then it's up to the court whether to grant the relief or not.
So if the accused person has already run out of their own ability to request a post-conviction review, the Attorney General doesn't have those same limitations, time limitations, whatever, so that they can just go to the court and ask for this review.
That's correct. Now,
okay.
Although, I mean, I'll say that if all of the issues that are being brought up are the same issues that were already brought in a post-conviction review process by the defendant himself or herself, that's probably going to be a factor that would probably weigh against the Attorney General filing a petition if those issues have already been addressed by the court. But the answer is that yes, that wouldn't preclude the Attorney General necessarily.
Okay. And then, we're all also considering changes to the post-conviction review process. Do you have any idea how these overlap?
Well, are you referring to the sentencing portion of the process, or I guess I'm not sure what you mean by you're also considering the post-conviction review process changes.
So the bill that I thought we had another bill of Evangel's bill to look at the post-conviction review process. And so I was wondering about the overlap between this and that, and if you were able to speak to that. I myself just don't quite understand the differences between what this is going to affect and then, what we have in process and then what we're also considering to change in the process. It's a lot to answer.
Yeah. So I think, are you referring to 1270? That's no, Representative Evangelos, is there another bill that you have that addresses post-conviction review? Because I guess I'm just not familiar with that one.
Yes, earlier in the year, we passed in a divided report to a bill we worked on for 3 years to amend the post-conviction review process to strip that 1-year time limitation, so that Walter McKee wrote the amendment saying that at any time during the period of incarceration, if new and convincing evidence came forward, you could file a post-conviction. Also, the due diligence standard was being amended so that the prosecution couldn't do what they at times do now, that, well, your first lawyer should have seen that. It's no longer going to be held as an excuse. But I don't see it as an overlap with this. This particular bill deals with information or evidence that has come to the attention of the Attorney General outside of the post-conviction review process. And the Conviction Integrity Unit would investigate it and make a recommendation based on the evidence that the matter needs further attention. And then if the Attorney General goes along with those recommendations, he or she then goes to court and makes that case in a post-conviction review before the Superior Court. I think I've got that right, Chris. And
yeah, so I think that's right, Senator Khan. There really is no overlap. It sounds like there was a bill that sort of removed or made it easier for defendants to file post-conviction review petitions by getting rid of the 1-year statute and maybe some other things. But that doesn't have any impact on what this bill would do, because this bill essentially says whatever obstacles the individual defendant might have, those aren't going to apply to the Attorney General. Timeliness won't apply. Waiver is not going to apply. Exhaustion of remedies is not going to apply. So I don't think that there's any overlap between the two things.
Okay, thank you. And then the only other thing I asked earlier, but didn't get an answer for, is what it looks like for staffing.
So we've thought a lot about that in our office, and of course it's hard because we've never had a conviction integrity before. We don't know, how many requests we're going to get. But our thought is, for initial staffing, what we think we would need would be an assistant attorney general, an investigator, and some sort of either paralegal or secretary support. So probably three positions to start. And then, if it turns out that there's more work than we anticipated, we may have to come back and seek further resources. But at least to start, we think an attorney, an investigator, and a support staff person.
Chris, Tom, excuse me, I'm losing my voice. I have a question for you. Was it fair to say that this bill proposes a conviction integrity unit that, because it is within the scope of the Attorney General's office, that it's really it's really protecting the state interests in not having innocent people in jail, and that's kind of a slightly different perspective and interest than that of people who are incarcerated?
Yeah, I think that's exactly right, Senator Carney. I think there's a public policy and important public interest in making sure, I mean, the name says it, that to make sure that there's integrity in the convictions, and, you know, to make sure that convictions are, you know, were done properly. And, you know, I think part of the idea also is if the AG's office discovers that there are problems that can be corrected going in the future, that can be addressed. So I think you're absolutely right. This is like a different perspective. This really isn't about the individual person. It's about the process that was used. It's about the criminal justice system, and it's about assuring people that there really is integrity in the process, and the process is working as it's supposed to.
Thank you very much. Committee members, I sense that we have perhaps learned as much as we can about this legislative proposal at this point. Would committee members like to continue with questions and discussion, or are committee members ready for a motion and a vote? Representative Evangelos?
Representative Babbage had his hands up. You all set, Chris? Yeah, I'm ready to make a motion, and I'll take the chips how they come. I'm going to move off to pass as amended.
Okay.
And I'm adopting the amendment submitted by the Attorney General's office. And I would like to speak briefly to that when it's time.
Let's ask for a second before we go on to have you speak to the motion. Is there a second on the motion? Seconded by Representative Babbage. Okay, you may speak, Representative Evangelos. Go ahead.
Thank you, Madam Chair. I want to be brief. You know, criminal justice reforms are sweeping the nation, and this is an integral part of those reforms. You know, it's no accident that states and major prosecutorial districts are adopting this, but it speaks strongly that the chief law enforcement officer of our state wants to join that movement. This isn't, you know, the MACDL or the defense people coming forward asking for reforms. This is the prosecutorial side saying, you know, we got to get these things right. This is a very important bill and a very important development by Attorney General Fry's willingness to see what's going on in the other states and join this movement. And I consider it a really great opportunity. It's a no harm bill. It hurts nobody. And it brings fairness and justice as already required in prosecutorial oaths that are taken. It just sets up a process to make it happen. And I will tell you, if you research these units across the country, they are freeing innocent people. And when it comes from the prosecution side, it speaks volumes. So I hope you will consider voting to support my motion. Thank you.
Thank you, Representative Evangelos. Committee members, would anybody else like to be heard on the motion?
I'm sorry.
Go ahead, Representative Hagan.
Thank you very much, Madam Chair. When all is said and done before the vote, I would like to banter back and forth with my colleagues and do a corner caucus. It won't be a long one.
Thank you. Representative Moriarty? We're not able to hear you, Representative.
Yeah, in light of Representative Hagan's request, I'll defer or hold off on my comment.
Okay. Any other comments before we break for a brief corner caucus? I am not seeing any. So Representative Hagan, if we return at 5:45, does that give you enough time?
I think it should.
Okay, great. Thank you.
If not, I'll text you, but I think we should be fine.
Okay, so we'll resume at 5:45, everyone. And I also did want to let people know that I sense that the committee is running out of steam. And so once we take this vote, we'll talk about where we're headed this evening. Thank you. Hello, committee members. It's 5:45, and if you're at your desks, could you please activate your camera?
And did we just have a caucus?
No.
Oh, I couldn't get in, so I wasn't sure what was going on. Okay.
No, I just needed a moment to catch my breath.
Understandably.
Okay, it looks like many of us have returned, and I do want to thank Chris Taub for his participation this afternoon. And as we're moving to a vote, I'm going to send you back to the attendee part of the meeting. Thank you.
Thanks for having me.
Committee members, are we ready for a vote on 1273? The pending motion is an ought to pass as amended by Representative Evangelos, seconded by Representative Babbage. Go ahead, Senator Keim.
Yes, and we're ready for a vote, but I am just going to explain that I will be voting against the pending motion. I think that this is, far better than where it began, but I have questions still that remain unanswered. And I think given the change here is significant, and I would like to have had time to hear from other people and other stakeholders around how they feel like this is going to play out and in real time. And I also am concerned that within Mr. Taub's presentation is a lot of we're going to figure that out in routine technical rules, and yet they seemed important policy considerations for the committee. So I am uncomfortable with the amount that's left ambiguous and up to the Attorney General to decide without our input at a later date. And those will be my reasons for voting against the pending motion.
Thank you, Senator Keim. Representative Moriarty, go ahead.
Thank you, Madam Chair. I'm going to vote no for those same reasons just expressed by Senator Keim. And I'm particularly concerned about the apparent disconnect as to whether or not there will be a finding of innocence. If that's to be part of this new process, that should be written in the statute and not left to the rulemaking process. The statute as written does not require a finding of innocence, and I don't know how such a finding would be made because there's no procedure by which, there's no procedure set forth in the statute for the making of such a finding by the Attorney General. There is too much inconsistency here, and I just am not willing to turn it over to rulemaking.
Thank you, Representative. And Representative Evangelos, go ahead.
Thank you, Madam Chair. 2 points. First of all, Senator Keim, we didn't expand any language in this bill that was not subject to the public hearing. We just narrowed it up. We dropped the counties. It was the real only substantial change. The rest of the bill was the same as that we heard. So the only substantial change was to have one unit instead of one in every county and the AG's office. And secondly, Representative Moriarty, the court makes the finding, the final finding. The Attorney General reviews evidence that came forward. He takes it to the court, and the court makes the decision. So there is a process to address your concern. So the Attorney General enters a post-conviction matter with the Superior Court, and the court will decide on the matter. So that's the way the process is set out.
Thank you, Representative Evangelos. And Representative Moriarty, I know that you would like to respond. I'm concerned that if the answer isn't going to change your vote, then I would just encourage you to let us move on to a vote. Representative Babbage, go ahead.
Thank you, Madam Chair. I just want to explain, I seconded the motion. I will be voting yes. And, you know, I think we've identified that currently there's a very big time limitation, and the Attorney General's ability to initiate the situation is not as it is in this bill. But this bill is extremely limiting as to, I mean, the bar is very, very high. So much so that the effectiveness of the conviction integrity unit might be at risk. I think there's very little risk of passing this, in that if there is clear and convincing evidence of actual innocence, then they should act on it. But that bar is exceedingly high, so I really see no reason why this should be opposed in its present form. So I am supporting it. Thank you so much.
Thank you. Committee members, any other discussion? Go ahead, Senator Kime.
Sorry, I know it doesn't change my vote, but I am confused by what Representative Babbage just said, and recognizing that, you know, we're being listened to by the public. I understand the clear and convincing evidence is stated in the purpose of the Conviction Integrity Unit, but I didn't understand that to be necessary in order to move forward with a review. And I think that's how you stated it, Representative Babbage, and I am a little bit confused by that. I think that
You are correct, Senator, that it's only stated in the purpose, but given that that's the purpose of the Conviction Integrity Unit, it is then the Attorney General is then given the discretion to act, and that's permissive in this way. This provides that avenue to take place should the Conviction Integrity Unit meet these three criteria in the review part there, which I think is a very high bar, honestly, in order for them to take action. So that's why I'm you know, sympathetic with the way the bill is written. Thank you.
Yeah, and I would just like to say that it's my understanding that the Conviction Integrity Unit is empowered to move forward on its own initiative or at the request of someone else if there is a request that includes facts suggesting a plausible claim of innocence, but that the determination about clear and convincing evidence of actual innocence is actually the end result of the process and not a threshold for the process going forward. Committee members, I need to take a very short break for just one moment because there are only 1, 2, 3, 4.
I'm sorry.
It's actually, there are 7 committee members present, and so we are able to move on to a vote. So at this point, I think that we are ready for the vote. Representative Moriarty, I know that with my encouragement, you refrained from commenting. Are you okay moving forward with the vote?
I am.
Thank you. I appreciate that very much. Okay, committee members, I think we are ready for the vote.
Madam Chair, Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
No.
Senator Kime votes no. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckitt. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Cardone. Representative Cardone is absent. Representative Galgay-Reckitt. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 5 members voting in the affirmative, 4 members voting in the negative, and 5 members are absent.
Thank you very much, Ms. Panett. The ought to pass as amended motion carries. For those who were voting no, is your report ought not to pass? And so we'll close the work session on 1273. And I would ask committee members, I know that it has been a very long day. I would very much like to complete our work session on LD 1270 and then wrap up for this evening. Are committee members agreeable to doing that?
Madam Chair,
Yes.
on the previous vote, could you record my minority position
Yes.
as a motion to table?
On the vote that we just completed?
That's right.
Okay. Thank you very much for that clarification. Sorry, I didn't catch that you had a different report. So committee members, can we complete one more bill? Denton, that we have to add on to tomorrow's workload? You will be very efficient. Okay, let's go ahead. We'll open up the work session on LD 1270. And Peggy, have we done a work session on this one yet?
I'm sorry, we at least did a preliminary work session where Representative Evangelos said that he was working on the conviction integrity unit with the Attorney General's office, and so you just tabled it. I don't think you really talked about it.
Okay. And Representative Evangelos, just a quick question. Did you have any amendment or anything in addition to the bill text that was printed that you would like us to consider?
Yes, very briefly, I just, I wanted to also on this bill, take the county district attorneys out of the bill and just have one unit housed in the Attorney General's office. No other changes.
Okay, great. Thank you very much. And so this would come back to us for a language review based on that. And Peggy, could you please give us a sort of an overview analysis to initiate our conversation on this bill?
Right, so this bill is creates resentencing units, and you just heard that Representative Evangelos would target it just in the Attorney General's office, so that would oversee the whole state and not individual districts as the bill was drafted. But it would, the resentencing unit would look for reduction or termination for different sentences. And it's not looking at convictions, it's looking at how long somebody is sentenced. And if you remember, there was some concern raised about disparate sentencing based on who knows what. And this would clarify, this would give the Attorney General's office, the resentencing unit, an opportunity to look at sentences and ensure that they were fair, no longer than necessary to ensure public safety. There's very specific criteria in subsection 2, including a person who committed an offense under section 202, which I believe is manslaughter, or felony murder, in which the person did not commit the killing. That's felony murder, or have the intent to kill. A sentence of at least 5 years for a person who is eligible for release within the next 12 months. A sentence of a person who is suffering from a terminal or debilitating illness. A sentence in which an illegality or irregularity may exist or have been committed. and a sentence that the resentencing unit determines should be reviewed in the interest of fairness or justice. So that's maybe the more inconsistent one that I had mentioned. And the first one is actually also focused on people who are either over 50 years of age or who were sentenced for a crime committed as a minor, and to determine if the sentence is longer than necessary. If the conviction integrity, no, I'm sorry, if the resentencing unit identifies a sentence that needs to be looked at, then they would make a recommendation to the Attorney General. I think this is still true. The Attorney General would still have the discretion to make the decision about asking the court to look at it and resentence.
Thank you. Peggy, I have a question for you, and if you can remind me, did the Attorney General provide testimony on this? I was just flipping back to my electronic records because I just have forgotten that.
I don't have anything from the Attorney General on that one.
Okay. Thank you. I just wanted to make sure I wasn't missing something. All right. And Representative Evangelos, would you like to be heard on this bill?
Sure. Very briefly. I know it's been a long day, but part of the process of this bill does involve filing a petition back to the court. And so you do have that step. But I do want to remind the committee of a couple things. First of all, I rechecked today and determined that Maryland, San Francisco, Boston, Philadelphia, Brooklyn, LA County, Washington State, Washington, DC, and San Diego County, that was with 2 minutes of research, have already adopted standards like this. This is another one of those reform efforts that is sweeping the nation. And lastly, I thought I made a compelling case in my testimony regarding disparate sentencing for similar cases. And you know, I'm going to take us back to Sarah Churchill's confirmation hearing when she was presented with that evidence. She said that unfortunately, the higher sentence was the result of human error. All this bill does is try to remedy those situations so that somebody isn't serving 30 years for something that somebody else is serving 6 years for. Identical circumstances. So we need to fix the human errors in the system. And again, in the interest of fairness and justice, you know, most of the jurisdictions around the country that have picked up on these resentencing units are housed in the prosecutorial offices, similar to the previous bill. And, you know, that speaks volumes to me, because it's basically the police coming out. I mean, the Attorney General's office is the chief law enforcement officer of the state of Maine. It's the police coming out and saying, we want to get this right. And so all this bill does is give them an opportunity to do so if a case comes to them that fits the stipulations under page 1 of the bill.
Thank you very much, Representative Evangelos. Would any other committee member like to be heard on LD 1270? Go ahead, Representative Moriarty. And we're not able to hear you.
My phone just rang. That's why I muted myself. Representative Evangelos, my notes from our very, very brief work session of May 11 say that you met with the Attorney General and he wanted more time. So I'm wondering if that meeting took place, and do we in fact have any input from the AG on your oral amendment to the bill?
No, the Attorney General needed time in discussions with them. They told me they were going to take up for 1273, but we're not doing anything on 1270. That I was on my own on that one. And so I appear here before you on my own. But the case I made in the public hearing stands. We have one of the most respected attorneys and now a district court judge that admitted we have human error in the system. Just trying to fix that. And it's not in the interest of the defense counsels, the police, or the prosecutions to have injustices in our penal system or criminal justice system. So we're just trying to put some fixes in. It's not unique anymore. The stuff looked unique 2 years ago, not any longer. I just, rattled off 10 jurisdictions. But they told me I was on my own on this one.
Thank you.
Any other questions, committee members? Any discussion on the motion? I mean, excuse me, on the bill? Go ahead, Representative Poirier.
Thank you, Madam Chair. I'm just trying to remember back to the first round of work sessions that we had, and I have on my notes that there weren't really any limitations around the timeframes and such. Is that still correct, or has that changed?
Is that a question for the bill sponsor?
Or maybe Peggy.
Oh, okay, I'm sorry.
Right. I don't. Right. I don't think that there's, kind of like in the previous bill, there's not a limitation once this resentencing unit acts. It's not limited like anybody else might be in asking for a sentence to be reviewed.
Okay. And is there a limit? Sorry, can I follow up? Okay.
Yes, please.
Is there a limit as far as how many times they can ask for it?
Well, so the person who's asking for the resentencing under this bill would be the Attorney General.
Okay.
So I know there's not a limit, but I'm not sure that the Attorney General would ask for it more than once. And it does say the filing deadline is till the end of the sentence. So that's the time limit, but right.
Thanks.
My apologies, committee members. And especially you, Representative Poirier, I was pulled away by a robocall that I needed to deal with. So Representative McCrate, go ahead.
Thank you. Just a technical question. I'm trying to look up the bill to look at the testimony, and I don't see it in the list.
It's not in the judiciary list. It was heard on May 5th. If you want to go through the calendar, I'm sorry that is not showing up in the not sure what's going on there. I do actually, it is there. I can send you the link if you want.
Okay. I don't see it by number. It's there.
It is.
I think I just ran something off.
I'm bad with the alphabet, but I'm pretty good with numbers. I don't see it.
I just sent it to Senator Kine. Oh,
okay.
Do you want me to email it to you? I was putting it in the chat.
Oh, okay. I have to look at the other computer. Okay. Thank you.
Thank you, Representative McCrate. I'll just add to the our discussion about this bill, and we don't have a motion pending, but I do have concerns about the fact that we haven't heard from the Attorney General's office, and so we don't really know from an implementation perspective what the hurdles would be, and for example, whether changes would be required even for Section 2, the review section, because I'm not sure that these categories of information are even readily identifiable in the database or from some other source. And without some kind of assurance that this statute could be implemented, I am reluctant to vote for the bill. But I do appreciate the underlying policy concerns and would like to keep working on them. Any other discussion, committee members? Representative Evangelos, is your hand up anew or residual?
Well, if no one else is ready to discuss anything, I was going to make a motion.
Go ahead.
I'm going to move out to pass as amended. The amendment is to take out the county district attorney's offices. And similar to the previous bill, the unit would be housed in the Attorney General's office.
Thank you. So we have a motion by the bill sponsor. Is there a second on the motion? And I'm not seeing a second on the motion. Is there another motion that a committee member would like to make? Go ahead, Representative Moriarty.
Madam Chair, with some reluctance, I move ought not to pass.
Is there a second on the ought not to pass motion? Seconded by Representative Poirier. Any discussion? Go ahead, Representative Evangelos.
I put a motion on the floor. Another motion was recognized before people were given an opportunity to second my motion.
We could go back. I thought I gave quite an amount of time, but you know, we could withdraw the motion and.
I'll withdraw my motion.
Okay.
To make more time available to my colleague.
Thank you very much, Representative Moriarty. Okay, so there is a motion without a second, and that is Representative Evangelos's ought to pass as amended. Committee members, is there a second on the motion? Okay, Representative Harnett is seconding the motion. Thank you very much. I didn't see your hand, Representative Harnett.
I hadn't put it up before. I just got back. I'm sorry.
Yeah, thank you. I know you've been doing a lot of different things. Okay. All right, committee members, is there any discussion on the ought to pass as amended motion? Go ahead, Representative Babbage.
Well, I just want to explain where I am with this, and you know, I very much appreciate the direction and effort, but there are a few definitions, and I'm not sure about the separation of powers argument, but I still have unanswered questions, and I don't feel that I have had enough of an examination of this to go forward. And so that's why I will be voting no on this motion. Thank you.
Thank you, Representative Babbage. Committee members, anything else before we move on to a vote? Not seeing any hands raised. Ms. Panett, thank you so much for joining us. I think we're ready on the ought to pass as amended vote.
Thank you, Madam Chair. Senator, Representative Babbage, that's a residual hand. Thank you. Senator Carney.
No.
Senator Carney votes no. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
No.
Representative Babbage votes no. Representative McCreight.
Yes.
Representative McCreight votes yes. Representative Cardone. Representative Galgay-Reckett. Representative Moriarty.
No.
Representative Moriarty votes no. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Cardone. Representative Cardone is absent. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 4 members voting in the affirmative, 6 members voting in the negative, and 4 members are absent.
Thank you very much, Ms. Panett. And for those who voted against the motion, Could you please let me know what your report is?
Mine is not to pass.
Same for me.
Ought not.
I'm prepared to do other than ought not to pass.
Okay, thank you. And with that, we conclude the work session on LD 1270. And
I'm sorry, I need just a little clarification on Representative Babbage is not voting not to pass.
No,
And
I was unfair. Yeah, no. I'm sorry.
may I ask what you're voting?
Ought not to pass.
Oh, you are voting not to pass.
I am.
Oh,
I was
apologize.
unprepared to do other than ought not to pass.
and I also am an ought not to pass.
Okay, so I'll be 6. Thank you. I apologize. Misunderstood.
And with that, we'll close the work session on 1270. And I feel that the committee is done with our work for the day. I also think there are storms approaching all of us, and we may at some point be without electricity. Thank you for your work today, everyone. As far as going forward tomorrow morning, Peggy, are we permitted to indicate that the matters we did not reach today will be taken up first thing tomorrow morning so that we address these right when we start at 9 o'clock tomorrow? Or do we need to put out a notice to that effect?
I don't know. Maybe the committee clerk is the better person to answer that, since she'd be the one we could always send an email to the interested parties that says we'll be handling these bills first thing tomorrow. Although actually you also set aside first thing tomorrow at 9 to take public comments on Representative Morales's bill. But we could say we could add them to tomorrow's work session.
Okay, let's add them to tomorrow's work session, and we will in the morning post in the chat first thing what the order will be, and then people will be able to anticipate when to check back in with the committee.
Great.
Okay, thank you. Representative Moriarty?
Well, Madam Chair, I'm clearly not trying to win a popularity contest, but given how much is left over from today, and given how much is on tomorrow's list, I'm suggesting we start at 8 in the morning. I did not take Peggy's and Susan's interests into account. I suggested that.
And also, I think that the members of the public anticipate that our committee meetings will start at 9. And so we'll stick with the 9 o'clock. But I would just say, I think that we can, if we all do our homework tonight, and I think we can move through a little more quickly tomorrow than we were able to do today. Not because people didn't do their homework today, but I think that we know that tomorrow and Friday are our last 2 days. And so if we can really ready to vote on bills tomorrow, I think that we'll address some of those concerns. Representative Harnett?
Thank you, Madam Chair. Will Democrats be caucusing before tomorrow's?
Yes, we will caucus at 8.
I'm sorry,
At 8, our usual 8 o'clock caucus.
Thank you.
Lisa's going to hand up.
No? Okay.
Oh, fuck.
Committee members, thank you very much for all of your hard work today. We appreciate your being here. Subi, did you have anything else for us?
Representative Evangelos has his hand up.
Go ahead, Representative Evangelos.
Madam Chair, I just want to thank you for taking those 2 bills up for me today. It made my life easier. Appreciate it.
Well, we were very happy to take them up. Thank you so much, Representative Evangelos. All right, everybody.
Just to make this maybe a little bit easier for tomorrow, I did send out it's a working draft remote participation that Senator Carney and Senator Keim have been putting ideas together. So that is out there, and I don't know if that helps you tomorrow, but it gives you a little more time to look at it before you get to those bills, which are now on tomorrow morning's schedule.
Yeah, thank you for mentioning that. I had forgotten, but yeah, that'll help to have the evening to look at that. All right, everyone. See you tomorrow morning. Thank you, Soupy and Peggy. Thank you so much.
Thank you.
I appreciate my hardworking colleagues.
Good night, all.
Night.
Yes. Good night. Thanks a lot.
Hi. Forget we're still.